All right, my friends. I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet and all across the Arizona before we get into it today, because we've got another full day ahead and we want to make sure the tubes are working. And it looks like they are. So let's get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney broadcasting from the Valley of the Sun, deep in downtown Phoenix, Arizona. And today, my friends, we are talking about Kari Lake Trial Day 2. We spent yesterday, about 8 hours of it, talking about Day 1, and we're going to do a quick refreshment on who is here. We've got 5 witnesses that were there yesterday. And remember, we started the day off with Jacqueline Onikit. She came out and talked about signature verification. She was a level 1 signature verifier, and she explained the process and the frustrations that she had when she would verify a signature, send it up to level 2, and then level 2 would send it right on back down to level 1 and say, do it again. We're saying to ourselves, why would they do that? I mean, if they already verified that it doesn't match, why would you send it back and say, do it again? And so she was frustrated. She got emotional. She got tearful up on the stand. She was concerned that, voting is not being done appropriately here. And she worked her butt off to not only work in the election, but also to come in and testify. We also saw this individual come in and talk to us, Chris Hansel. He acquired a bunch of data from Maricopa County, and we ran into a little bit of difficulty with him because he was kind of an expert. I mean, he is an expert, I would say, not legally qualified in this case, but I mean, if you sat down with him, you'd be like, what did you do? You took software and you connected this and all the rows and the things and the variables inserted into the other layers. What? He would be an expert. And although he filed a Freedom of Information Act request and he got a bunch of data from Arizona, he really couldn't get into the conclusions of what that data produced because he wasn't disclosed as an expert. He wasn't qualified as an expert. So he could just talk about some of the facts that he did, the things that he did, but the judge really precluded them from getting into a bunch of the technical conclusions, which is really what we wanted to get out of him. We also had a little bit of dicey behavior, or dicey threats, not behavior, threats against Shelby Bush, who is the co-founder of We the People in Arizona. And we had some very interesting testimony here. We were kind of on pins and needles here for a little bit because she was explaining what We the People do. And part of her testimony was that they were essentially, I would say, use the word scraping the video feeds off of the public feeds that Maricopa County provides. And if you were here on this channel, we went through a lot of those public feeds together and we said, hey, what's going on over here? Remember, we were looking at people. What is he doing? Where's that envelope going? And all that kind of fun stuff. Well, they were scraping that data. It was live streamed. And so it just, evaporated as soon as it was gone, but they captured it and they went back and did some analysis on it. And so the government, as is typical with the government, they try to use every unfair advantage they can against people who try to hold them accountable. They don't like it at all. If you're somebody like Shelby Bush, or you're somebody like Chris Hansel, or you're somebody like Jacqueline Onikit, who comes out and challenges them and you say you did bad things, well, they'll come out and they'll literally threaten you with jail time. So they had Shelby Bush on the stand and they said, oh, you scraped a bunch of our data. Do you have images also of signatures? And she's like, well, maybe. Do you have images of names? And she's like, and everybody starts to panic a little bit. We get an objection from Kari Lake's team because we can see where this is going. He's like, oh, so you're kidding me. You've got names and registration and you can see this and you can see that. Sounds like that might be a criminal privacy violation here in the state of Arizona. And they weren't real sure what potential criminal statute it would have violated. I wasn't sure either. So I was actually, as that segment was going on yesterday, I was scouring through Arizona law, Title 16, the elections law, and trying to identify where just being in receipt of publicly available information makes you a criminal. I didn't see any justification for that at all. And as we were going through this, I was, there's other sections of the code about that govern other things about information and privacy. And so, on the fly, it's hard to dig in and do some research. But we weren't sure what he was threatening, and he wasn't sure what he was threatening, and the judge wasn't sure what he was threatening, but the judge just cut it off, stopped, suggested maybe we pause on this, and said, don't ask any more questions about that and move on. But the point is, it is chilling these efforts. It is a direct, I would say it's an indirect, direct threat. I mean, he's in court. He hasn't gotten there yet. He hasn't crossed the threshold of connecting the dots that this is going to lead to some sort of prosecution, but he got damn close to it, and we all knew where he was going. So as far as I'm concerned, it was a threat for criminal charges in queue coming down for Shelby Bush, and the judge saved that. So the point being, she came out, she laid a bunch of foundation for the video that we spent a lot of time talking about yesterday, which showed who we now know is Steve the Pecker, the person going pa, 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 on the screen in order to validate ballots and to verify the signatures. And this was, let me grab this one. I thought I had this one queued up for us, but I'll grab it very quickly. This was one of the issues. Where are my bookmarks? All right, anyways, I'll find it later. But we saw it yesterday, a ton of it. They were just scrolling through the images, and it was just flashing through. What Steve the Pecker was just clicking away, and it was interesting to see. We also had Andy Myers come in. He testified via Zoom, and he explained his role in verifying signatures and how frustrated he was with a lot of, well, he also explained some of the numbers. He was shocked that they were able to get through so many ballots so quickly when the regular pace that they had been working hard to achieve what would have been exceeded exponentially. In other words, there's not enough time in the day to scan that many ballots over the course of this many hours. He just knows that because he's been working on this for a long time, and his testimony helped to add some meat to the bones on what they are trying to communicate there. We also finished the day with Ray Valenzuela. Ray Valenzuela was somebody who testified in Kari Lake's first trial, and he's in an interesting position because here he was called by Kari Lake's team. They actually brought him in to testify, and we saw Kari Lake's lawyer, Mr. Blem, doing the direct examination of him, and it was a direct exam. You know, there were a couple opportunities there that I was hoping that he would take, and he came back to it at the end, and we started to crack it a little bit, but then we wrapped up the day. And so I believe today we're starting back up with him for a rehabilitation. And then at another stage, it's very likely that the government is going to call him as well. I think he might be their only witness to talk about the fact that layers 1, 2, and 3, levels 1, 2, and 3 signature verifications were completed. And that may also open up the opportunity for cross-examination by Kari Lake's lawyers against him. So we might, in other words, have many more opportunities to get into the testimony of Ray Valenzuela. But the big crux of this thing was yesterday, during opening arguments, the government said that the person who was clicking away on the screen was removed from the line. And Ray Valenzuela, when we were watching that video, seemed to make it appear as though that person who was later removed from the line was doing an amazing job. So we had an inconsistency there. If he was doing an amazing job on that screen and all of that was just perfectly appropriate, why was he removed? And what was the consequence of that removal? What did Maricopa County do to remedy his past verifications? Did they corroborate his work? Were there other people that were in similar positions who were also removed? We'd love to know that. We would also like to see how they identified that person and what the mechanisms were to identify him, so we could see if they worked on identifying other people, and the list goes on and on. You have a massive inconsistency. The point is, maybe that one Steve the Pecker doesn't, in and of itself, he doesn't touch enough ballots to change the outcome of the election, but he opens the Pandora's box to show that there is a massive, extensive failure, so broad, so pernicious, that extends its tentacles into the entire signature verification process, such that it invalidates the signature verification process. Remember, Kari Lake has to meet a threshold. The judge is saying that you've got to prove essentially that there was no signature verification at all. Didn't happen. Well, we know there were mechanical people there. There were hundreds of people working there. Over 100 were doing signature verification specifically. So you can't say that the mechanical aspect of signature verification didn't happen. It clearly did. They're on video doing something. You have to say that there is a problem so catastrophic that it is as though signature verification had never happened. And so that's how Kari Lake's argument is now morphing into that, to meet that standard, to say, yeah, judge, there's people clicking on the keyboard, but it's not good enough. It's essentially invalidated the whole thing. And so that's where we are going to pick up today. You can see the court is still warming up their tubes, and we do have a few minutes before things are back in session. And so let's take a look at who else we might be expecting today, because this is the witness list from Kari Lake's disclosure. And so let's go through this and see who we've got and who we do not have. So we are expecting still to see, these are Kari Lake's witnesses, and it doesn't mean she's calling all of them, but we are, I would imagine, we see Erich Speckin today. He's the expert witness. We've got a full day ahead, and so he was already disclosed in the expert witness disclosure statement. I expect to see him. Ray Valenzuela, I do believe we're starting with him. I could be mistaken on that, but I think we've got a redirect with him this morning because Mr. Blem was not quite finished yet. We also remember Scott Jarrett. Scott Jarrett was somebody who testified at the previous trial for 2 days, in fact. The first day of his testimony, he said, I don't know anything about 19 inchers on 20 inchers. Don't have a lot of knowledge of that. And then the next day, he suddenly knew a little bit more about the 19 inchers on the 20-inch paper. So very curious. I'd like to, he was the person last time at the first trial. We were thinking you got to just go hard on him. He's kind of the keystone in the bridge, right? He holds the whole arc together. And so you want to take, if you're going after witnesses to shatter their credibility or to expose their malfeasance, you pick certain people to do it. Scott Jarrett at the last trial was the person I thought you could say was the most responsible for a lot of the consequences. Ray Valenzuela is in this trial somebody who, his testimony is very persuasive. He's very competent. He's been doing this for a very long time. And so yesterday the commentary was that in terms of credibility, he had opportunities to have his questioned pretty aggressively, and we'll see if they pick back up on that. We had onesie twosie Bill Gates. We read about what he was doing yesterday. Still have not heard from him. Chris Hansel, we heard from him yesterday, so we got him off the list. Shelby Bush testified, so she's off the list. We had Andy Myers testify. He's off the list. I think Yvonne is not testifying, if I remember correctly. I think the Kari Lake's team communicated that. And then we also see Jacqueline Oneke. She testified. So we're getting close to the end of the list. Today should be a good day with Erich Speckin, Bill Gates, and Scott Jarrett all testifying. So interesting stuff. Now, they're clicking around over in court. Looks like we're getting the queue up. And the judge is already seated.
Very good. All right. All right, this is CV 2020-209-5403. This is Kari Lake versus Katie Hobbs et al. And I will take appearances at the beginning of the day. Plaintiffs, please.
Brian Blem on behalf of plaintiff Kari Lake.
Morning.
Morning, Your Honor. Kurt Olson on behalf of plaintiff Kari Lake.
Good morning, Your Honor. Robert Gouveia on behalf of Watching the Watchers.
Good morning, Your Honor. Elena Rodriguez Armenta for Governor Katie Hobbs.
Alexis Danneman for Governor Katie Hobbs.
Morning, Your Honor. Craig Morgan for Sherman and Howard on behalf of the Secretary of State. With me are my colleagues Jake Rapp and Shane Stewart.
Morning, Your Honor. Thomas Liddy on behalf of the county defendants from the Maricopa County Attorney's Office.
Morning, Your Honor. Emily Kreger from the Burgess Law Group on behalf of the Maricopa County defendants.
With me this morning, Your Honor, is Joe LaRue from Maricopa County Attorney's Office, Jack O'Connor, and Rosa Aguilar. All from MCA.
Thank you very much. And good morning to all of you. All right, there was one matter that I wanted to address with you at sidebar, but the easier way to do the sidebar is I think what we did yesterday is just have the clerk have the headphones on and we'll pause the live stream proceeding for just a second. I'll excuse everybody from the courtroom except for the attorneys and the parties, and then I'll address that one issue and we'll move forward. Okay, so if we could do that at this time. Luz, do you need the headphones or anything?
No.
Okay.
Cutting us off here so that they can discuss some issues.
Right.
And I think we're going to see you'll see the mic go off down here on the bottom left.
So sorry.
We don't let her out.
Yeah.
Please have a seat. Okay. Yesterday I gave you a homework assignment to visit with your clients. Is there what are your positions?
Your Honor, plaintiff Kari Lake, we have absolutely no objection to the court continuing in this matter.
Thank you, Mr. Bunn.
What?
Homework assignment. We have to turn it in.
Hold on. Hold on just a second. Go ahead. Have a seat. Mr. Olson, did you have anything to add or?
Your Honor.
All right. Any of the defendants or each of the defendants, I should say?
Morning again, Your Honor. Governor Katie Hobbs has no objection to proceeding the court.
Thank you.
So they're talking about timing stuff
Secretary of
like
State has no objection, Your Honor. Thank you.
continuances.
Your Honor, I've personally spoken to the actual elected representatives of Maricopa County and the recorder's office, and they each indicated they have the highest confidence in your ability to proceed without any bias in what you do. So,
Very well. I think I've heard from everyone. Then I'll proceed. My next question to you is this. Your jobs are hard enough.
Okay, so they gave us some access to the timing, and then they just cut us off. So the mic just cut off. So we got to hear a little bit about the continuance. So it sounds like we've got some questions about the judge's bias, and I'm wondering if there were some comments that were made on social media or somewhere else that were brought to the court's attention and that this is something they're talking about. So you know what I think is probably happening? This is probably something like what's happening in the Trump cases. And my point is, if there are comments that are being made on the internet, yesterday what happened, to catch everybody up, I'm scrolling around Twitter if you're wondering why I'm sort of trying to process what might be happening right now. Remember yesterday on the show, there was a moment where they paused, they kicked us out for a little bit, and somebody from Maricopa County's team brought their phone over to Kari Lake's lawyers, and they shoved it in their face, right? They shoved the phone in their face, and they said, Your Honor, we have to talk about this right now. And he said, right now. And the judge is like, well, relax, bro. He's like, I can't listen to you until you talk to them. And so they found something on the phone. I was wondering if they saw a mean tweet or something that was very offensive.
Say that we're going to take care of that first before we.
Oh, gosh.
That's okay.
And
Stay
maybe
where
they
you are.
questioned
I'm
bias.
excited.
You can do
Don't
that.
know what that was, but we're back.
we get the
Okay. All right. Okay, the court's been advised that there was an exhibit that the parties wish to add. On the record, I want to address this. So who's going to do that?
Yes, Your Honor. Your Honor, last night in preparation for today's testimony, we realized that Exhibit 18, which is the data chart drawn from Exhibit 20, the data that was produced by Maricopa County, pursuant to the Public Records Act request, that it had printed out two-sided and it was only scanned one-sided. Exhibit 18, as it currently stands, the summary, the totals, which are the most significant aspect of it, are in Exhibit 18. But Your Honor, we would request, and we also notified defendants as soon as we learned about this morning, we would request to add the complete exhibit numbered as Exhibit 47 now that we have prepared for Your Honor.
Thank you. And counsel for the defense, you've had the opportunity to inspect Exhibit 47.
We got an opportunity to look at it, Your Honor. I think our position generally is that we're going to object to its admissibility for purposes of this discussion. I don't know if you need to go there.
We're not admitting it right now.
I don't think we object to having it included in the exhibits. So it's for the purpose of completeness. But I just want to make the court aware we are absolutely objecting to its admissibility.
I'm not asking anybody to stipulate to admissibility at this point. We're simply correcting an administrative problem in that Exhibit 18 it was copied two-sided, and we're now correcting it to be Exhibit 47. Admissibility will be addressed at proper time.
Yes, thank you.
Okay. Yes.
The governor does object to the inclusion of this exhibit. Received, didn't get it.
This is what it's listed
Don't
at,
know what it is,
signature
so-
verification performance.
That's why I asked if you've inspected it. So if you want to look at it to make sure that's the other co-defendants apparently believe that it's the same thing, but not two copies cited.
Yeah, Your Honor, I have no reason to doubt that they're not being truthful about that, but it was like disclosed back to the court considering it in any form, but that was disclosed.
Well,
Okay.
it's just late. You can't add exhibits late, Your Honor.
Your Honor, Maricopa County is in a unique position because this document reportedly came from Maricopa County, so we've had it. Oh, I'm sorry. Was 18 one that?
18 is the data chart from Exhibit 20, which came from the.
But 18 is the one that was created by your witness.
Correct.
Okay, I feel like I'm not even here, Your Honor.
All they did is took
Okay.
18 and bumped it down to 47.
My only concern is if you want to look at it right now and compare it, I'll give you the chance to do that because I'm being told it's a technicality. It's basically what was there before is now being presented in different format with, in other words, one-sided copies versus two-sided copies. And nothing has changed
Katie
with
Hobbs.
regard to what's been previously disclosed and marked.
I
That's
object
what's
to
been represented to me. If you're telling me that
single-sided
you
pages,
haven't had
Your
the
Honor.
chance to look at it, I'll let you look at it.
My understanding, Your Honor, I apologize if I'm not stating this correctly, is that the exhibit that was disclosed was every other page of this chart. And now they have produced every page of the chart. If that's the case, Your Honor, I mean, I would still object. I don't know what these numbers are. I assume there'll be some testimony about that, but we didn't have this before.
Understood. And the significance of the numbers of admissibility is something that we'll address later, but this is I don't want to belabor this, but it appears to me to be a form over substance kind of a thing. So I'm hesitant to overrule an objection and say it's not admitted, but it's a procedural step. Put it this way. I'm going to allow them to mark it. It's going to be in the record. If you look over things later on and then you've got a problem with the difference between the two, you can raise that objection at the time it's posed for admission.
Understood, Your Honor.
Fair? Okay. I think we dealt with it.
Yes,
Okay.
we did.
Yesterday, where we left off was we had Mr. Valenzuela on the stand and Mr. Blem was continuing with his direct examination of Mr. Valenzuela.
Direct.
So, Mr. Valenzuela, sir, if you could please come forward. You remain under oath. If you'll just go ahead and have a seat up here to my right.
Do I turn something on?
There you are. Okay. Thank you. All right. I believe he's situated. So, Mr. Blem, as soon as you're ready, you may continue.
Thank you, Your Honor. Good morning, Ray.
Good morning.
I've got some documents here we're trying to get up onto the Elmo.
And I'm using these as demonstrative exhibits, Your Honor. They are simply video clips of verification room inside of MC Tech.
Is this the Elmo screen? Oh, we got video footage.
Judge, I was aware of having been disclosed the video we saw yesterday. I don't know what we're looking at here. I heard him say videos. I object to using any of these videos.
Well, which exhibit?
Yeah, but Your Honor, these are not exhibits. These are clips from video clips. I'm simply trying to conserve time by using these images. I'm going to ask Mr. Valenzuela what they depict and whether or not they appear to be an accurate representation of signature verification room inside of MC.
Okay, but they're not marked as exhibits and you're not intending to offer them as.
I have no intention of offering them as exhibits, Your Honor. They're solely for demonstrative purposes.
Your Honor, I disclosed and marked for exhibits by impeachment exhibits because that's what we were told to do. This is not fair. We cannot use things we've not seen and spring it on us or our witness in the middle of a hearing or a trial. These can't be used.
Okay, Mr. Liddy.
I would join that, and also, Your Honor, that this is not being used as a demonstrative. It is being used as evidence while this witness is on. It's not what a demonstrative is used for.
He's going to ask him
The
questions
governor
about.
would join in the objections by the other defendants. It's not a demonstrative. He is offering it as evidence.
Okay. Demonstrative exhibits, as I understand them, would be exhibits that would be offered to demonstrate how something happens. In other words, well, I don't want to give a seminar on demonstrative exhibits, but included within that would be things such as writing on a chart while a witness is testifying, explaining a calculation on a chart, or explaining a process.
Or yeah, pointing out a makeup of a room, who's where, how does this
Previous
process
clip
work?
that we used, I don't recall which exhibit it was. Somebody help me. What was the exhibit that
8.
19, Your Honor.
19? Thank you
19 is
all.
what I meant.
Exhibit 19 would serve the purpose of a demonstrative exhibit that we used yesterday.
That's the CD-ROM.
This would be cumulative in terms of demonstrative, and it hasn't been disclosed previously, and it's not marked as an exhibit. So
19 was the
Understood,
CD-ROM.
Your Honor.
is there something unique about this clip that demonstrates something completely different than we saw in exhibit 19?
Oh, this is actually used to refresh Ray's recollection, Your Honor. Yesterday, counsel for defendants made specific representations to this court regarding this signature verification employee. Mr. Valenzuela testified before this court that this gentleman was incompetent with technology.
That must be Steve.
Paraphrasing. And as a result of that, Your Honor, he was removed from the line, all right, and transferred to a new job.
Good, we're digging in.
These demonstrative exhibits I intend to use to refresh Mr. Valenzuela and his recollection so that we can more artfully discuss whether or not this individual was removed from the line and whether they were aware of his behavior during signature verification.
And what'd you do
Okay,
with it
so what
after?
you're telling me is it's impeachment evidence, because refreshing recollection, you have to have asked him a question first for him to say, I either can or can't answer that. But
Yes.
you'll also have to have foundation within the question, because if it's going to timestamp, if he has a statement, for instance, this activity happened on this date, for instance, the person was removed on X date, it's impeachment as to the memory or reference as to when this person was removed.
Understood.
And so if, never mind, we're going way beyond this, but it's the cart before the horse if you're using it for impeachment, and what you're demonstrating is the impeachment. So why don't you go ahead and ask the questions you wish to ask him first, and then we'll discuss what you can use it for related to impeachment.
Ray, did you hear the witness testimony yesterday stating that they were basically relieved of their responsibilities on November 11, 2022, following the general election?
Objection, Your Honor. Council's referring to opening statement by counsel, not to any testimony was put in evidence.
I believe the whistleblower witnesses we testified believe that they were told they were no longer needed as of November 11, 2022.
No, wait. Just to be clear, if you're going to impeach this witness, it has to be this witness's statement. This is not going to be.
I'm going to ask him about his statement, Your Honor.
Well, that's what I want you to do, is ask him what his statement is so that we can address possible impeachment, not someone else's statement, either in opening or a different witness.
All right. Ray, do you recall when this particular user that was depicted in the video yesterday was relieved of his duties as a level 1 signature verifier?
I do not.
Do you have any reason to believe it was November 11?
I would not have that data as indicated.
Do you have any reason to dispute that it was November 11?
I have no reference material to know when he was changed as far as job tasks.
Okay. You just know his job was changed.
Correct.
Okay. And he continued working for Maricopa County, isn't that correct?
That is correct.
In the elections department, correct?
Correct.
In a different level of signature verification?
Not in a different level of signature verification, in a different task, such as curing, such as special election boards. There are many tasks involved in the election process.
What individuals would be responsible for sitting in one of those little cubicles with green affidavit envelopes, sorting them into 2 different piles, and then walking them over to a little stand and dropping them in a green and a red box?
Objection is to form, Your Honor. There's been no testimony about anybody in a cubicle sorting green affidavit packets and moving them anywhere. There's just.
You could stop it for him. It was multifaceted. If you could break it down,
Okay.
Mr. Blum.
What task are they performing when they sit in their cubicles in the possession of green affidavit envelopes?
A physical green affidavit envelopes, then they are either in the process of curing, meaning alphabetizing those packets so that when a voter calls, we can locate them, and or they are packets that we needed that fall into a category of deceased, moved, all of those different, we categorize them into different trays to identify them as such.
Okay. And so what was the last day you had most of the temporary workers close their business with respect to signature verification?
And with respect to signature
I'll allow it. Go ahead.
as respect to signature verification, we were completed by Friday, November 11th.
By Friday, November 11th?
Absolutely.
Okay. And so it's entirely possible this gentleman was still working in signature verification as of November 11th. Isn't that correct?
More than likely not, because again, he was reassigned a task. That last push would have been the very last cue, if you will. So it wouldn't have been, we're done, now let's reassign him. It would have been ahead of that. Excuse me.
Because of his performance?
I don't say that it's because of his performance. I indicated on a reason why many folks or somebody could be moved out of a task. It could be performance, it could be technical skill set, many other things that could lend it to that.
Okay. Are you aware that the video that is Exhibit 19 has a date stamp of November 10?
I don't have the video in front of me, but I will trust that if it has date stamp, that date would be accurate.
Okay. And so if he's working on November 10 and now you're testifying that he was reassigned because he, was somehow incompetent with either his skill set or his performance, then was he really reassigned, or is that you simply trying to cover yourself?
Form.
An objection relevance, Your Honor. The issue
Okay.
is clarification.
All right. Overrule on relevance. I understand the form, although it's direct examination, this is a witness who's party representative of the other side. So I'll allow that it can be a leading question. The only issue is if Mr. Valenzuela, if you understood the question and you can answer it, please answer it. If you need it rephrased, you can ask it to be rephrased. If you don't understand the question, please do not guess. So, Mr. Liddy?
Your Honor, while formulating the question, he accused our client of trying to deceive the public to hide something that he did. That's argumentative,
Okay,
and I object to that,
all right.
and unfounded.
If you're just joining us, this is Kari Lake's lawyer, Mr. Blem.
Well, the unfounded part, we'll wait for his answer if he's able to answer the question. As to argumentative, I'd imagine most everything that Mr. Blem has is argumentative with regard to this state's position. Mr. Valenzuela, I believe, is capable of understanding the implications of the way the question is phrased. Okay, argumentative I reserve for, I will protect witnesses from being badgered or from being harassed, but if I feel that they're capable of answering the question,
Thank you, Your Honor. I'll withdraw my objection.
that's fine. Okay, Mr. Valenzuela, I'm sorry. It seems like it's been minutes since you were asked a question. I can have Mr. Blem re-ask it if you need to. Would that be helpful?
If I could have the question
Mr.
repeated.
Blem, please re-ask your question.
Mr. Valenzuela, you testified that this gentleman was reassigned, and you don't know why, so I will just leave that. Had something to do with his performance, whether skill-wise or duty-wise, that he was reassigned. Was that a way to simply protect yourself in Maricopa County Elections Department in the face of very negative?
Yeah, you got
Evidence.
me. You got me. I was trying to
And
cover
form.
up the fraud for the election. You got busted.
Okay.
Good question. You got me.
I'll overrule on relevance. And we've already gone over form. So if you can answer, please answer.
So to the question, if I'm looking to protect myself and the county by, I'm not sure what we're protecting ourselves. So we reassign somebody to a task because potentially they didn't have a skill set or the tool set, if you will, that to apply. I don't know how that's protecting ourselves or what statement I made that would infer that.
Okay. Have you provided this data set that's marked as Exhibit 20 to any media organizations like ABC News and the Data Guru?
Objection, relevance.
I give you a little bit of leeway. I'm not sure where this is going, but this is pretty far
He's
removed from the issues.
What's the 20?
You want to know whether they've disclosed this to any media?
Yes,
To
Your
the
Honor. The
committee?
reason for that is
Well,
the Data Guru on ABC News last night has been
hold on.
this is Twitter.
Well, I'm not bringing in the news. I'm not bringing in any kind of media. We're focused on this courtroom. Okay.
Did he make statements to them?
You
Can you
can
impeach
ask him
him?
if he's aware of any other public records requests if you want to by media. But
Data gurus on Twitter, Garrett Archer.
that
Mr. Valenzuela, are you aware of any public records requests made by any members of the media with respect to the data set that's been marked as Exhibit 20?
that's a yes or no.
Objection on relevance and foundation. The
Well, that's
it
what
is
yes or no.
Data guru says
Mr. Valenzuela is not the custodian of records for Maricopa County.
Data Guru says, I have
Given that that's the
verification
truth,
logs.
I'll allow him answer the question. If you're able to, Mr. Valenzuela.
No, I'm not aware.
Okay.
Thank you. Let's move on.
Are you aware at all if the data set marked as Exhibit 20 has been shared with any media outlets without making a formal public records request? Objection, relevance.
Objection foundation, this witness has not seen that exhibit, Your Honor.
Exhibit 20 is admitted, Your Honor. Maricopa County's data.
Right, but
That's Maricopa County and every employee.
But that's fine. But I'm not going to hold any witness to photographic memory standards.
Your Honor, for clarifying, are you speaking about the data set, the Exhibit 20?
CD-ROM and all.
Your Honor, I don't know how he could possibly testify to that knowledge of the entirety of Exhibit 20 in the data, the CD.
I'm not asking him specifics about the data, whether line 1,327,000 says X, Y, or Z, Your Honor.
Right.
I'm simply asking if the totality of that data set has been provided to any media outlets in the absence of a formal public records request.
Here's the issue. You can ask him as a private individual, or he's not here as the custodian of record. He's not here to testify as to the entire organization's responses with regard to public records requests. I'm struggling mightily with relevance.
But I'd simply say, Your Honor, that he is he's the designated representative for the Maricopa County Elections Department. He's here every day representing the people of the Elections Department and their work.
That may be true, but the Apex doctrine, and this is not somebody that, this is like asking the President of the United States about who stood guard last night at the Tomb of the Unknown Soldier. I'm not going to infer that he has photographic knowledge of everything. We're fast approaching, well, put it this way. I'm trying to be as lenient as possible with regard to relevance, but now we're far afield of the issue in front of the court. You've asked him one question about whether he has any knowledge of a public records request. He said no. If you want to ask him, I'll let you ask him one more question to the point of, has any knowledge of that information in that CD-ROM being shared with somebody? This is his personal knowledge, not the organization. Other than public requests, other than in this courtroom, you can ask him that.
Ray, do you have any personal knowledge of anyone sharing the contents of Exhibit 20 with anyone outside of Maricopa County Elections Department in the absence of a formal public records request?
As a representative of the department, as soon as a public record request is fulfilled, that becomes public records for any and all media and anybody else request. So, but for this particular data set, I am not aware of another public records request, as I haven't been in the office, been in court.
Exhibit 21. You're aware of Exhibit 21, isn't that correct?
I am not. Not just by the number.
It's this one, PR whatever this is.
Yes.
PRR 1482 in communications, some sort of document.
Marked as Exhibit 21, and can you tell the court if you are aware of that public records request?
I am.
Public records request 1482.
Did you help fill that public records request? Section, Your Honor, relevance?
Give you some leeway that we're going somewhere quick with this. All right, I'll take your word at it. You can answer it if you're able to, Mr. Valenzuela.
So the question did I assist? Yes, part and participle to several elements of this request I assisted with.
You actively assisted in the fulfillment of this public record request?
That is correct.
Your Honor,
When you're walking away and talking, I can't hear you.
oh, I apologize, Your Honor. I'm looking, okay, this has been admitted then, correct? Okay, then no need. So your answer is you're completely unaware then of any other disclosure of the documents you produced in response to Exhibit 21's record request?
As not being the custodian of records, I am not aware.
Do you have a formal custodian of records?
We do indeed.
When did that start?
Objection, relevance.
He's asking about signature
I'm understood
verification.
saying that we're.
All right. We'll switch gears here a little bit.
Here are some questions that I
Signature
thought of for
verification.
Steve.
And I don't think you specifically answered this question yesterday, but can it be done at an employee's home?
The review is part of having to be logged into our network. So it requires that element of an individual being on site or at one of the recorder's offices at the present.
Okay, so it's not possible then what you're testifying to log into your network to conduct signature verification from home.
Objection, relevance, Your Honor, to the extent that the question is formulated to get any information related to signature verification at any time other than November of 2022.
This was discussed yesterday with him, and I think the very question that you asked
Understood.
previously was asked and answered.
My specific questions, just to assuage their concerns, are specifically related to the general election of November 2022 and whether or not Maricopa County employees, because he has not answered this question yet, Your Honor, are able to log in to the county network and conduct signature verification from home.
You're
Objection, Your Honor.
asking, wait, let me clarify it to see if I've understood. You're asking him, is it possible for that to happen? Is that what you're asking?
Objection, Your Honor, this is relevance. He's talking about process. We aren't here trying the process. We're trying whether the existing process happened.
I'm not trying the process, Your Honor. Our next witness will present a great deal of evidence showing. I'm not testifying, I'm making an argument and I'm
Offer of proof.
protecting the record.
No, you're making an offer of
Offer
proof.
of proof. Okay, our next witness is going to present a great deal of testimony that a lot of what is taking place is simply button clicking, button clicking, button clicking.
Mhm.
We want to know if that is taking place outside of the public's purview, Your Honor. That's what we want to know. Because the law in Arizona,
I thank you for your clarification. He answered that yesterday, and I think you asked him if that was being done, and he said no. You're asking today if it's possible for an employee to log in from home to the computer system of the county.
that's what I'm asking, Your Honor. Is it possible?
Not just that, that's poorly phrased. You're asking him, is it possible for an employee to log in from home and do signature verification from home, not just log into the general county's website?
Correct, Your Honor. To log in and perform signature verifications from home.
Okay,
It's a yes or a no question, Your Honor.
I gathered that.
Yeah, they can do that. They were doing it from his office. You can remote log
Go
into
ahead and
these.
answer, Mr. Valenzuela.
If I may take a point of privilege, we do have remote capabilities
Yeah.
for several of our staff admin, and I can log into my PC, but it is not a set standard or protocol to do so for signature verification.
So you can do it. Perfect.
So
And nobody's required to look over you
I
to
understand the
monitor.
response correctly. Maricopa County employees can log into the county system and perform signature verification from home, correct? Yes or no?
As a protocol, not a standard. Yes, could the clouds cover the sky and make systems go down? We could have a lot of that, but technically they could log in, admin could log in
And
to our network.
conduct signature verification from home.
It's not a protocol that we have established for that.
Yes or no, can they do it? All right, I've got some questions for Steve here about Steve. This is Ray Valenzuela on the stand, but I've got questions. So you're in charge of all this. Can you explain how Steve was investigated and
Mr.
removed?
Valenzuela, I'm just trying to make sure the record is clear.
What are the criteria to remove somebody? How many other people were removed? Did you check Steve's work after you removed him?
Yes
If
or
not,
no
who did?
answer, Mr. Valenzuela. Is it physically possible for MAricopa County employees to log in and conduct signature verification
Asked and
from home?
answered.
Objection, Your Honor.
Asked and answered.
Relevance. Asked and answered.
Your Honor, he keeps saying protocol, smotocol. It's
Uh,
a yes or a no question. Can they do it?
An employee can log in and access all of their PC as if they were sitting in front of that PC remotely.
yeah, desktop,
That are
remote
assigned
desktop
those
access.
workstations. Not every employee has such.
Do you allow your temporary employees remote access?
They do not have workstations assigned to them, nor are they provided that capability, no.
Okay.
What political party does Steve belong to?
Change gears a little bit. Do you know someone by the name of Kathleen Nicolaitis?
I do indeed.
And who is she?
She is a certified forensic document examiner who's certified by the ABFDE with those credentials, and she is with Associated Forensic Laboratories, which is the entity that provides the Secretary of State's training to all 15 counties. In addition to that, we have contracted with her prior to the Secretary of State offering this service to train and certify our FTE, our full-time employees and permanent employees, and certified election officers.
Okay. And what is it? Do you have a personal relationship with her or anything?
Objection. Relevance.
She's the individual that does all the training for signature verification, Your Honor.
Right. And I think we're pretty far afield at this point.
I just want to understand his relationship, Your Honor, with this individual who conducts their signature verification training.
I don't understand the relevance, so I'm not going to allow that.
All right, Your Honor.
Disdain is another word for that.
All right. And so we talked yesterday about Exhibit 1. Can you please turn to the page that and this I would like to use as a mark to go.
Do you have a page number, please?
And the exhibits haven't been admitted yet. Exhibit 18, I think.
What is Exhibit 1?
You just said Exhibit 1.
If we can point to a page in one of the exhibits that you're about to use, then the answer to your question is yes. Of Exhibit 1.
And it should be titled User 130.
This page is numbered.
All right. Mr. Valenzuela, I suppose I should ask you, have you ever seen this page?
I briefly have
Where?
in today when we were looking at some of the numbers that potentially other witnesses had.
Do you respect the number 130, user 134? User 134
Your Honor, this is a document. We don't know anything about this document. Who created it? It's not in evidence yet. We would ask that.
Foundation.
Yeah, we would object on face.
I just want to ask him some specific questions about the data, and then I'm going to show a video of user 134. Ask some questions about
He's not allowed.
Well, right. So, first of all, this is not data created by the witness,
No, Your Honor.
Mr. Blount.
Your Honor, this is data that's contained in exhibit number 20.
Which the witness testified.
Wait, I thought we were exhibit 11, page 139, user 134.
It should say user 134, Your Honor.
No, but I have it down as exhibit 11, page 139. Is that what it is?
Yes.
Foundation.
Okay, and who is this data created by? This witness or someone
No,
else?
the data wasn't, the data was created by Maricopa County. What this data represents, Your Honor, are keystrokes on user verification computers. So when a user logs into their workstation, that's how they know how everything we do at work. They hit a button that says to do something, and that's recorded.
Okay,
this
this
is-
sounds like you're laying foundation by you testifying, but what I'm concerned about is a demonstrative exhibit. Put it this way, if you want to ask him a hypothetical question with assumptions of certain things, you're able to do that.
That's where I'm going, Your Honor. I want to ask him a hypothetical question.
And lay the foundation for your hypothetical, please. You have to give him the specific variables that you want him to consider. Let's make whatever you want him to assume, and then if he's able to offer an opinion, he can do that.
Mr. Valenzuela, going back to the user that we. Does that look like it might accurately represent his behavior?
Objection to form.
Sustain on form because it goes to foundation. It's assuming there's several leaps in this. Please go back and lay the foundation.
Okay. Let's assume that this data represents user 34
What?
and his approval.
134 or 34?
I'm sorry, we got 34 now.
Your Honor, may I please be heard?
Go ahead.
I'm objecting to foundation because my understanding is, although I can't see it because of the furniture in the courtroom, that there is an exhibit in front of my client, the witness, that he's looking at it. Okay, there. This, as you can see, what we have here from this exhibit, it's a white page with black ink, red ink, green ink on it. We have no idea what it is. We have no idea who produced it, where it came from. I'm asking for him to provide some foundation before he shows it to the witness and asks him questions on it. Thank you, Your Honor.
Okay. Right,
Certain facts.
right, but I'm having a hard time following your hypothetical because I don't know before what we're asking for him to assume. For his opinion, your question and his answer to have any value, I need to understand the basis for it.
Objection. Sorry, Your Honor. Sorry. Just an objection from us, Your Honor. I candidly am lost. If we're gonna start all over on this issue and lay foundation, that'd be great. I honestly am not able to follow along at this point.
Thank you.
Okay. Mr. Valenzuela, are you a data analyst?
I am not.
Background at all in analyzing data sets such as that contained in Exhibit 20?
Other than reviewing data and obviously pivot table and that kind of for statistics, but not an expert in data analysis.
What is your background in statistics?
I have no background in statistics. It's deriving statistics, example, turnout. early voting participation, those kinds of broad,
And so you can do that math?
yes.
Okay, how do you do that math? Tell us, how do you compute turnout?
Relevance.
Join.
This witness is not an expert.
I think,
Okay, he's not an expert.
wait, wait.
I think he is.
Far afield.
I think he is an expert.
Let's lay the foundation specifically for this exhibit and then establish the parameters of your question for him so that I understand the basis of what's being asked.
Okay. Mr. Valenzuela, do you have any reason to dispute that this data accurately represents the time performance of user 134 from the date? And ended?
Objection is the foundation to the extent that counsel is referring to data on the exhibit for which there's been no foundation laid.
I'm going to sustain it. I'm not going to tell you how to ask the question. But we don't have foundation to ask the question you're posing to you.
Your Honor.
We couldn't even hear what that question was because he's not by the mic. All right, good. Olson standing up, wrote him a note. Hey, ask this question.
Okay. I just wanted one hypothetical question to ask him, but I have to ask him to assume, Your Honor. The assumption I'm asking him to assume is this: that this user and his approval of ballot affidavit envelopes is represented by this line on this graph, Your Honor, over time.
Going to be the same objection.
That's the question?
The hypothetical is, if that is consistent with Maricopa County's standards for approving ballot affidavit signatures. That is my question.
Objection, foundation, Your Honor, as regarded his digit on that right hand was pointed to that exhibit for which no foundation has been laid.
Okay. But hypothetically, what you're asking him, the problem is you've been thinking about this examination for a long time, and there are things in your examination, the question you're asking him that are quantum leaps and assumptions that you're not asking him to assume. And so it lacks foundation. If you want to show him a picture, not representing that it's anything substantive from the case, but this is assuming, and I'm trying to tell you how to ask your question.
And Your Honor, that's, I'm showing him this graph and just asking him to assume.
But is this a graph to show you? I don't, as I look at this, I don't know what that graph is. I don't know what any of the axes represent. And you're asking him a hypothetical that doesn't, you're leaving out assumptions. You're not providing all the data. You're just saying,
Mr. Valenzuela,
look appropriate.
what I would like you to assume on this graph, this axis here represents the number of ballot affidavit envelopes approved. And that this axis here represents the time taken to approve. Do you understand?
I understand that explanation, yeah.
So if you had a signature verification employee whose time to approve on average followed this pattern, would you say that they are comparing signatures or they're not comparing signatures?
Objection, foundation, Your Honor. We don't know where this document came from, who made it, what it.
At this point in time, Mr. Valenzuela, if you're able to understand the question and you don't need any other information or clarification, and you're able to answer the question the way it's posed to you, you can answer it. If you can't, you can tell me you can't.
I don't believe I can accurately answer. I can make some assumptions like you're asking me to, but I don't know that particular data. I don't know who that user is. But if you're asking, does that bar look accurate as far as ups and downs, peaks and valleys? There would indeed be peaks and valleys when somebody's doing a disposition of a no signature 1 second, a no signature 1 second, a absolute consistent signature 2.4 seconds, or one that is not consistent that needs further evaluation. So we would see peaks and valleys in any user who reviews signatures.
Oh, okay. And so please explain for me what you mean by these here peaks and valleys. Is this a peak?
I'm inferring that's what that is because I'm looking at a chart that have never seen before, but assuming it goes up and down, that is indication as you explain the axis to me.
Your Honor, sorry, finish your question.
Because we're both making assumptions.
You're asking me to make an assumption. I am following along.
Yeah,
That's what I'm doing. I'm asking you to make assumptions.
Objection calls for speculation.
And that you, as the head of the elections department who oversee all signatures, is this, if this represented, user 134 represented an actual Maricopa County signature verification employee, would you say that that behavior is consistent with their oath of office?
Objection, Your Honor. It appears the counsel is using that as a demonstrative, and he's asking the witness to make assumptions that it's based on actual data from the 22 election, for which no foundation has been laid. And he's then will argue to the court that based on these assumptions, his answers are evidence that somehow should be used by the court to deliberate for the ultimate question. This is completely improper, and it deprives my client of their due process rights in this hearing.
Thank you. All right. Is this a demonstrative? Hold on, Mr. Blum. There was an objection. Is that a demonstrative exhibit? You started off by saying that that's a demonstrative exhibit.
Yes, sure.
Okay, that means that you've got a witness that you will use to lay the foundation for that.
Okay.
Now, you can ask questions. In fact, you already did yesterday. Ask all the questions about times for performing the analysis of whether signatures were similar and timing. But now you've apparently transposed that, some representation of that onto that demonstrative exhibit. It's not this witness's demonstrative exhibit. And so if you have a witness that you want to lay the foundation for that demonstrative exhibit, it's not, demonstrative exhibits don't come into evidence. They are there for demonstrating more effectively to the trier of fact what the witness is testifying to.
Understood, John.
So this is not a proper use of a demonstrative exhibits. You've already asked and had answers to all of the questions related to the data yesterday.
Understood, John.
So let's move on, please.
a lot of time on the rules here.
Okay, so
Almost very little questions and testimony.
you testified that you did participate in the production of that data that I represented to you is represented by this chart I asked you to make assumptions about, correct?
Correct.
Okay. What was your role? What role did you play in producing that data?
I apologize because it's going to sound overly broad, but I requested it of our RT and gave them specifics of what to pull for that data request.
Okay.
But I did not pull the data myself. I did not analyze the data. I submitted the ticket under the public records request.
All right. Do you have the ability to analyze this data?
I do. I have the raw data, but I don't have the ability to probably to that degree, as again, indicated, I'm not a data analyst.
Okay. Thank you.
Okay, it's asked and answered, so.
All right. I'm done, Your Honor.
I'm done.
All right, cross-examine. I told you yesterday, you can either go as far as you want, because as you all understand, Arizona is not limited like the federal system on cross-examination. You can go as broad as you want if it avoids calling the witness again, in your case in chief, or you can stick to what you wish to in this case.
Woosah.
So who's doing the cross?
Woosah. Woosah.
Yes, Your Honor, we will be calling this witness as our only witness on direct.
That's your right.
And I'm happy to do a minor cross to clean this up. I can do that on direct. It's really up to you, Your Honor, how you want to do this. I don't know if you need a break now or.
It's really not up to me. It's your choice as to how you wish to try your case. But I'm just emphasizing you have that. I'm signaling to you that I recognize that you have the right to recall this witness if you wish to in your case in chief. So you can either conduct cross as you see fit or not.
Your Honor, we're going to not question this witness at this time and wait and do all of our work on our direct.
Very
On
well.
our case.
Okay. Okay, without cross, there's no rebuttal. And so can we,
Next witness.
I think somebody in the back, are you taking pictures, sir?
No.
Sir, are you taking pictures? Pardon me? I didn't hear your answer.
Your Honor, he said, yes, he did, but he won't anymore.
Okay.
Delete that.
Okay. All right, there's just specific rules that are in place that we have to follow with regard to that. So I would just ask you to delete that. I could have my staff review that. I'm not going to have them come take your camera, but you already get it. You're not going to take more pictures. If you could just delete what you took in the courtroom, I'd appreciate it. Thank you. Okay, so
Hopefully it's not already on Twitter.
we're going to, let's see. We've only been at
Don't
this for an
retweet
hour.
that.
So, Mr. Valenzuela, I think we can excuse you to go ahead and take your place in the courtroom if you'd like to, sir. Thank you. Okay. Who is the next witness that you would call? I think you only got one witness left that you told me.
Correct, Your Honor. That is Mr. Speckin.
Okay.
Oh,
Are
we
you
only
ready
got
to?
one? We're
to-
not calling Scott
Oh.
Jarrett? We're not calling Scott?
Just returning the. Perfect. Thank you, Mr. Blem. I appreciate that.
Yeah, what about Bill
Okay.
Gates? Onesie, twosie, Bill Gates.
Luz, how are you doing? Do you want to break now or do you want to keep going? Okay, we're going to continue because I have to check with the court reporter. So we'll begin with your minutes, Mr. Olson, knowing that we'll probably break around 10:30 for the mid-morning break. Okay. All right. Go ahead. Get your, I think he's.
Maricopa County. I'm Bill
Your Honor, plaintiffs will
Gates,
call
Chairman
Erich
of the
Speckin.
Maricopa County
Mr.
Board of
Speckin.
Supervisors.
And I'm Stephen
Come on
Richard,
forward,
the
sir.
Maricopa County Recorder.
You could raise your right hand and be
Here to
sworn in,
give you
sir.
an update on how things are going so far with the election. We've already had almost 44,000 people show up this morning,
Mr.
check in, and be
Have a seat.
available to vote. And things are going great out there, but there's one thing that we wanted to address to make people aware of today. And
All
that
right,
has to do
Mr.
with
Olson,
our
you can
tag.
begin.
Your Honor, I just want to move that monitor.
What is, oh, the monitor. Yeah, right. That's just fine. That's fine, sir. Is that blocking anybody on the defense side now?
No, Your Honor. Thank you.
We're good. Thank you.
Your Honor.
Now, according to county.
Good morning, Mr. Speckin.
Good morning.
Could you please state your full name for the record?
Erich Speckin, that's E-R-I-C-H. Last name Speckin, S-P-E-C-K-I-N.
What's
And
up,
Mr.
Eric? Thanks for
Speckin, where do
being
you
here.
work?
I work for Speckin Forensics. Our main office is in Michigan. I work primarily out of the Fort Lauderdale, Florida office. Now Hollywood, Florida, I should say.
And what does Speckin Forensics do?
We're a full-service forensic firm. We deal with all aspects of forensic science. We deal with computer data recovery, crime scene crime scene reconstruction,
DUI, blood,
firearms and tool mark, fingerprints, DNA,
Blood?
toxicology.
toxicology.
But the
Good.
section that I deal with is documents and inks.
Mr. Speckin, you need some water. You coughed.
Have it ready. Thank you, Your Honor. And they have extra lined up for me, I think, too.
You're set.
All right, this should be good stuff. This is
Do you
this guy's
also
highly
work in the field
qualified.
of handwriting analysis?
Yes, so under documents and inks, there are two schools of thought. There's a document analyst that looks at just the document aspect, and then there's handwriting. I do both, and in the United States, nearly everyone does that does documents also does handwriting. In some countries, they differentiate the two. But under document examination, or under that title, it would be document examination, and handwriting would be part of that.
And is signature verification subsumed within handwriting analysis?
That would be another way to say it, or an application thereof from handwriting examination for determination of authorship. That's the way I would say it. But signature verification is saying the same thing, in my opinion. It's just not a phrase that I normally use. I would say determination of authorship, but it's the same thing.
And can you give me a more detailed description of your job that you perform at Speckin Forensics?
So my primary functions as it relates to work are documents and inks. I mean, I have administrative functions as well, but nobody's probably interested in those today. So I deal with the examination of documents and inks. So in the examination of documents, I examine documents for alterations, additions, and rewritings. Has a document been altered, changed, added to after the fact, and also perhaps when it was done. The
Interesting.
examination of photocopiers, facsimiles, printers for determination of origin, date, time, associations. The larger part, especially now because we've had a death of one of our partners, is handwriting. I've been doing handwriting now for 30 years, a little over. And that is the determination of handwriting and hand printing. Of course, included in that is signatures for determination of authorship. Did someone write something or not? And the certainty to which you can express that conclusion. And that's what I deal with on a large scale. It seems like if you ask my wife every day, but 6 days a week, probably.
And so I believe you testified that you have worked at Speckin Forensics for the approximately past 30 years.
Yes, I started in March of 1993, and now we're May of 2023, so 30 years and 3 months.
How many employees are at Speckin Forensics currently?
Between full and part-time, you would say?
Yes.
Well, instead of testing my memory to count every one, I'd say roughly a dozen.
Okay.
I could take a lot of time and give you an exact answer, but if that's good enough for you, roughly a dozen.
Can you describe the education and training that you have in the areas of expertise you just described with respect to document analysis, handwriting analysis?
Yes, I have a degree in chemistry. It's a Bachelor of Arts from the College of Natural Science from Michigan State University. That's my educational background. My training, I had a 2-year training program with Leonard Speckin. That's my father. My training, I had a 2-year training program with Leonard Speckin. That's my father. It was in the examination of documents and signatures. He's the retired chief document examiner for the Michigan State Police. He retired in December of 1989. He trained me from 1993 to 1995 in the examination of documents and handwriting for determination of authorship as it relates to handwriting. I then had a 1-year training program with Richard Brunel. He's the retired deputy director of the ATF National Laboratory. He trained me from 1995 to 1996. That primarily focused on inks and papers, who manufactured an ink, when it came out, how long it's been on the paper, and are 2 inks the same or different? That's the primary fast answer to what that was. And that was from 95 to 96.
Do you hold any licenses related to offering expert opinions on handwriting analysis?
No, there's not a license per se that's granted by a state or local body. I am a licensed private investigator in the state of Michigan, which is required under laws of some states. I don't think Arizona is one of them, but I don't know for sure. But you have to be a licensed private investigator to store and maintain forensic data, primarily related to computer cases and computer data. I maintain that license in an abundance of caution, but it's not something that really plays into my normal workday, but I have it.
You described two instances of the training that you've undergone for handwriting analysis, I believe.
Yes, my father and Richard Brunel.
And do you maintain any, or strike that, do you perform any proficiency tests, annual tests that would allow you to show that you have maintained proficiency in these areas?
Yes, my laboratory many years ago, I think in 2007 or 2008, at the decision of Roger Bullhouse, who was our laboratory director at the time, decided that we would all go in our laboratory, undergo proficiency testing. So we have an outside proficiency testing agency called CTS, Collaborative Testing Services. They're the ones who provide a lot of testing for government agencies as well. That's what they do. To be tested in handwriting and document examination for me, obviously our DNA people are tested in DNA, but that's what I'm tested in on an annual basis. And we have occasional additional proficiency tests that will be tested that are internal proficiency tests that are created by staff at the laboratory. But the main one is outside proficiency testing on an annual basis.
And when is the last time that you completed your outside proficiency testing in handwriting analysis?
With COVID, it changed things a little bit. So I can't remember if it's 1 year or 2 years ago. And the new one is coming up. So it's been ordered, but I haven't been delivered for 2023 yet.
Have you participated in any workshops with respect to scientific meetings on the issue of handwriting analysis?
Yes, I've attended many workshops on handwriting examination, expressing conclusions. Within that, determination of handwriting on mass scales. They have software in the forensic world for mass scale handwriting comparisons. I've looked at what they would say would be more difficult cases, like how to tell something that might be more difficult that a layperson wouldn't be able to see in terms of forgeries and how it's done. But that's probably one of the more frequent workshops is the examination of handwriting in some form or fashion, because it's one of the more common things that's encountered in my field by similar experts.
I wonder how long
Who
it takes
puts
him to
on these
compare
workshops
signatures.
that you're describing?
Well, generally speaking, it would be a relevant scientific organization. So it might be, I heard someone say American Board of Forensic Document Examiners. They don't actually have their own, but they have American Academy of Forensic Sciences that they're related to. They have workshops all the time. The American Society of Question Document Examiners has workshops. Here you have the Southwestern Association of Forensic Document Examiners, SWAFD. They will put on workshops. There are other regional organizations similar to that, such as MAFS or SAFs, or for different geographical areas that will put on workshops. I've also attended workshops from specialties. In other words, I've attended workshops at Canon on how Canon printers, technologies, and toners work. I've attended workshops on paper, on how paper is made at various factories. I've attended workshops on ink, on how inks and pens are made and ink is put in pens. Those are not the norm, but those happen on occasion, and I always try to make those.
Are there workshops specifically related to the issue of handwriting analysis?
Yeah, as I said, with various scientific bodies, that's probably one of the most common types of workshops that's available.
And do you participate in those workshops as well when made available to you and schedule permits?
When schedule permits is exactly how I was going to answer. Early on in my career, I attended a lot more frequently. As I've gotten busier and had more children, I've attended less frequently, but I still do attend. And I also present. I mean, I'm a frequent presenter of papers and workshops at various scientific bodies on this type of thing.
How many cases involving handwriting and signatures have you reviewed in your career?
So I only, when we say cases, just to be clear, I only keep track of a case by a submitter. So for instance, there could be a case with many, many signatures that are involved, but it's only one case. So if we take one case by single submitter, I would estimate it's probably at this point in my career in the range of 3,000, 2,800 to 3,200, given a range that I've examined as an examiner. And I'd estimate in my training period, I had probably around 700 that I either reviewed through the course of the work, or I was asked to review older cases for specific purposes for training supplement.
Have you testified as an expert witness with respect to, well, strike that. How many cases have you testified as an expert witness in your field?
I think the number is 413 today. This will be the 413th time in my career, counting trials and depositions. I don't have it broken down specifically, but counting trials and depositions, sworn testimony, I think this is around 413.
That's a lot.
Of those cases, how many did you testify on the issue of handwriting analysis, signature verification?
I can't give you a breakdown that fine. I can tell you it's the majority of them, but I don't know that it's 297 or 350, or I can't give you a number that specific. That would mislead to say I know it that specifically, and I don't. But the majority of them have been handwriting type cases.
So when you say the majority of them, you mean the majority of the 413 cases that you referred to earlier?
Correct. Over the majority, well over half is what I mean.
This is pretty typical. A lot of foundation. He's highly qualified.
All of the cases from which you testified as an expert, have you ever been disqualified by any court?
There was one instance related to ink dating where a court read an opinion that had been thrown out and said, we're not going to have testimony on that issue, but never with handwriting.
So when you say ink dating, what does that refer to?
Well, the issue was a very, very narrow issue, and it had to do with the estimation of age, the length of time an ink had been on paper by the chemical drying properties, and comparing it to an ink from the same sample that had been accelerated aged in a laboratory and saying the extraction properties were different. That's the technique, and that was in 2003. Now, every private laboratory I know uses that use of heat to accelerate the age of inks. But in 2003, the judge wasn't ready to hear that at that time for a myriad of reasons.
You mentioned that the court relied on a case that had been vacated. Can you explain that further?
Well, so the case that I'm talking about where the judge didn't allow testimony here in the United States was EEOC versus Ethan Allen, Northern District of Ohio. And I think it was 2002 or 2003. They quoted an opinion from a Hong Kong case that had myriads of terrible things to say about me. And it later came out that the judge didn't write that opinion at all. He just copied it from what the other side had written. And the Court of Final Appeal, they call it the CFA in Hong Kong, threw the decision out because the judge merely copied what the defense had written. And I don't remember the exact language. It's been over 20 years. But something like he didn't apply an independent thought, or I don't remember exactly, but something like that. Or they couldn't be satisfied. He applied an independent mind. I don't remember exactly, though.
Can you describe to the court the number of different venues, jurisdictions in which you have testified as an expert in handwriting analysis?
Specific to handwriting? Let me think.
Well, let's
I'm just starting from
back up for a moment.
Uh-huh.
I'll withdraw the question. Can you describe to the court the number of cases, or strike the number of jurisdictions and the names of the jurisdictions in which you have given testimony as an expert in your field?
So as an expert in the field, I can give the fast answer of 37 states and 11 countries.
Nice.
I can attempt to list most of the countries. The ULEX court in Kosovo, England, Jamaica,
Nice.
Canada, Mexico, Japan, Hong Kong,
I'd say he's qualified.
United States.
Yeah, he's qualified.
I'm falling short on 3.
Don't need the rest of the countries. No problem. We got it.
Germany by submission.
All right, let's get to 2022 now.
The Virgin Islands. And the last one currently stumps me, but I'll probably have it before I leave the witness stand if anyone cares for the 11th.
I believe you testified that you have offered expert testimony in over 30 states.
37, I believe, is the count.
And is Arizona one of those states in which you have offered expert testimony in your field of study?
Yes, Arizona is. The surrounding states, well, forgive me if my geography is slightly off, but when I say surrounding states, I mean the ones that are close. They might not touch, but California, Nevada, New Mexico, Colorado. I know Texas doesn't touch, but it's kind of close if you're from the East Coast. And then spreading all the way up to Washington State, Maine, and Florida, and everywhere in between of missing 13 states that I haven't.
And can you give just a general description of the clients that have retained you to give expert testimony on their behalf? Are they individuals? Are they companies?
So most of the clients that would retain me would be lawyers representing a party. It could be a governmental entity, it could be a company, it could be an individual. I do have some companies and some organizations that have retained me directly. The NCAA, the NBA, NHL Players Association, things like that. Big companies with internal reviews of certain issues. Handwriting is a common one. Did someone write a threatening letter? Did someone write a note on a bathroom wall? It's common that I'm retained by a company such as General Motors, a Ford, a Honda, Chrysler, that sort of thing in those instances. Large banks, I mean, anybody with big HR departments that conduct their own investigations on threats. I see that frequently. But still, the majority is attorneys that represent a party that would retain my firm.
What government agencies have retained you as an expert?
As an expert, Florida Department of Law Enforcement retained me to provide training to perform analyses. Many U.S. attorneys' offices, prosecutors' offices in many states, National Labor Relations Board, the DEA in forged prescription cases, SEC, and then usually it would be the U.S. attorney representing someone. So it might be a case, say, for an FBI prosecution, but the U.S. attorney is who retained me. So it wouldn't be directly from that agency. It would be a U.S. attorney's office, or I forget the national of the Fish and Wildlife, whatever that is. I've been retained by the U.S. attorney's office in those type instances.
And have you been retained by government agencies, particularly with respect to law enforcement, for your testimony regarding handwriting analysis?
Yes, I would say most of those were. With few exceptions, it might have only been regards to ink dating, like Orange County, California prosecutor's office retained me, but it was only related to ink dating. Los Angeles County prosecutor has retained me for both. I mean, we could go on, but yes, generally it's both, but in some instances, it's only one of them.
Have you ever testified in front of any legislative bodies on the issue of the subject matters of your expertise?
Yes, I have.
Can you describe that?
I testified here in Arizona at a hearing. I think it was a joint session of the Senate and the House together. It was a few months back. I've testified in the state of Michigan to I think it was the House of Representatives. It might have been the Senate as well. I'm not for certain. Those are the only two times I can think of.
Have you been appointed by any court for the defense in criminal cases?
Yes, I've been appointed by judges throughout the country many times for my expertise.
And did any of those appointments involve the subject of handwriting analysis for your expertise?
Most all of them. That's the most common thing that you would see in government practice. And I would say most of them, yes.
In your career, have you
Yes, he has. He's very competent.
offered
very
opinions
qualified.
or testified as an expert in election-related cases?
Yes.
Offered
5,000 of them.
opinions many times. I've testified in election cases, only a few. Doesn't normally come to testimony on the broad spectrum of the cases that I see. Obviously, examined thousands and testified hundreds speaks to that. But I've offered opinions many times, yes.
Have you performed handwriting analysis in connection with election-related cases?
The majority of election-related cases would be related to handwriting, except for a few recent ones regarding printing processes and so on. But historically speaking, it was handwriting that I dealt with almost exclusively, but most still are handwriting.
Can you describe when you're doing work related to elections and handwriting analysis, what is the work that you're doing?
So the most common thing that I've seen in the past when it relates to handwriting is in nominating petitions, recall petitions, that sort of thing, that are signatures required to put something on the ballot, either a person or a referendum or whatever that's called. And they have to gather a certain number of signatures in order for that to be voted on. And I'm not an expert in politics, but that is how I understand it. Looking at those signatures to determine, more commonly, not is it the exact person of that signature, but did one person sign a bunch of these names all together? Or is there what we refer to as a round robin of 8 people sitting around a table and person A signed signature line 1 and then 2 and 3 and so on. And so every 8th line, in general terms, is signed by the same person. So it's looking at overall characteristics of handwriting to determine is there common authorship that can be determined on a rotating basis like that. Not very often in election matters, the way the discovery works, are we provided signatures and known signatures to compare to of the people and be able to do it in a manner that comports with the discovery rules in election cases. So I don't see that too often in election cases like that. I have in the past, but that's infrequent. Usually it's more on petitions and ballots.
Are there other instances where you are tasked with evaluating large numbers of signatures?
Sure, there's other applications, of course. I mean, when I started, well, not maybe exactly when I started, but early on in my career, long distance slamming was a big thing. So you could go to a supermarket and you sign a piece of paper saying, change my long distance carrier to this person, and they give you a $50 gift certificate or a savings bond or whatever. I mean, they have some or toaster, whatever, they have some gimmick, right? And then these people say, I never changed my long distance. Well, then the FCC investigates that and says, did this long distance carrier fraudulently switch them to their service? And in that case, then you have to go do the research and get collected signatures from DMVs in those states or voter applications, voters registrations, if you can get them, and then do the comparison that way. So that's an instance of it being done in a mass scale. Mass tort cases were certain documents signed by plaintiffs when there's the most recent one I can think of with an affidavit was the Birmingham hip replacement case. And there were hundreds of plaintiffs in that case. And the question was, were they signing their updated disclosures of some sort? And I don't remember exactly which disclosure, but were those signatures consistent with other documents they had signed in the court proceedings to that point in time? And there were hundreds of plaintiffs to look at and do that comparison. So it's something that I see regularly on top of election cases in a mass tort or other related settings.
So in this context,
This is
you
all the
have
countries,
often
all the
performed an
states.
analysis of signatures to compare with a record signature to determine whether or not the signature is consistent or matches, correct?
I would just modify the question to say record signatures is the most common. So usually you have 1, 2, or 3, 2 and 3, or 4 or 5, whatever. You sometimes only have 1, but that's not the most common result of how many signatures you have. But sometimes it can be 1, yes. And you do the comparison with what you have. Absolutely.
Kraft Foods, Citigroup cases, JJK Industries, ExxonMobil. He's worked on ExxonMobil versus Polar Equipment, Local Union versus Kraft Foods, Citigroup, Walt Disney Corporation, Winnie the Pooh appeal.
Mr. Speckin, are you familiar with the
General Motors
issues related to signature verification that are being presented in this case?
We have 2
Hold on
minutes.
just a sec.
Let's take a break.
I sense a change of gears.
Yep. Knew that was coming.
From foundation to application.
Yep.
It's 10:30 and we need to take a break.
Knew that
So
was
I'd
coming.
rather not chop you off in the middle of what you're attempting to do, but take a break here, come back in the 15 minutes and let you resume, okay? So we'll be taking our morning recess of 15 minutes.
All right. So, all rise. We have to comply with the OSHA requirements. We have to stretch. So we are going to take a quick break here as well, my friends. I want to queue up what was happening earlier today. So let's do that so that we have a little bit of background activity going on. But we're going to come back. That was a lot of foundation, okay? A lot, like, a lot. So we'll come back and then we'll actually get some application. We'll get some questions that will go out. And so that will be very good. But let us pause. Let's do a little bit of a bathroom break, a stretch break. We're going to want to get outside or at least get some blood moving a little bit. And we'll come back in about 10 minutes from here. I'm getting a couple things queued up on the screen. And then we'll come back in about 10 minutes for some good stuff. This should actually be good. This is going to be Kari Lake's expert witness talking about application of signature handwriting verifications in this election. So should be quite good. And we'll get right to that. Here's what happened earlier
All right, do you
today.
have the ability to analyze this data?
I do. I have the raw data, but I don't have the ability to probably to that degree, as again, indicated, I'm not a data analyst.
We'll be back in 10 minutes, my friends.
Thank you.
Okay, it's asked and answered, so.
All right, thanks then to, I'm done, Your Honor.
I'm done.
All right, cross-examine. I told you yesterday, you can either go as far as you want, because as you all understand, Arizona is not limited like the federal system on cross-examination. You can go as broad as you want if it avoids calling the witness again, in your case in chief, or you can stick to what you wish to in this case.
Woosah.
So who's doing the cross?
Woosah. Woosah.
Yes, Your Honor, we will be calling this witness as our only witness on direct.
That's your right.
And I'm happy to do a minor cross to clean this up. I can do that on direct. It's really up to you, Your Honor, how you want to do this. I don't know if you need a break now or.
It's really not up to me. It's your choice as to how you wish to try your case. But I'm just emphasizing you have that. I'm signaling to you that I recognize that you have the right to recall this witness if you wish to in your case in chief. So you can either conduct cross as you see fit or not.
Your Honor, we're going to not question this witness at this time and wait and do all of our work on our direct,
Very
on
well.
our case.
Okay. Okay, without cross, there's no rebuttal. And so can we,
Next witness.
I think somebody in the back, are you taking pictures, sir?
No.
Sir, are you taking pictures? Pardon me? I didn't hear your answer.
Your Honor, he said, yes, he did, but he won't anymore.
Okay.
Delete that.
Okay. All right, there's just specific rules that are in place that we have to follow with regard to that. So I would just ask you to delete that. I could have my staff review that. I'm not going to have them come take your camera, but you already get it. You're not going to take more pictures. If you could just delete what you took in the courtroom, I'd appreciate it. Thank you. Okay, so
Hopefully it's not already on Twitter.
we're going to, let's see. We've only been at
Don't
this for an
retweet
hour.
that.
So, Mr. Valenzuela, I think we can excuse you to go ahead and take your place in the courtroom if you'd like to, sir. Thank you. Okay. Who is the next witness that you would call? I think you only got one witness left that you told me.
Correct, Your Honor. That is Mr. Speckin.
Okay.
Oh,
Are
we
you
only
ready
got
to?
one? We're
to-
not calling Scott
Oh.
Jarrett? We're not calling Scott?
Just returning the. Perfect. Thank you, Mr. Blem. I appreciate that.
Yeah, what about Bill
Okay.
Gates? Onesie, twosie, Bill Gates.
Luz, how are you doing? Do you want to break now or do you want to keep going? Okay, we're going to continue because I have to check with the court reporter. So we'll begin with your minutes, Mr. Olson, knowing that we'll probably break around 10:30 for the mid-morning break. Okay. All right. Go ahead. Get your, I
Hello,
think he's,
Maricopa County. I'm Bill
Your Honor, plaintiffs will
Gates,
call
Chairman
Erich
of the
Speckin.
Maricopa County
Mr.
Board of
Speckin.
Supervisors.
And I'm Stephen
Come on
Richard,
forward,
the
sir.
Maricopa County Recorder.
you could raise your right hand and be
Here to
sworn
give
in,
you
sir.
an update on how things are going so far with the election. We've already had almost 44,000 people show up this morning,
Mr.
check in, and be
Have a seat.
available to vote. And things are going great out there, but there's one thing that we wanted to address to make people aware of today. And
All
that
right,
has to do
Mr.
with
Olson,
our
you can
tech.
begin.
Your Honor, I just want to move that monitor.
What is, oh, the monitor. Yeah, right. That's just fine. That's fine, sir. Is that blocking anybody on the defense side now?
No, Your Honor. Thank you.
We're good. Thank you.
Your Honor.
Now, according to county.
Good morning, Mr. Speckin.
Good morning.
Could you please state your full name for the record?
Erich Speckin, that's E-R-I-C-H. Last name Speckin, S-P-E-C-K-I-N.
What's
And
up,
Mr.
Eric? Thanks for
Speckin, where do
being
you
here.
work?
I work for Speckin Forensics. Our main office is in Michigan. I work primarily out of the Fort Lauderdale, Florida office. Now Hollywood, Florida, I should say.
And what does Speckin Forensics do?
We're a full-service forensic firm. We deal with all aspects of forensic science. We deal with computer data recovery, crime scene crime scene reconstruction,
DUI? Blood?
firearms and tool mark, fingerprints, DNA,
Blood?
toxicology.
Toxicology?
But the section that I deal with is documents and inks.
Mr. Speckin, you need some water. You coughed.
Have it ready. Thank you, Your Honor. And they have extra lined up for me, I think, too.
You're set.
All right, this should be good stuff. This is
Do you
this guy's
also
highly
work in the field
qualified.
of handwriting analysis?
Yes, so under documents and inks, there are two schools of thought. There's a document analyst that looks at just the document aspect, and then there's handwriting. I do both, and in the United States, nearly everyone that does documents also does handwriting. In some countries, they differentiate the two. But under document examination, under that title, it would be document examination and handwriting would be part of that.
And is signature verification subsumed within handwriting analysis?
That would be another way to say it, or an application thereof from handwriting examination for determination of authorship. That's the way I would say it. But signature verification is saying the same thing, in my opinion. It's just not a phrase that I normally use. I would say determination of authorship, but it's the same thing.
And can you give me a more detailed description of your job that you perform at Speckin Forensics?
So my primary functions as it relates to work or documents and inks. I mean, I have administrative functions as well, but nobody's probably interested in those today. So I deal with the examination of documents and inks. So in the examination of documents, I examine documents for alterations, additions, and rewritings. Has a document been altered, changed, added to after the fact, and also perhaps when it was done. The
Interesting.
examination of photocopiers, facsimiles, printers for determination of origin, date, time, associations. The larger part, especially now because we've had a death of one of our partners, is handwriting. I've been doing handwriting now for 30 years, a little over. And that is the determination of handwriting and hand printing. Of course, included in that is signatures for determination of authorship. Did someone write something or not? And the certainty to which you can express that conclusion. And that's what I deal with on a large scale. It seems like if you ask my wife every day, but 6 days a week, probably.
And so I believe you testified that you have worked at Speckin Forensics for the approximately past 30 years.
Yes, I started in March of 1993, and now we're May of 2023, so 30 years and 3 months.
How many employees are at Speckin Forensics currently?
Between full and part-time, you would say?
Yes.
Well, instead of testing my memory to count every one, I'd say roughly a dozen.
Okay.
I could take a lot of time and give you an exact answer, but if that's good enough for you, roughly a dozen.
Can you describe the education and training that you have in the areas of expertise you just described with respect to document analysis, handwriting analysis?
Yes, I have a degree in chemistry. It's a Bachelor of Arts from the College of Natural Science from Michigan State University. That's my educational background. My training, I had a 2-year training program with Erich Speckin. That's my father. My training, I had a 2-year training program with Erich Speckin. That's my father. It was in the examination of documents and signatures. He's the retired chief document examiner for the Michigan State Police. He retired in December of 1989. He trained me from 1993 to 1995 in the examination of documents and handwriting for determination of authorship as it relates to handwriting. I then had a 1-year training program with Richard Brunel. He's the retired deputy director of the ATF National Laboratory. He trained me from 1995 to 1996. That primarily focused on inks and papers, who manufactured the ink, when it came out, how long it's been on the paper, and are 2 inks the same or different? That's the primary fast answer to what that was. And that was from 95 to 96.
Do you hold any licenses related to offering expert opinions on handwriting analysis?
No, there's not a license per se that's granted by a state or local body. I am a licensed private investigator in the state of Michigan, which is required under laws of some states. I don't think Arizona is one of them, but I don't know for sure. But you have to be a licensed private investigator.
Gosh, all right, that was brutal. Sorry about that, everybody. Holy moly.
Computer data. I maintain that license in an abundance of caution.
All right, sorry about that, everybody. We're back. Sorry about that. We're back. All right, yikes. All right. I didn't realize it was going to be blowing everybody's eardrums out of there. But hello, we're back. And hopefully you got to refresh your beverages. We're refreshed over here. Relieve yourself, stretch out a little bit, do some jumping jacks, some calisthenics. Let's see where we're at with court. And here's what we've got back in session. Wrecked everybody's nap. We're back. We've got trial. Wake your butts up. We got to get to business. Get back in here. All right. So we're making sure you're coming back. Good to see everybody. All right. Sorry about the we're not under attack. The Russians are not invading, or the Chinese or everybody else. Good to see everybody. Come on back here. All right. So we are still waiting for the court to get back in session, and we can see they're still moving around. Let's make sure our volume's nice and loud over here. Good. And we should be coming back about any minute. And while we're waiting, let's say hello to everybody who is out there. I saw some very nice super chats come in. Very much appreciated. Vienticus. Thank you, V. Too funny. Okay. Who do we have in the house on this lovely, lovely day? Oh, court's coming back. Here we go. Good timing. They are booting us back up. As they make their way back into the courtroom. And we have our expert, and this is going to be Kari Lake's expert. And we just heard from him, ton of background. He's experienced all over the place. And while he was testifying, I actually pulled up his webpage, and we went through some of the court documents. And those documents, he's worked on cases like Exxon, Disney, banks, other major cases. So he's obviously qualified. And now we're going to be curious to see what his conclusions are about 2022. Should be good. Yeah, everybody thought the house was on fire. No, it's not on fire. Only Arizona's on fire. Yeah. It's just our state. It's not your house. It's just the state of Arizona. So if you're in Arizona, yeah, your house might be on fire. Yeah. If you're anywhere in our state, yeah. Well, we are getting close, waiting for the judge to take the bench. Let's say thank you to some of these super chats. Blasco's here. What's up, Blasco? Says, love you, Robert. Longtime watcher, first time caller. Thank you, Blasco, for being here. Love you back, brother. Thank you for the super chat, my friend. Very much appreciated. We also have Dark Side Digital. Says, glad to have this to keep my mind off things as I'm driving 4 hours to see my dad, who just went to the ICU in North Chicago, VA. So, my friends, if you are the praying kind and the good energy sending kind, and I know many of you are, send some out there to Dark Side Digital's father. Gone into the ICU, and he's on his way out to visit. 4 hours. We're praying for you, Dark Side.
Well,
all right.
We are
Please be seated.
continuing on the record in CV
Drive safely, Dark Side.
2022-09-5403 Lake.
Prayers to Dark Side's dad.
Present for the record are party representatives and or parties, all respective counsel, and with Mr. Speckin on the stand with direct examination in progress, and we will continue without Mr. Olson.
Thank you, Your Honor.
See you when you're ready.
Thank you, Your Honor.
We're back. Kari Lake's
Mr.
expert
Speckin,
witness.
Before we took a break, you testified that you were involved in cases involving a review of mass signatures, some election type matters, mass tort cases, and the like. Do you recall that?
I do.
And typically, how would the review of mass signatures be conducted?
So if possible, my preferred method would be to have someone in my office that's at a lesser hourly rate, prepare graphics that would have the signature at issue. It's what I call the question signature. But the signature that's at issue at the top, a dark, or if there's more than one, the 2 or 3 at the top, a dark black line, and then the known signatures below with the dates, so that I can compare the relative time and know when they were from, on consecutive slides. So if I'm at my computer and I have my monitor, a slide would come up on the screen, and I would have the question signatures at the top, known signatures at the bottom, and I would do my comparison from there. Then I could click to the next slide and do my comparison from there. And that's how I would go through it. Similar to what I've seen that MAricopa has. It's not exactly the same, but it's substantially similar. Setting forth the question and the knowns to compare.
How long would that take? We
If
can't wait
it's
to
a
get
very
there.
large scale for limited purposes, I would try to have someone in my office with some training on handwriting. I don't know what the word would be. Triage or initially review to determine, are there a lot of signatures that have problems? Which ones are they, and so on. But I wouldn't remove any of the slides from what I see, but I would have notes on which ones they saw. That is in a perfect world. That doesn't always, the last step doesn't always happen.
And when you say typically, you would maybe have some individuals from your office perform the first cut. Would that be a fair way to characterize it when you say triage?
Yes.
And would you train those individuals in what to look for in terms of signature verification?
Well, they would have already been trained. So it'd be someone who's maybe a lower level exam, hasn't been doing it as long as me, but has undergone the training or has had a year or two of the training. That's an advantage that we have at our disposal in my office that other people don't, but clearly they've had training, yes.
And speaking of training, did you hear the name of Kathleen Nicolaitis?
I heard it in the question and the response from Mr. Valenzuela, and I've seen it in some of the other materials. I know who that is.
And who is Kathleen Nicolaitis?
She's an examiner, forensic document examiner or analyst here in, I think, Phoenix, but definitely in the Phoenix area. She was trained by a guy named William Flynn. He's like my dad's age. I've known him since I was a kid. And she trained, I think she's a little bit younger than me as far as I know, but I don't know a ton other than her professional background.
Is it your understanding that Ms. Nicolaitis has offered training at the employment of Maricopa County for signature verification workers?
Yes, it's my understanding from one of the witnesses that testified yesterday, Mr. Valenzuela today, and I think she cites that in her own professional bio in cases that I've seen that she has done such in her CV.
Would you consider her a colleague or in the same field that you are offering testimony in?
She's definitely in the same field and attends the same types of meetings. Maybe we've not been to the exact same one at the same time, but the organizations that I talked about, she would attend those meetings and she would go to the same kind of workshops I talked about and things like that, yes.
And you mentioned that you know her supervisor, is that right?
I don't know if supervisor is the right term now. She's been doing it for quite a while, but the one who trained her, I know Bill Flynn, yes.
How do you know him?
Well, I first met him, I think, when I was a kid, before I even got in the examination at a meeting with my dad. But as I got in the field, I would talk to him at meetings. He's a nice guy.
Who is Mr. Flynn?
I believe he retired from Philadelphia Police Department as a forensic document analyst. He's probably, well, I'll just say roughly the same age as my dad. I wouldn't want to offend him, but he's been around. He's a contemporary of my father.
Objection, Your Honor. This line of questioning relevance.
This is Kathleen Nicolaitis.
We done with that, or?
I think we're done with it anyway, Your Honor, but it's just establishing his background and particular relationship to similar experts at Maricopa. That's fine.
We're moving on, that's fine.
Mr. Speckin, are you familiar with the issues in this case as they relate to the review of signatures, voter signatures, by Maricopa signature verification workers?
Yes, I believe I've heard several days of it. and specifically the testimony yesterday and today, I have a pretty good, at least working knowledge of it, yes.
And what is your understanding of the variables at issue in this case?
My understanding is to determine if it was physically possible to review and compare, as it is in the statute, to compare samples to one another to determine if they are consistent or inconsistent. And then, of course, there's a disposition as to what to do, but I don't have an opinion on that part of it once it's disposed of.
Hold on. Objection, Your Honor, relevance. This goes to Reyes. Again, Judge, we've heard foundation, I believe, for the experts, I'll say background, okay, Your Honor. But may I continue to speak? I don't want to presume I can. Thank you. And Your Honor, we've heard him talk about how he analyzes signatures, and he has to have access to signatures to look at the signatures to analyze them, how he would do it. First off, that's a process. Second, he doesn't have access to any of these signatures. Third, he can't testify about the process. Nobody gets to take issue with the process today. The question is, was it followed? And we cannot have an expert here today testify beyond that issue. And it sounds like they're going into something that's completely inappropriate for this trial.
Okay. Thank you for clarifying the objection, because there is a crossover here, and let me make it clear so we don't have this popping up and down through the entire spectrum of testimony provided by Mr. Speckin. The nature of the presentation by plaintiff, as I understand it, is going back to the system being overwhelmed and not performing the inspection at all. This is not a revisit of how well it was done. It's basically the position that plaintiff's position is that it's not physically possible to perform even the rudimentary analysis. And so as a matter of pleading and evidence, I've allowed them to present the evidence that they have on that. I understand, and I will acknowledge that during the course of any of the testimony, as there has been up to this point, there's going to be crossover where people are going to be talking about ideal situations or would have been, could have been, should have been. Okay? That's not the nature of the trial. The nature of the trial that is before me is whether or not it's physically possible to do any inspection as part of the proof. Understanding I have been here for the entire trial and I have listened to all this. He testified it's several days. It might have felt like several days, but we've only actually been here a day and almost a half.
That's right, Your Honor. Just for purpose of clarification then, Judge, it would be cumulative, and here's why. We had an entire day of testimony from their witnesses testifying it actually happened. So again, he's going to process.
To make the argument that the process was so bad that it invalidated the whole
Truly,
thing.
I do. Okay. But I've already made the ruling. I addressed this mostly in the motions before trial, and it's not possible to completely clarify everything. So I'm taking the time right now to say I'm inclined to know, let him testify with regard to these matters, knowing that there will be some washover, if you want to call it that goes to process. However, this is a bench trial, okay? And I tried to make that clear in my ruling before trial and related to excluding witnesses wholesale, in that I believe that I'm capable of sifting through that and discerning where the line is being crossed, okay? Now, if we get too far afield, I have absolute faith that you will step up and point that out to me, okay? So,
Thank you, Judge.
This is a long speaking ruling on an objection that you're not used to, because I have long speaking objections, but I have allowed and even encouraged, okay? Mr. Olson, is there anything to add? Did I get it?
Yes, Your Honor. I think you've calculated.
Oh, and by the way, what happened yesterday in terms of my willingness to accept any defendant's objection as being joined by all the rest of the defendants holds true today and throughout the rest of the trial. Okay?
Your Honor. You know, we don't feel good unless we're talking.
I'm the opposite. Mr. Olson, please proceed.
No, I'm going to re-ask the question because I'm not sure if he answered it.
Thank you.
Mr. Speckin, what is your understanding of the variables at issue in this case with respect to signature verification as performed by MAricopa County employees in elections?
So to be more specific, there's a statute that I was provided, and it's 16-550, I believe is the number, that says what is to happen under law with early voting ballots. And it says they shall be compared. So my understanding is, were they compared? Could they be physically compared under the definition of compared in the time that the data shows that they were compared?
The county recorder and other officer in charge shall compare the signatures with the signature of the elector on the elector's registration record. Shall be done. If it's not done,
Is there
then it's not
an issue
in compliance with the law.
with respect to something that's been called as an FBI black box case that is relevant to any opinion you might offer here?
I don't know that it's relevant to the opinion. It's relevant that I've been involved, and it would be part of my training and experience. So it would naturally factor into my opinion, but there's not a direct correlation of study says A and therefore B. But I have a knowledge, and it's part of my knowledge base.
Objection, relevance.
Well, I think you asked the question and I got the answer. Thank you.
Thank you, Your Honor. Have you published any papers on the subject of handwriting and document examination?
Yes, I've published and presented papers, including a chapter in an encyclopedia on the subject. I've presented papers at meetings. I've presented as part of workshops to various organizations, primarily not on doing the examination, but on expressing terminology and conclusions, perhaps more directly. But the chapter in the encyclopedia is on doing the work and how to detect it.
And Mr. Speckin, have you reviewed any data provided by MAricopa County with respect to time-stamped log data on the performance of signature verification workers in the 2022 general election?
Yes.
And are you prepared to testify about your conclusions and analysis drawn from that data?
Yes.
Does that data directly relate to the ability of a signature verifier to compare a signature on a ballot envelope with the record signature of the voter?
Yes, based on the time that's spent, or the average time, or however you want to phrase that, as to whether that can physically be done. If there's a limitation that you could actually compare, which is to look at two or more things to see similarities and differences. That's what compare is. If that could be done at the speed at which the data shows it was done.
And what you're talking about is to compare signatures.
To compare signatures, because that's what is, the question is whether that's what's being compared. One set being the one at issue on the ballot envelope, the other being one or more known signatures from some historical retrieval process.
And is it your understanding that the comparison, as that word is defined and used in ARS 16550, that the determination is whether or not the signature is consistent too?
Yes, if you read the statute, the next sentence says, if it's inconsistent, this is what you do. So clearly the selection process is consistent or inconsistent. Based on that, it's either A or B. And that's what the level 1 users have for inputs. It's A or B. They have 2.
And at this time, plaintiffs move to admit Mr. Speckin, an expert, to testify on the ability of MAricopa's signature verification workers.
Okay, Arizona doesn't do that.
Apologies.
It's okay. I know some jurisdictions do. Arizona just requires that you have education, knowledge, training, or experience under Rule 702 to opine on a certain matter. The rest of it goes to foundation. I'm jumping over Dalbert, gentlemen. But the rest of it goes to foundation for each question.
Daubert's
So-
a case about qualifying experts.
For the record only, Your Honor, and because the question was asked, we would object just to preserve the record. But I understand the court. Thank
And I
you.
understand, and that's preserved for all defendants. So there won't be, I just told you, we don't do that. You just ask your questions, and then if they have an objection on foundation, they can raise it. But let's proceed.
In other words, he's an expert. You can go ahead.
No further questions with this witness at the time, Your Honor.
May I, Your Honor?
No further
You may.
questions?
Thank you.
What? We didn't talk about timing. We didn't talk about most things in his report, did we?
Ask if we can have just a few minutes before you begin. Ask if we can have a few minutes.
Oh my gosh.
Your Honor, can we have 5 minutes, please? Oh. Quick recess, just to assess how much of a cross-examination we may or may not need to do. I'm willing to cede the 6 to 10 minutes that we'll take of our time.
If 5 minutes is going to save me 30,
Correct. Could. It
it could. Then I'm willing to give you the 5 minutes.
Thank you, Judge.
We will recess for 5 minutes.
Okay. All right. So what we're going to do here is we're going to pull up Kari Lake's request. I'm not real sure what just happened there. I can't believe we're done with this expert already. I'm not real sure why we're done. Like we're done? What? No further questions for him? What? Okay, so I'm going to pull up Kari Lake's I'm trying to find the document. I'm a little bit flustered right now. I'm not real sure what they did that for. Here is the motion. Like, I can't believe we're done with this witness. We had like over an hour of foundation. We had the whole first morning session was foundation, and we didn't get any questions. I'm actually, I don't even know what just happened there. Okay, because this is what they submitted previously. This is what I thought the argument was going to be. This is why they brought in Erich Speckin. This was part of Kari Lake's filing, and we've already talked about a lot of this. But remember this section, there was the claim for new evidence, so we can forget that. But we had a whole section. I wonder if this is the motion. It may not be. It may not be. We didn't ask about timing. We didn't ask about, he didn't even go into the signature. Did we even talk about signatures? Like, did he say? Did I miss it, my friends? Am I just totally gone on this? Anyways, maybe during the break he said at this time. Okay, well, we're just going to hang tight here. I'm going to continue to look for this document. I can't believe we're done with that expert. I'm trying to find this filing. And this was the older one. Let me share what I'm looking up with you guys. So, very strange ordeal. I can't believe we just finished with that already. All right, this is what we were trying to dig into. And Kari Lake, this was the motion for the relief. No, that is the other one. Even Kari Lake's expert disclosure, this was what she said he was going to come in and talk about. Erich Speckin, this was his testimony today, supposed to be. He's going to offer area in the area of signature verification processes and a time study analysis. Did we hear that at all? No, we didn't. This was his credentials. We spent a lot of time on that. Here we have a little bit more. Speckin has discussed a number of issues. He's reviewed the sworn declarations of 3 level 1 whistleblowers, Nystrom, Onakit, and Myers. He also interviewed persons who've undergone Maricopa County signature verification training, and he has considered the following materials informing his opinions. But what were his opinions? So here's what he was supposed to talk about. Mr. Speckin will opine that accepting instances where there is an individual mark, X line or example, said the comparison of a signature set of known signatures up to 3 known signatures in level 1 and up to 6 in level 2 should not take less than 30 seconds. He's also, did we hear that? Did we hear him talk about that whole summary? Did I miss it? Like honestly, did I miss it? Did I zone out or something? Mr. Speckin will opine that this time can increase with factors detailed, as well as the simple point that a level 2 reviewer would generally have a more difficult time making an association on signatures than had already been rejected. So the timing, remember we had 70,000 ballots that were processed in 60 seconds or less. We had another batch that was processed in 2 seconds or less. We had another batch that was processed in 3 seconds or less. He was going to talk about all of those things, I thought. He's going to talk about the factors that may need to be accessed assessed
enough time to
before the comparison would be known. He's then going to testify that a comparison is made of formative habits. He's going to discuss control. Here, he's going to opine. His conclusion is based on 1.3 million early ballots reviewed in the election. They rejected.
We are continuing back on the record in
25%.
CV 2022-09-5403 Lake versus Hobbs et al. And present for the record are either party representatives, or their appearance being waived, and counsel for all parties. Mr. Olson.
Yes, Your Honor. I just want to make it clear, I was not resting our case or dismissing this witness from our standpoint. When I originally offered him as an expert, and Your Honor admonished that that's not the way it's done here, I was merely saying that I was done, had no further questions at this time. And then I was going to allow, that was to let the other side know that I had nothing further at this time. I believe that counsel may be arguing that we did not intend to call this witness for any further questioning. And so I just want to make it clear, we're not done with questioning this witness on his substantive opinions. That's all.
Well, wait a minute. I need to understand something. If you tell me that you have no further questions on direct,
You're done.
if they have no questions on cross, there's no redirect.
You're done.
And then you'd rest your case. You don't have any other witnesses, correct?
Well, but that was not my intention, Your Honor.
He
It
said
was-
no further questions.
Wait. I'm not going to parse words. Hold on a second. Explain to me, Mr. Olson.
Yes, Your Honor. All I was saying is that we were done at this time because counsel was jumping up to question just as he did. I just wanted to let him know that we were not done with, we were done with the initial presentation to allow them to voir dire the witness.
Oh, wait a minute. Okay.
If I may, Your Honor, and I
Oh, one lawyer per person, but with all due respect, Mr. Blum, here's what I'm getting to. If you're telling me that you are done laying foundation for his qualifications to render opinions, then I would expect that you'd proceed right into his opinions in the case. Because when you tell me I have no further questions, that means I'm done with direct.
Right.
Then it's their decision as to whether or not they cross. If they don't cross, there's no redirect, so the witness is done. And the only other way he comes back to testify is if they put on a rebuttal case. If they elect not to put on rebuttal, he doesn't come back because there's nothing to rebut if they don't put on anything further. So I'm not trying to lay anybody's strategy out here and flay it open, but I also don't want some type of high-level chess going on with somebody claiming later on the rug got pulled out from underneath them. So either if you have questions of him that relate to this case and you can put them on at this time, you have to put them on. Rebuttal is saved for things that you didn't anticipate but were raised by the other side in their case, and then move on. I feel like I'm teaching a seminar up here.
Yeah, this is bad.
So have you?
I do have further questions for this witness.
Your Honor, I object. You are teaching a seminar.
Yeah.
It's not my fault they don't understand basic procedure. He rested.
No, he didn't rest. He said, I have no further questions
yeah.
for the witness.
Here, I'm using a term of art. My
Yeah, that's right.
apologies.
The judge
stopped-
can bring it.
He ceded the witness to me.
Right.
I would,
It's now my turn to cross or not cross, and then we proceed from that. That's how we do this, Your Honor.
I would ask the court's indulgence. Given everything that has gone on,
Things
clearly was not done with the.
What happens is this, and you, Mr. Morgan, I understand your position, but you're also very familiar with a request to reopen that somebody makes. You haven't spent your cross-examination and then, put yourself in a position where I'm re-allowing this. At this particular time,
Allow him to reopen it. Cross hasn't started. Cross hasn't started yet.
it would be a hyper application of procedure over substance to have that happen.
I understand the court's position.
Because he's going to, I understand you do. I understand you do. And what I'm trying to do too is to protect the record, because I don't want an argument later that a request to reopen should have been granted. And I'm not coming back to be blunt with you, 7 months from now to find out somebody took a different view than me.
I understand.
Yeah, we're
Completely.
here. Let's hear
I
it.
do.
Now that we've
Preserve your
addressed the
objection.
800-pound gorilla in the room. Okay?
Your Honor, before you rule, I understand what Your Honor is about to rule, but may I make my record real quickly?
You absolutely may.
Thank you, Your Honor. For the county, I join the Secretary of State's objection, and I add that under our rules of civil procedure, an attorney admitted pro hoc vici is expected to understand our procedure and understand our rules. And I disagree with Your Honor's ruling. I respect it, but I disagree with Your Honor's ruling that he is making. Thank you, Your Honor.
Thank you, Mr. LaRue.
It's the right
Thank you, Your
ruling,
Honor.
but
Just so the record reflects, the governor also
he didn't
joined
have
this
to do that.
objection and would request that no further questions be asked.
Right. I'm going to take it that every one of the defendants joins in what Mr. LaRue just told me. If I'm mistaken in that, stand up and tell me. Otherwise, you're joining with Mr. LaRue. I don't hear anybody telling me opposite. Okay. Thank you.
May I approach and retrieve my exhibits?
Yes.
Thank you.
Man,
Thank you, Your Honor. Mr. Speckin.
wow.
Is there a difference in verifying an individual signature to determine if they are consistent versus verifying signatures on a large scale to determine if the signatures are consistent, such as occurred in the 2022 general election?
Yes, there's typically a difference, number one, in application. So for instance, if you had just one signature, the consequences of that decision could be extraordinary if it is a genuine signature or not. When you have 1.3 million, each individual one, of course, has less consequences. And I'm not discounting the argument yesterday of how important it is for your right to vote. I value mine like everyone else does. I'm not saying that. I'm saying in a mass, it's not as big a deal. Number two, the time to set up. And number three, the tools and technology and staff at your disposal to set these up, such as we heard about the process of how they're scanned and how other records are located that are similar, how they're inputted on the screen with user interface and so on. That's not something you would do if you just had one signature at issue. It wouldn't make sense. So of course there's differences, yes.
Are there differences in the way two signatures would be compared, whether it's an individual one or on a large scale?
I don't think there would be a substantive difference in the way it's done. The level of detail and amount of time would go proportionately down typically with the number of signatures at issue, depending on the task and the consequences and the layout of the individual matter. But in a sense, what you would look for, like the broad and local characteristics that were discussed yesterday, those don't change. That's how a comparison is done. You're looking for similarities and differences. That's what it means to compare. I'm looking to see if two things are the same or different.
And are you familiar with the system by which MAricopa employs to verify signatures at the level 1 signature verification worker status?
My familiarity as far as what a level 1 worker would see, do, be presented with, I would say I'm very familiar. As familiar as you can be without sitting in front of the terminal. As far as like how was scanned in to get to them and who did it and where it came from, I heard the talk yesterday, but I wouldn't say that I totally understood that. In general terms, I do, but I don't know the players like everyone else in the room probably does.
What did you do to familiarize yourself with how signature verification is being performed in MAricopa, and specifically in the 2022 general election?
Specific to 2022, I talked to people that were, number one, trained in their process. I investigated who did the training, and it was someone that I was aware of.
Who's that?
Kathleen Nicolaides that we talked, and I may be pronouncing her last name wrong because it's not intentional. I don't know her to that level, if I am. I talked to people that did level 1 signature review, including 2 of the witnesses that we heard from yesterday. I heard Mr. Valenzuela at length discuss the process of where it comes from, how it's done. I've seen the video of people doing it. I've seen other videos of people doing it as well. It wasn't just the clip that we saw in court. I've seen, I don't know, maybe hours of different videos of people doing this process, screens flashing, things like that. And of course, my own knowledge of how comparisons are done, consistent with what their training was.
Did you review any of the training materials that had been provided by Maricopa County to signature verification workers?
Yes, I believe there was one provided by Jackie Onakite, I think is how you say it, or Jacqueline.
She was the first
And
witness that we heard from in this
there was
trial.
another one attached to some discovery at some point. I don't remember whose declaration it was about training procedures. I've reviewed the EPM procedures of Maricopa County, and I've reviewed the training materials of the Secretary of State that have been discussed. It's a low numbered exhibit, I think was 1 or 2.
Have you operated the signature verification system employed by Maricopa County?
No,
Does that affect the opinions you would give today?
I don't think so, no.
Why not?
Because the inputs of what you're going to do, how you're going to do it, and the basis of what I already know is sufficient to draw the opinions that I did. If someone were to ask me what keystroke does what function, of course I don't know that. But that doesn't factor into the opinions that I have.
Your Honor, objection, again, performance is not an issue. It's whether they perform the analysis at all. Object on relevance ground.
I'm going to take that as a continuing objection to all this line of questioning for this witness, joined by every one of the defendants.
Thank you, Your Honor.
Thank you, Your Honor.
You, Mr. Olson.
And informing your opinions, did you review data provided by Maricopa County that is listed in or contained in Plaintiff's Exhibit 20?
I don't have the exhibit number positively to memory, but if that's the CD-ROM that had the data related to a public records request that was admitted, then yes, that's what I reviewed.
And can you describe what you did in assessing that data?
The first was to assess the amount of time that each keystroke, well, no, I should back up. The first thing I did is look at the email chain describing what the data was, what was requested, and what was provided. So I looked at the chatter, if you will, the exchanges between the two ends of the terminal in providing that data by link that we're talking about. After that, I looked at the data to determine how it could be distorted and what could be interpreted from that. The main piece, the two main pieces, would be percentage. In other words, the percent of pass piece. The two main pieces would be percentage. In other words, the percent of pass or fail, or what we've called, I think, good signature or exception. I prefer not to use the word exception today, not because it's not a good word in the English language or doesn't fit the bill, but because it sounds too close to accept. And when someone's taking it down or hearing it, they might mistake it, and I don't want to be misinterpreted in what I say. So for purposes of this, if I just say pass or fail at level 1, I think we all know what I mean, I hope. But the exception is something that's, I've had problems when people talk to me with that word. And then calculate the time between each of the successive keystrokes to figure out how long each of these data entries is taking to make the next one. In other words, from the time you draw a conclusion on one set of signatures in front of you to how long you draw the conclusion on the next is what the data is allowing to be determined. So the very first one, when you log in, we don't have a data point for that one because there wasn't something before that showing a decision was made in the
It's a
data.
log of all the
You just
all
have
the
the first one,
rows.
then
Ballot
every
comes in
subsequent
this
one
time. Ballot
of
comes in this
determination
time.
to
Ballot
them.
comes in this time. How much time elapsed between the ballots coming in?
Did that, are you familiar with the video that was entered as Exhibit 19 of the gentleman performing signature verification work?
Rapid fire speed.
Absolutely. I was here
Clicky
all day
Steve.
yesterday and I've seen it before that as well.
Clicky. Like you hit that
Is
like
that
button like you work for Maricopa County.
Activity represented in the data that you reviewed, that is Exhibit 20?
Objection, Your Honor, vague.
Okay, if you've understood the question, you can answer it, Mr. Speckin. If you don't need clarification, I'll have it rephrased. If you don't understand it, tell me, don't guess. Ask for it to be rephrased. If you're able to answer it, sir, you can answer. If not, I'll have the question rephrased for you.
The answer would be yes, in two parts. So it's there on the whole of what that data looks like with repeated speed, and also for that user at specific points in time. So the answer to the question is yes in two different parts. The trend of what the data looks like for someone clicking quickly like that. And then secondly, the data is present for that user at those timeframes as best I can tell. Keeping in mind the computer clock may not be synced to the second with the video feed clock, but it's close so you can determine who it is.
Yeah, so every time he clicked one of these
Can you
submissions,
describe further what you did to
enters a log.
analyze
Boom.
the data
Boom.
provided by
Boom.
Maricopa County?
Boom. He's
That
just
is
looking
Exhibit
at the
20.
logs
Well,
of
once
this.
those fields are created, so the data fields that were already given, voter ID, user, date and time, stamp, and disposition are created. And then the additional field that I just talked about with the amount of time between keystrokes is created. Then you can query through Microsoft Access or similar databases, that data to look for what you would want to look for. In other words, you can filter by a certain user, you can filter by a certain day, you can filter by a certain speed, you can filter by all the users at a specific time. You could filter by any sort of if-then statements. If this, then provide it, or if not this, then provide it. And you can use greater than, less than, equal to, greater than or equal to, less than or equal to any of the numbers that we talked about. So for instance, you could say less than or equal to 5 seconds, or less than or equal to 2 seconds between keystrokes, or greater than or equal to an hour if you wanted to see when someone took a break. Whatever the case may be, you can use the data through a database tool or database program like Access to query a myriad, many, perhaps even close to an unlimited number of different reports or ideas that you would want to see.
Is this similar to
One second. Mr. Speckin, you have a tendency to speak fast.
I heard that before, Your Honor. I'll work on it today.
Well, for the sake of my court reporter who doesn't want carpal tunnel, just speak slower and it'll help the record.
I will do that. I'm sorry.
Is that similar to, for example, operating an Excel spreadsheet?
Yes, in that Access is typically used for data sets that are larger. So Excel doesn't necessarily have a cutoff that I'm aware of the number of data sets. But when you start getting into the thousands and thousands and over 100,000, it doesn't work as well, and Access is a better tool. But it's the similar queries.
Objection, Your Honor, this line of questioning and the question that was just asked. There's been no foundation whatsoever laid for this witness to be an expert in statistics, statistical analysis, or electronic databases.
Excel
I'll
or
ask the
Access?
court, to strike the testimony. we
Have you
just heard.
seen his credentials?
Okay.
Give me a break.
All right.
Or may I, before?
Yes, go ahead.
He doesn't have
There
Microsoft
is
Access on
no
his CV.
particular expertise required to operate an Excel spreadsheet, or it's no different than a secretary operating Microsoft Word. And I would like to lay the foundation for that.
All right. The response tells me that you're not offering him as a person to do statistical analysis.
It's spreadsheets.
And I think it's much like Mr. Valenzuela, who said, I can do a spreadsheet. I know what the data is when you present it to me in a report format.
They're objecting
He
to
does have some
spreadsheets.
expertise in terms of interpreting what that means. And I may have underestimated or understated Mr. Valenzuela's capabilities, but I believe I heard something similar. So to the extent that the witness is relying on
Katie
spreadsheet
Hobbs.
data,
Yeah.
he can
We
do
object to your
that subject to your
spreadsheets.
cross, but he's not being offered for an expert on statistical analysis per se. Correct, Mr.
Yes,
Olson?
Your Honor.
Then that's fine. Go ahead.
Thank you for the clarification, Judge.
Go ahead, proceed.
Are the tools that were employed to access the data on that had been produced by MAricopa standard off-the-shelf tools common usage, in your opinion?
Yes, Access is a Microsoft product. I assume you can buy it at Best Buy or buy it online from Microsoft. It's not, it used to be packaged as part of their Office suite. I don't know if it currently is. I think you can buy it as such. I'm not in charge of purchasing, so I can't tell you, but it's a very common software that Microsoft makes for this application. Absolutely.
Can you turn a computer
Did you
on,
work
Eric?
with anybody in?
We object, Your
accessing
Honor.
this
There's no
data?
evidence he knows how to
Yes, I
use
did.
Microsoft Windows.
I worked with Chris Hansel, the one who testified yesterday about the receipt of the data.
And what did you do with Mr. Hansel?
We worked together to run reports for things that I wanted to see. Typically, I would give him the inputs and say, I want to see the data for X user with less than this seconds, or all the users that had this type of activity, whatever the query was. And we used the wizard function, which is part of the commercially available Access, that creates the process by which Access searches, which in a sense is the for and X loop that's used, like basic programming is how it looks.
Your Honor, I'm going to object for the record. What I'm hearing is testimony about statistical analysis.
Keyboards.
I was just told by counsel he's not being offered to give any opinion on or testimony on statistical analysis. Yet here we are. I again move to strike.
Okay. I'm
We don't
going
even
to
know how much
explain
RAM
to you
he
when I
has.
use the term statistical analysis, I'm talking about the interpretation of the data. If they're talking about sorting data, I don't believe that's statistical analysis.
I agree.
And so therefore, what I'm hearing is the spreadsheet is being used as a program to respond to specific queries that the witness has posed to the person who's assisting him. Give me the data sorted for these criteria. If that's the way that the system functions, that's fine.
The spreadsheet
Applying
objection
statistical
Our
analysis to
third
that
spreadsheet objection.
goes beyond the scope. That's interpretation.
I'm so sorry. Yeah, no, I agree, Your Honor. I just want to make sure I'm on the same page too, because I did object. It's one thing to have and testify that you did so. It's another thing to testify that the end result you received, it's my opinion, they're correct. He's not a statistician. I think we've established that.
I don't follow the argument that there's not an opinion in front of me that's been
So
offered.
I agree. I felt like we were getting there, and that's why I stood up.
And that's fine. When I get to that point, if there's an application of statistical analysis, I expect that you'll object at that point. Right now, what I've got is data sorting by categories and reports being run. In other words, if he asked for a report that says, if it's in the database, everybody named John, he would get that input. Statistically, how that impacts his opinions, different matter. Okay. So at this point, that's as far as we are.
If it is sorting the data, that is one thing, but he testified that he is making inquiries or drafting queries to the Excel spreadsheet. That
We better get some conclusions. That's for sure.
I object to his testimony about whatever queries he's drafting.
All right.
On what basis?
I disagree with you. I would agree
Yeah.
that if the question were phrased that I used a program to generate statistical analysis of the data, I would agree with you. But right now, all I hear is data sorting.
And when we
We're
get
on
to
the
it,
same page. Thank you, Judge.
it should be pretty basic. This many completed in this amount of time, and
Mr. Speckin,
that's out of pocket with the other
the
mean output.
data that, right there. Can you describe again what you did with and working with Mr. Hansel to extract data?
So maybe it's easiest if I just give an example. So I would say, let me see all the keystrokes and determinations that were made less than 3 seconds from the time the last keystroke was made or determination was made. It would tell me all the times that they did it. From there, I can calculate which users did it, how many times the users did it, how many times that input was whatever the determination was, whether it was passed, failed, whatever it was. You can determine that from the answer that you get.
How many times
Is that
between the
data
clicks?
that's been extracted under those criteria just simply sorted by time?
Perhaps filtering is a better adjective than sorting. I'm not disagreeing with sorting, but I'd say filtering.
Is
Filter
there
is the
any
better word.
statistical analysis involved in your opinion?
The only statistical analysis is calculation of an average of a certain set of numbers, like what's the mean?
That's not,
That's
that's just
something
math.
I think you don't need to be a professional statistician to know you sum it up and divide it by how many you have.
Yeah, it's just math.
Um,
Not that I know how to
think
do
that's
it,
the only,
but I'm
and if
pretty
you
sure
count
it's
a
math.
percentage outcome of statistics, I wouldn't, but if someone wanted to be super technical, how many were this related to this? That's a simple division, but those would be the only rudimentary statistics, but we're not talking student t-test or standard deviations or anything like that. I'm not.
You're talking about calculating an average, which is what is done in 6th grade and requires no special expertise, correct?
Unless you work for the government.
Or even before 6th grade. I 100% agree. Yes.
Objection! Spreadsheets! Statistics! They're being very quiet right now. No objections on that one.
We had
Yeah, no
started.
spreadsheet objections over there.
talked how
Gosh,
we were
took 30
going
minutes to
have
get through
Exhibit
that.
47, which was the complete version of 18. Don't believe, I have everything here. I don't believe we haven't put anything in the record to submit it.
Well, it hasn't been marked yet?
Well, we have the blue sheets on it, and it has not been marked yet. But when we submitted, Your Honor, the exhibits, Exhibit 18, as I said, was every other page was not. So
All right.
I can use Exhibit 18 because it doesn't change anything.
No, we're not doing that. Unless, if you're going to admit 18 and you're not going to put in 46, you can do that. But I thought the whole purpose of marking the other exhibit was completeness.
Yes, Your Honor.
Don't even suggest that you want to use the half one then, because you don't get to duplicate. So if you're going to use 46 right now, if you're going to have it marked, I thought it was marked because I believe that I wanted the,
You did ask him to mark it this morning.
but that's fine. Hey, you haven't got it marked?
Hall monitor
I believe
alert.
it's 47, Your
You
Honor.
told him, Your Honor.
It's 47.
Yeah.
Thank you. And my clerk tells me that 47's been marked and she has it. That
Yes, Your
should be
Honor.
up here.
My apologies.
You don't have anything different in your hand, do you, than Exhibit 47? Wonderful. That's good news. So did you have questions about Exhibit 47 that you were going to ask?
Yes, Your Honor.
Okay.
As long as what we're doing is laying foundation, I'm okay with that. I can see how it progresses. I just didn't know what we were doing.
Thank you. Is that where we're at, Mr. Olson?
Yes, Your Honor.
Please then.
Pull up exhibit.
We get the video.
Well, first, you're going to talk about Exhibit 47. You're going into what it is. I was at the earlier objection that some of the states council had was that to the actual foundation, as in custodian of record, like this is the complete and accurate copy. Because the original exhibit number 18 was missing every other page because it was only copied halfway. As I recall, the objection that council had was this is late disclosed because we only had every other page. And so I had asked that the 47 be made available to them so that they could inspect it and look at it. And I understood that the argument you're going to have is that this is the data that came from them that's transposed onto the exhibits. So it's not something that's newly discovered, but it's supposed to be something that's marked and exchanged as an exhibit ahead of trial so that they know, everybody knows what the evidence may be, but what's actually going to be presented is a different thing. And so has the state had the chance to inspect Exhibit 47?
Your Honor, only in so much as that I've got a copy of it and I've looked at it. And what I'll tell the court is, one, it appears to be, again, statistical conclusions. And two, based on the testimony I just heard with respect to another exhibit, it appears that this may not have even been created by this witness. And we have foundational problems.
Okay.
Now we got a
Then
paperwork objection.
Maybe I'm
Spreadsheet,
working under a misunderstanding.
and now an exhibit paperwork
I
objection.
thought that Exhibit 47 represents nothing more than a physical printout in written format of the data that was provided by the county. If it's a product of analysis and a summary of the witness, then at this point in time, that makes sense that you're laying the foundation by talking to the witness about how the witness created it. Is this something created by this witness?
Yes, Your Honor.
Okay, now I understand. Okay. All right. So we're going to go through that with Mr. Olson laying the foundation. So now I understand it's not a custodian of record, it's he created it, meaning he knew the witness, and you're going to tell me the basis for it.
Yes, Your Honor.
Let's get started.
We're back.
You wanted to play a video, is that right?
No,
It is the exhibit.
we wanted to put the exhibit up on the screen.
Oh, fine. It's not a jury trial, it's a bench trial, so go ahead.
And Your Honor, may I approach the witness and give a hard copy?
You absolutely may, Mr. Olson.
Your Honor, while he's doing that, may I please move this television screen?
You may do so, absolutely, Mr. Morgan. In fact, if you want to,
This isn't in your way too. I don't want to get in your way. Oh, I know what I'll do. Look at that. So how's that work? Can you see? All right. Does this work? Thank you, Judge.
okay, now we're working on, just to be overkill here, we're working on Exhibit 47, right, everyone?
Yes, Your Honor. Mr. Speckin, do you recognize what has been marked for identification as Exhibit 47?
I do.
And what is this document?
This is a summary table of the data related to user number, how many total verifications they did over the period of time that was given for the data.
Spreadsheet.
The election cycle for the general is what was requested. The verification rate, so how many of the keystroke entries were to what I said earlier, just quite simply is pass or good signature related to the other keystrokes. And then as we move to the right, the speed at which those verifications or comparisons or determinations were done. So when we get to the first column, it says in less than or equal to 5 seconds. Just to clarify, that's an integer-based search. So it means if the integer...
Your Honor, I'm sorry for interrupting the witness, but he's testifying about what this document says. The foundation has not been laid, and we're still objecting on the basis of the foundation for this.
No,
But he's
come
beginning to
on.
offer testimony about what the document says.
He explained.
Okay. All right, I may have overlooked something. Let's go to how it was physically created, or who created it, if you would. I believe that's where you're coming from.
That's correct, Your Honor. Thank you.
Please.
Ah, gosh.
Can you describe how this document that's been marked for identification as Exhibit 47 was created?
Yes, it was created at my direction using several different queries in the Access tool to look at the column headings that are present there.
The
Of course, the worker
spreadsheet.
or the user number is a data field that was given.
Analysis
in the
on the
data.
spreadsheet.
The others are generated from the verifications or the keystrokes that they gave, the number of them. And I started saying what the other things are, but it was created at my direction to demonstrate the speed at which these comparisons were being made.
That good enough, dorks?
Your Honor, yeah, we still renew our objection here, Your Honor. This foundation is established merely that someone else created the document. And we have serious concerns with the underlying data that was used. We don't know where the data came from, who uploaded it, where'd they upload it?
He
How did they,
just told
what buttons
you.
did they push? How do they do it? I'm not trying to do.
We got
the
questions about
foundation
your
exam
buttons
for
there,
Mr.
buddy.
Olson, but at the end of the day, just to help ease things along, those are the issues with our objection.
Questions about you pushing buttons.
Or I should say those are the underpinnings of our objection.
Your Honor, I would like to add to this objection. Again, this witness is not a statistician. He is not qualified as such. He was not disclosed as a statistician. His disclosure
It's not.
says he will
It's not
respond to
statistics.
opinions.
It's
or
sixth
he
grade
will testify
algebra.
about signature verification process. He is someone put together a spreadsheet and now he's doing math and
His office
percentages
did.
based on numbers that we don't know where they came from. This is
If you don't
far
trust
beyond the scope
numbers,
of-
then I guess we shouldn't trust any Maricopa County's numbers.
I think
if-
I can
if
summarize
they
that
weren't
you're
directly
objecting to
prepared.
the foundation for who prepared it, how they prepared it, when they prepared it, gave it to him. Fortunately, I believe the answer to those questions is Mr. Hansel, who was in the courtroom until about 2 or a minute ago.
That was
in
yesterday's
terms of
witness.
exclusion of witnesses, but
Hansel
I
talked
think
about
that,
the receipt of the documents from his FOIA request. He got all the data from his Freedom of Information Act request.
But keep in mind, this is something that you're talking about the foundation of where the data came from.
Maricopa County.
If
You can cross-examine him if
the
you don't
data
trust
was,
it.
well,
Cross-examine him. You can hit all of that on cross. Challenge the data on
subject
cross.
to them calling the witness that actually created the document,
which would be his
we
office.
can take the testimony, but it's only as if it is only relevant and has zero weight unless you establish the foundation. Okay, this is doing it backwards. I agree.
Which he has.
But I think I'm capable of sifting that out.
He has.
So that if you want them to call the person who actually made the report and have that person testify about how it was created, then
totally unnecessary,
we can do it,
Your
or
Honor.
they can either, a plaintiff can do it or defendant can do it, either one. Okay.
Your Honor.
Totally
I
unnecessary.
appreciate Your Honor's opinion and perspective. For the county defendants, I want to again say on the record that we expect those who are admitted pro hoc vici, and we certainly
happened?
expect Arizona attorneys to understand the rules and how things are to be done. I also want to say that I understand that this is a bench trial, and I have the utmost confidence in Your Honor's ability to separate these things and make these distinctions. But I remind Your Honor that this is being live streamed, and there are many people across the county, perhaps across the state, perhaps across America watching it.
Across the world.
And they don't necessarily
across
make
the
those
world.
distinctions that Your Honor is capable of making. And it is prejudicial to our client, the county recorder, to have something shown and testified about that the foundation has not been laid for. We don't know what the underlying numbers are. We have no idea whether it was entered correctly. And this will become the story among the people who are watching this.
Well, it's your county.
Put your minds just a
It's your
at rest for
numbers.
a little bit. This really isn't as unusual as you're pointing out.
Yeah, you hysterical
For the
whiners.
reason that expert witnesses testify all the time in court, and exhibits are admitted without any more foundation than for the expert to say, yes, I relied on that. Yes, I relied on that. Yes, I relied on this.
All the time.
And then when it comes time for cross-examination,
But he
the
didn't
other
do the
side may
spreadsheet.
attack and say,
Cross, right, exactly.
this is a completely invalid piece of evidence that you considered in your report.
Judge
and
got it.
ask, doesn't that undermine your opinion if all your opinions are predicated on something that has no foundation?
Exactly. That's
So
what
it does happen all
cross-examination
the
is
time.
for. Happens all
But
the
I
time.
appreciate the need for foundation if
Which he's
it's
laid.
offered for the truth of the matter asserted. But again, and that happens in jury trials, not just bench trials. So evidence that experts rely upon that would not otherwise be admissible can be admitted for that limited purpose. And I appreciate the fact that there may be people who are on live stream
That's us. That's
who
us.
draw wrong conclusions.
No,
or
that's
don't
not us.
understand how the
No.
rules of evidence work, the rules of procedure work.
I think
All
we know
can
better
do
than they
here
do.
is follow the rules, and I can do my very, very best, which is what I've tried to do to make
No
it
better than these
that we
government.
follow the rules
these
and have a
guys,
fair
for sure.
proceeding. So even if there is no foundation,
Algebra,
this
statistical
witness can testify
objections.
that he relied on it, and I will also give you the opportunity, and I'm sure I will hear an able cross-examination on those issues.
Thank you, Your Honor.
There's all the witness to lay the foundation is up to the plaintiff, not this witness.
Yeah, on that issue, just again, so I didn't say anything about that. I will object to that if and when it does
The
occur.
what?
I would object to that if and when it does occur. I want to be clear. I'm not asking for anyone to call the witness a witness that's already testified after we invoke the rule
Right.
who's been in court. Different issue for later, but I just want to make sure we're clear. I didn't waive that.
You have not waived it,
Thank you.
and I have always taken the objections you're making now to the admission of the exhibit as a unique standalone exhibit.
Correct.
If they were, what I explained to you about experts relying upon it would be based on the attorney saying, I'm not offering it for the truth of the matter asserted, I'm offering it for proof of what my expert relied upon. Different animals, okay?
Thank you.
Thank you, Your Honor.
Good
With
Lord.
that,
Judge is laughing.
the look at the clock says it all.
The look at the clock says it all. He's right. It's 12 o'clock.
We've got,
We've been arguing about spreadsheets
Well, we've
and
got about
documents and
7
statistics
minutes.
for the last. Oh
I'm
my
just trying to
gosh.
make this thing move along, and
Thank you, Judge.
I want to use the 7 minutes, so go ahead and ask more questions, and
Ugh.
we'll end at noon. Okay. Are we on track to, where do you think we're going to be at the end of the day?
We'll be done with
I think
Speckin.
we may be done, Your Honor.
Yeah,
At
we'll be
least
done.
with witnesses.
Okay, now then, that's them. Then you have to decision to make about what you want to do. And that puts us pretty much on track for what I allocated. So thank you.
Valenzuela from the
Let's go
government
ahead,
on
Mr.
Friday
Olson.
morning. We
Keep
might be done by
asking your questions, if you will.
early tomorrow by maybe lunch.
Mr. Speckin, you testified earlier that this document was made at your direction. Did you actually participate in the creation of it yourself?
Yeah, it's that right there.
And how did you participate in the creation of this document?
I explained for this chart, or this table in particular, exactly what I wanted for each column and how to filter the data to get it.
And do you understand that this type of data is something that it's voluminous, correct?
The raw data of exhibit 19 or 20, what is?
Yeah.
It's huge. It's 1.4 million lines of text with 4 columns per piece. It's big.
And if somebody wanted to arrive at the same conclusions in terms of the interval between keystrokes, that's something that would be, you could do by hand. It would just maybe take years.
Objection,
Quick.
form, again, out of an abundance of caution, I think I'm hearing a request about mathematical certainties, calculations, and statistics, Judge.
I heard the question to be basically, if you perform the sort function that Excel spreadsheet did, it'd take you years. Is that what you
By
were
hand.
asking?
Yes, Your Honor.
If you did it by hand?
On foundation.
I don't know that he knows the answer to that, how long it would take, but
I'm laying the foundation. This has nothing to do with statistics. It's just extracting data. That's all.
I can take judicial notice of the fact that computers can do things faster than humans if y'all want to do that, but
We'll stipulate to that, Judge.
thanks.
Your Honor, the county definitely stipulates to that. Thank you.
Let's move on, please.
Yes, we agree. Computers are faster at calculating numbers. We agree, big time. Just call it, Judge. It's
Does
lunch. Let him
Exhibit
get some food.
47 appear to be a true
Just
and
call it.
accurate copy of
Let him get
chart
some
that was
caffeine.
created with your participation and at your direction regarding the data extracted from what has been entered into evidence as Exhibit 20?
Yes, other than I have a black and white version, but yes, I think a couple numbers might have been in color, but it's absolutely accurate. Yes.
I would like to move that this exhibit be entered into evidence.
For purposes of what your expert has reviewed or for purposes of admission outright?
For purposes of what our expert has reviewed.
Any objection?
No.
No. It's offered for that limited purpose and admitted for that limited purpose. Thank you.
Thank you, Your Honor.
Mr. Speckin, you were earlier testifying about the top columns headings where it says verification rate of 5 seconds. Excuse me, verifications in less than or equal to the integer of 5 seconds. Do you see that?
Yes.
Could you explain once again what those columns relate to?
Yes. So when the data was received, the time clock or the date time stamp was only resolved to the actual second in nearly all of the instances. A few had to the millisecond. I don't know how reliable that was, but nearly all of them was just to the second, which is reasonable. I'm not being critical. But that means if I say I did this event at X time, 12 o'clock, noon, 12 o'clock, 0 minutes and 0 seconds, and I did the next event when the clock is at noon, 0 minutes and 2 seconds, you can imagine that if I would have started it at the very beginning of the 0 and ended it right before it hit 3, that's 2.999 seconds. Or if I was at the end of the 0 seconds when I started it and the very beginning, it would be just over 1. So there's a range that can happen. What this means is the integer was 5 seconds or less between the subtraction. In common terms, and I'm sorry that this could be misleading, but in common terms, it means 6 seconds or less that we can say with certainty that the action was 6 seconds or less.
It actually means less than 6 seconds, correct? Because the integer goes up to 5.9999.
Depending on how the data resolves.
Again, objection. Leading.
Okay. Technically, it's leading. Yeah, technically, it's leading, but it's a rephrase of what he said. I think I understood the question and answer. Got another question?
Yes. Sir. Can you just go through the headings on this exhibit and explain what they mean?
Sure. So the easiest one is worker. That's what I heard was the term I think was anonymized user number. I'm assuming so they didn't have to give the names of the people, which I obviously understand. So each person was assigned an anonymous user number. Then for that user, what they did. So verifications overall. That means the number of times that they made a determination in some form or fashion about a ballot envelope. And then the percentage of those that are verified is the next column. So the number of times that either passed versus something else. Doesn't mean versus failed. It could be that it was a spousal exchange, or there's a lot of different codes that they use that it could be. It's just passed versus everything else.
What is a spousal exchange?
I'm sorry, Your Honor, objection. He is now testifying to the document as if it is true, and he is not testifying about his conclusions based on his reliance on the document. This is outside the scope of, first of all, this document is being used for purposes beyond which it is intended. Again, he is engaging in statistical analysis of this data, which is beyond the scope of the subjects on which he was disclosed, and it is extremely prejudicial to our client.
Okay, the first part, you're saying he's using the exhibit, interpreting the exhibit, or using it to offer his opinions. And it's the purpose for which it was admitted. The second objection is that he's making statistical analysis of
Back on statistics
what's going
again.
on. As far as what I'm hearing,
Somebody get that girl a calculator.
what I've heard so far is this is sorting of data with regard to keystrokes and differentiation between the time and keystrokes. And this is the data that was extracted into the very columns. And now he's reading that data that was requested, and now he's going to offer an opinion on it. So at this particular time, I don't see a statistical analysis component to it, but I'll wait and hear whatever further testimony there is. But
this is Matt, okay?
That's fine.
Go sit down.
Well, it's afternoon.
It's afternoon, the
So-
judge says.
I believe we're on track, so I won't make you come back early. We can come back at 1:30 to
1:30.
resume this. But we'll come back at 1:30 and resume again with Mr. Speckin on direct examination, okay? Thank you all.
All rise. Somebody else just let a big exhale too on the screen. Woo! Come on, Judge, we're standing here. All right, please be seated. All right, goodness. All right, wow. What a morning, my friends. What a morning indeed. They're going to boot us out of the courtroom. And so let's do a quick recap as they throw us out here. Yeah, what a day. All right, so it's been a little bit of a heck of a morning. I'll tell you, I got a little bit nervous there after that first morning session when we thought Kurt Olson was done with the expert witness, Erich Speckin. I about had a panic attack. You probably saw that here on the stream because I thought, like the court thought and like the defense thought, that he was done with that witness. And we needed a lot more to get to, including his conclusions, which we're starting to hear about now. But this has been a little extra painful today because we've had all these spreadsheet objections. We have a difference of opinion about algebra versus statistical analysis. And I know lawyers are pretty bad at math, yours truly included, but basic algebra is a little bit different than statistical analysis. But you know, they're going to be making the arguments that they have to make. They're, I think, doing a pretty good job of being extremely annoying to Kari Lake's team, which doesn't like the objections and which has kind of repeatedly gotten flustered in different lines of questioning, had to be helped along a bit with the judges, you know, kind of giving them some education about how things work here. And so it was a nervous, precarious morning. I was literally concerned that we were going to be done with Erich Speckin. I thought, that's it. We're done. I guess the afternoon's over. We came back. They took a break to prepare for cross-examination. They said, we need a break to prepare. They were probably shocked. They shouldn't have taken that break. They screwed that up big time. They should not have taken that break. They should have just said no questions, or they should have gone up there and asked one question. They should have asked one or two questions, and that would have started their cross-exam. And then the judge, I think, would have been in a worse position. I don't think he could have let them reopen the direct exam. So almost two screw-ups back to back there, two blunders. We had one where Olson almost lost his direct exam, and the defense, Katie Hobbs and their team, they should have just stood right up. Perfect. Oh, okay. So Mr. Speckin, so what you're saying is that you didn't do this thing, right? I asked him one question and said, no further questions, we're done. And that would have put the bookend. Then it would have been very hard for Olson to go back and say, I want to do, well, at that point, then he could have done a redirect, to be clear. But then he wouldn't have been able to go back into his, he wouldn't have been able to draw out all the conclusions because it would have been outside the scope, is what I would have argued if I was the defense. Or I would have just said, we have no cross-examination, Judge, we're done, thanks. And then that would have ended it. So, whew, man, I mean, it was like pins and needles there, you know. So fortunately, the judge, I think, did the right thing. It was the right call, an equitable interpretation of it. Yes, technically it was technically it was a mistake, but these things happen. I mean, there's a lot going on, and attorneys will, you know, you can get overwhelmed and you can misinterpret the judge and sit down and say, wait a minute. No, I'm not done. I'm done with the qualification part. Okay. And so fortunately for Kari Lake and for this trial, it has been fixed, and we're going to continue on with our friend on the stand, Mr. Erich Speckin, as he comes back here shortly enough. But we've had not a lot of testimony today, just Ray Valenzuela and then Erich Speckin, and that is going to be the end of it for the trial. And so we're going to take a quick break as well, my friends. I want to we'll do a quick break, and then we'll come back and we'll hit some super chats before the afternoon session, which is going to be at 1:30 Arizona time, so at about 90 minutes from now. So we're going to take a long break today, and then we'll come back a little bit early, and we'll jump back into the super chats, and we'll jump into the chat and say hello to everybody out there. But I want to queue up yesterday's proceedings. So I want to start, so, if you missed yesterday's show, and Kari Lake, I want to put that into the frame so we can get caught up with that. We'll have a timer. We'll come back in about just over an hour. So my friends, I hope you have a beautiful lunch. Get some exercise, get out there, get that blood pumping, get that blood moving. I'm going to put on opening arguments from yesterday, from day one, which was quite good. And then we'll let the trial go from yesterday, and we'll pick back up here in a few little bit, in some short time. There will be a timer, but I have the timer muted, so there shouldn't be any nuclear bomb alarms or fire alarms in the household. So I apologize for that. But my friends, have yourselves a beautiful lunch. We'll see you right back here in just over an hour. Make it an amazing meal. We'll see you soon. Let me get this queued up.
1-3. And you'll see, Your Honor, step 1, the signature's broad characteristics identifies 6 different characteristics of a signature. This is what signature verifiers are trained in. And then you can go down to step 2.
Have a great lunch, everybody.
These are the local characteristics. That's 5 local characteristics for a total of 11 characteristics that are to be evaluated to be considered a signature verification. Flashing up on a screen and moving to the next one without taking the steps necessary to verify is not signature verification under any measure. And at a rate of over less than 3 seconds to evaluate, that is not signature verification. Before all signature verifiers go through and begin on the election, they go through training that lasts a week, Your Honor. 5 days a week, 8 hours a day. It's actually quite good for the function that they are being tasked to perform. You will hear live testimony of 2 whistleblowers who, one, Jacqueline Onikit, who was a level 1 signature verification worker, and Andrew Myers, whose primary function was curing. Curing the ballot is after the signature has been rejected, then there is an attempt made, and this is per statute, to contact the voter to see if you can make sure that the signature is with who it's supposed to be. Both of these witnesses testified that the process that MAricopa set up for signature review, they had 24 workstations at level 1 review, 24. MAricopa had 3 level 2 reviewers. That's a ratio of just 1 level 2 reviewer to 8 level 1 signature reviewers. As the level 1 reviewers would reject signatures, it would be passed up to the level 2. You will hear testimony, Your Honor, sworn testimony, that the level 2 reviewers were so overwhelmed with rejected signatures that they would then have to check with even more resources than the level 1 had to see if they could determine that in fact it was the actual voter's signature, that they were so overwhelmed that they would not perform the level 2 review. They would simply kick back those rejected signatures back to the level 1. They wouldn't do it at all.
Beautiful.
And you will hear testimony that this was ordered by the managers at MTech. So that's the second part of this. First part, simply clicking through the computer screen like a woodpecker and moving on to the next ballot in less than 3 seconds. And secondly, the fact that the level 2 reviewers were so overwhelmed that they were kicking back rejected signatures that had been sent up to them without looking at them at all, kicking them back to level 1. That's not signature review.
Not signature review, which is the line he's got to adhere to.
As Mr. Myers will testify, he expected, based on what he was told to cure, that there would be 12 to 15,000 ballots for the curing function every day. He was told there's so many coming in, it's going to be a flood. He only saw 10% of that, which meant that on average, there were approximately 10,000 signatures for level 2 reviewers to cure. As he said, the math never added up. There is simply not enough time in the day to perform the signature review function. And again, the log data supports that. There's 70,000 ballots, Your Honor, signatures that were approved at a rate of less than 2 seconds. This is what MAricopa's own log data shows. You will also hear testimony today from Shelby Bush. Ms. Bush is the president of We the People Arizona Alliance. This is a group that's been focused on election integrity. It has been tasked by the Arizona Senate to perform investigations on their behalf. They have data analysts. They have actual people who have been trained in MAricopa's signature review procedures, and they conduct their own training. And this is much of which has been all directed by the Arizona Senate or the Senate President, then Senate President, Karen Fann, to review signatures and to see what is going on with the process at MAricopa. They received, at the behest of the Senate, the 2020 ballot envelope signatures and the actual record signatures that MAricopa employs. Their review that they've conducted in exact accordance with MAricopa procedures shows that approximately 9.9% of the ballots they've reviewed, and it's well over 200, well, about 700,000 now, but 9.9% are egregious mismatches.
Egregious.
Another 12% would not pass MAricopa's standards for signature review. The purpose of this, Your Honor, when you're not performing signature review or signature verification, as we just talked about, that means the system becomes vulnerable to fraud. This extrapolated out of 20% of mismatched signatures making it into the process and being tabulated equates to over 239,000 ballots in the 2022 general election.
Bigger than the margin.
When you don't do signature verification, this is what happens. That's the consequence of just clicking on a screen and moving to the next ballot at less than 3 seconds an image, and even less than 2 seconds an image. I mentioned that the review showed that approximately 20% of the 2020 ballot images did not match. This isn't about relitigating 2020, but it's about showing a failed process. And that evidence corroborates that the process has failed. And just as A.G. Bronovich noted, in 2020, MAricopa, out of 1.9 million ballots, they rejected just 587 signatures.
Gosh.
That's not signature review. You will also hear expert testimony by plaintiff's expert Erich Speckin. He has testified in over 400 trials and depositions as an expert on handwriting analysis. He has testified in connection with the evaluation of mass numbers of signatures in the context of elections, in the context of mass torts. He will give testimony on that it is impossible Not that you might get it okay, or it might be, it is impossible to review a signature in less than 3 seconds. This isn't about whether it's 30 seconds to get it good enough or 10 seconds. That it is simply not possible to review a signature at that rate when it's done on scale. He has over 30 years of experience in evaluating signatures in a variety of cases. His opinion is that signature verification was either not performed at all, or was simply clicking through in a sham process where the signature verification workers were just clicking through the screen.
It either wasn't done or practically wasn't done. Just clicking through it,
Your Honor,
looks like
there
it, but it's
are
not.
huge questions in the public
That's
about
true.
the integrity of the process. This issue, which again, mail-in balloting is the single greatest potential source of fraud. The evidence here today will show a failed process where no actual signature verification is being performed. On some ballots it is, but the question before your court, before your honor today, is whether no signature verification was being performed on a mathematically determined sufficient number of votes to set aside the election. As I said, MAricopa's own log data shows that over 264,000 ballots were reviewed at a rate of less than 3 seconds. 70,000 at a rate of less than 2 seconds. In addition, testimony that the level 2 reviewers were so overwhelmed that they simply didn't look at the signatures that were piling up on their desk. They simply kicked them back for the level 1 reviewers to take another look at. That's not signature review, Your Honor. Close.
Thank you, Mr. Olson.
Kari Lake's lawyer, Kurt
Would the
Olson.
defendants like to make opening statements now or later?
Right now, Your Honor. Thank you, Your Honor. Thomas Liddy for MAricopa County Defendants.
Need this?
No. All I need is this. ARS 16550. That's why we're here, Your Honor, after your ruling.
Very narrow.
15 county recorders. They have to determine if the signature is inconsistent. Determine if the signature is inconsistent with the elector's registration record. 15 county recorders are elected to do that, among other duties. And we're here today because somebody thinks in MAricopa County they didn't do it.
Yeah.
And that's their burden. And you just heard their opening statement that no actual signature verification was done, but for some it is. Some it is. Not that it wasn't done at all, but there was a showing in the video of a failed process. Well, Your Honor, we're not here over the next 3 days to challenge a process.
This is what the judge is
going to challenge a process. You got to do that after the process is set, before the election starts. You already ruled on that. So we're not here to defend a challenge to the process. We're here to determine whether MAricopa County, under its recorder and the team that he assembled, under 16550A, made a determination of signatures were inconsistent with the elector's registration record. And Your Honor, you will hear from Ms. Lake's whistleblowers, who will actually be the marching band for MAricopa County. And they will testify that they, in fact, were part of the process that did do signature verification. They were hired. You'll hear they were trained in the classroom and in practicum, that they executed their duties in accordance with their training, and that they weren't alone. There were others doing it with them. And you will hear that there were other levels from their own witnesses. Level 2 managers would review it. Under Reyes, there's no requirement to have handwriting experts looking for matches and loops and all that sort of thing. Because it doesn't require, according to Reyes, quote, does not require any special expertise on the part of the person making the comparison. The statute merely requires that the comparison is made, and that each county recorder in the 15 counties does it. The evidence just shown in the demonstrative is evidence that it was made. Now, if in fact that video showed 2 individuals,
It may be crappy,
you're
but
going to
we did it.
learn,
We did it, though.
Your Honor, hear from the evidence that there's 153 others, not just those 2. Now, on those 2, you couldn't see the screen. I would ask the court to take the video for what it is, not for what counsel says it is. Can't see the screen. But if in fact the individual on the left was not doing his job, and as you've heard from counsel in his opening, that all 155 level 1 signature reviewers were being monitored by their supervisors, that individual would have been taken off the line. And Your Honor, you're going to hear
Unless
that
they wanted
individual
that.
was taken off the line.
Oh, they was. Well, how many did you get through? What'd you do with all those ballots?
So, Your Honor, let's keep it simple. Did Maricopa County fulfill its obligations under its recorder and the team he assembled to execute their duties as defined by the Arizona legislature under 16550 to determine whether the signatures were inconsistent? And if so, they're accepted and moved on to level 2. There's no law that requires that there be anything beyond level 1. But Maricopa County, you're going to hear evidence that there's level 1, level 2, and level 3. Extraordinary Herculean effort, which Maricopa County proudly accepts, because when 1.3 million people turn out to vote, it's not a flood, it's a great day. Thank you.
It'd be nice if they could go and vote on election day. Idiots, you guys had problems all over the
Fine.
valley.
Your first witness will be?
Your Honor, the plaintiffs will call Jacqueline Oyeki.
All right, so good opening arguments. Now, I think that the judge really boxed in Kari Lake's team here, but they've done a nice job to salvage this. They've actually, the judge made them change their standard a little bit. He said, you got to prove that there was nothing done. They can't really prove that, but they've just changed their argument to say that in practice, nothing was done. When you have this poor of a process, it's the equivalent. They just translated it. We had a process argument, but the process was so bad that it disqualifies the entire activity. So they sort of, they fixed their argument in a way to fit the judge's ruling, which is good, but it's ultimately going to be up to the judge to decide whether to accept that or not. And as we saw, broad arguments from Kari Lake's team, massive fraud all over the place, different levels, different analyses. The defense came back out. They just said it's just this one rule, and we got to prove whether we did it or not. And we're going to be able to show that we did
Come up in
it.
front of the clerk here, raise your right hand, and she'll swear you in. Thank you. Ma'am, you make your way around to the witness stand and have a seat, please.
She's walking around over here, coming up around this corner here, should be poking up. There she is. Let's get out of the way.
Thank you.
Now,
You may begin when you're ready.
some were asking
From
the
there
judge-
or the podium, either one.
Sure.
The judge has a screen
morning,
over
Ms.
here
Archie.
too.
Good morning.
Would you please state your full name and address? Actually, just your full name for the record.
Okay, my name is Jacqueline Onakite.
Could you maybe move that microphone closer or move the chair, one of the two, because you're a little soft-spoken.
Yeah, short, sorry. Can you hear me now? Better?
Is it better? I can hear, but I'm very close.
Yeah, Your Honor.
Maybe pull the microphone just a little bit closer.
I'll be careful.
Don't pull it
Is
out
that
of the,
better?
Don't pull
Yes.
it on.
Sorry.
Be careful with the tubes.
That may be the best we can do. Thank you, Mr. Olson.
Ms. Onokai, what is your general understanding of why you are here to testify today?
I'm here to testify on the signature verification process.
And is that the signature verification process that you performed for Maricopa County?
Correct.
Do you live in Arizona now?
No, we just moved to Colorado Springs about 7 days ago.
Okay. How long did you live in Arizona before that?
27 years.
Do you have any political leanings or anything like that, one way or the other?
No, I do not.
What party are you registered?
I'm registered as a Republican, but I have voted Democrat.
And when you've voted Democrat before, who have you voted for?
Obama.
When did you become active in the election process in Maricopa County?
Probably when I started hearing back in 2020, there was a lot of information coming out about the elections not being valid. And so I started getting involved and trying to find out how I could get involved and help so that I could see for myself.
Why did you want to get involved in Maricopa's election process?
I'm doing this for my children. I have 5 children and 9 grandchildren, and I want their vote to count.
We want their votes to count too.
How many elections did you work in for Maricopa County?
I work for the primaries and general. I'm sorry.
You okay, man? If you need a break.
It's
No,
stressful.
I'm fine. I'll be okay.
Do you have water?
No, sir.
Do
Do you want water? We've got a bottle.
Yes, please.
We'll get that for you. Go ahead and continue, Miss. You can approach.
Thank you, sir.
You said you became involved in the Maricopa primary. Was that in 2022?
Yes, sir.
And that was the first time you became involved in the Maricopa election process, other than voting?
Correct.
Why did you decide, or strike that? How did you come to be involved in the signature verification process at Maricopa?
I found out where I could apply to become part of the process. So I went on the Maricopa website and applied for different positions for ballot adjudication, ballot processing, and signature verification. And I was called in for signature verification to work.
And when you say you were called in because Maricopa accepted an application,
Correct.
and that was in the summer of 2022 before the primary?
Yes.
Okay. And what is your understanding of the purpose of signature verification?
To verify that in the past history that their signatures match and to verify it's the correct voter.
Did you go through any training for signature verification put on by Maricopa County?
Yes, I did. Celia Neighbor trained us for approximately 5 days. And then we also had a full day of training from a signature specialist named, I think her name was Catherine or Kathleen.
Who is Celia Neighbor?
She's the director for signature verification and ballot processing at MTech.
MTech meaning Maricopa County.
Yes.
And can you kind of describe in a little bit more detail the type of training that you're referring to? Was this classroom instruction?
Correct.
And how long did it go for?
We usually started our day at 9:30 in the morning and ended either at 3:30 or 4 p.m. in the afternoon.
And did you receive any training materials to take home with you or anything and to review?
I did receive training material, yes.
Did you provide copies to council of those training materials?
Correct, yes.
I'd like to pull up Exhibit 8A.
Which exhibit are we looking at?
8A, Your Honor.
Don't have that in any of the filings.
And Your Honor, 8A is a rather large document that might be easier to authenticate if I was able to hand the witness a hard copy.
Is it the election manual?
It's all one. The clerk has pointed out to me that they don't bifurcate 8A, B, and subparts. It's Exhibit 8, and it's to be one exhibit. Is that your understanding? This was the exhibits were presented yesterday, and
Yes,
the
sir.
clerk has to comply with their process. The clerk of the court is separate from me. And so I've been told that Exhibit 8 is Exhibit 8, there's not an 8A and 8B.
Okay.
So going back to you, what were you telling me, sir?
Your Honor, the training materials that I'm referring to are quite voluminous. And to authenticate it, I thought it would be easier if I was able, with Your Honor's permission, to hand the witness a hard copy and have her authenticate rather than flip through. And I could
Have we gotten so technical that we've given up on 200 years of jurisprudence and that's the way we used to do it? Absolutely. You may show it to the witness and she can look at it to verify it. I'm sorry for the commentary. I'm just a little taken aback that the way that I've always done it for the majority of my life is you're asking permission to do it that way. Absolutely, sir.
Thank you, ma'am.
Looking approach, yes, for that purpose.
Yeah, little interesting comment there from the judge.
Thank you.
Okay, yeah.
The declaration's not part of that, correct? It's
just the training.
And I hear clicking and things that the exhibits are, I'm told, supposed to be clipped together without pages. They're supposed to be all clipped or stapled together without pages being removed or pulled apart. If we start doing that, it creates problems. So I heard something over there that sounded like the exhibit being taken apart.
As I said, Your Honor, it's a number of pages, so I didn't.
No, if she can just pull them over and look at them, then that's great. I just don't want to clip and loose papers.
Flying everywhere.
Well, becoming missing in a question later. That's all I'm asking, please. So did you understand what I'm talking to?
Do you want me to leave the clip on and flip it, sir?
Well said. Leave the clip on and flip it, please.
All right, while we're waiting for this, this is Jacqueline Onikit. This is from Kari
Ms.
Lake's
Onikite,
disclosure.
you have been handed a document that's been marked for identification as Exhibit 8 in the court's record. This is does not include your declaration that is the cover for 8. But these are the training materials, and I'll represent to you that these are the training materials that you provided counsel for MAricopa's signature verification training. If you would just take a moment to look through it and tell me if it is a true and accurate copy of what you presented and what you received from MAricopa in the summer of 2022.
This is correct.
Your Honor,
Go ahead and move.
I would move to admit Exhibit 8.
Any objection?
No objection from the county.
Hold on just 1 second because I need to visit with the clerk on the direction. Attached that way. Is the declaration marked as a separate exhibit?
It is on our end, Your Honor.
Yes.
So we can.
Yes. The actual exhibit mark does have the declaration attached to it, so the county would object to 8 being moved in if it includes the declaration, since she's here to testify.
It includes the declaration. We have no objection to not including the declaration.
Understand, but once an exhibit is marked, you don't pull pages out. What you have to do is create a new exhibit. I have no problem with that. Just designate the next number in line. We'll put a new tag on it and it will be the entire exhibit minus the declaration.
Okay.
Okay, with that understanding, what will that number be? That'll be exhibit number 46, okay? So plaintiff has moved to admit exhibit 46, as I've stated on the record. Defendants, no objection.
No objection. 46 does not include the affidavit.
Correct.
Just for
46
training
is admitted.
materials.
Proceed with the questioning, but make sure that this gets taken care of so the record's complete.
And just, I guess procedurally, the exhibit 8 is there. She's not testifying from exhibit 8. Does the court want her to use the actual exhibit the court has on file or something that counsel provided for her?
The exhibit, always.
But to the point of the exhibit,
We now made it 46.
It's exhibit 46. Okay.
I can make this easier.
Here's what's going to happen.
What?
At the next break, when I have to give the break for the court reporter, you either make a PDF copy, printing it out and create exhibit 46, or somebody comes up with a copy of what's agreed. Do you have that?
I have exhibit what's now going to be 46. It's double-sided, so we can just move.
Okay.
If you want to look at it and we can have it marked and then.
It's not supposed to be double-sided, but in a pinch, I'm going to.
Judge's blood pressure is rising very slowly.
Mr. Olson, you agree it's accurate? What you have in your hand then, let's mark as exhibit 46. Are you both agreed?
I'm fine with that, Your Honor.
Bursting. Rage.
Forget about the double-sided or two rule for right now. If you'll give it to the clerk, she's going to make a green tab. We're going to mark it 46, and then you're going to present it to the witness, Mr. Olson. Okay?
Yes, Your Honor.
So we'll make sure, yes, please.
A lot of time being spent on staplers and paper clips, but this is how things go. We got to have the record clean. If you don't do this now,
Whilst just doing that for future reference,
Things get
anything we
messy
present
after
to a
the fact.
witness has to be one of the marked exhibits rather than
we'll get
some
the system
substantial
down.
equivalent or something else.
Things will be smoother, hopefully, moving forward.
Great. Okay. The witness now has exhibit 46 in front of her, and that has been admitted in evidence. Proceed with further questioning.
Sure. Please turn up page 8432. Mr. Onikite, if you would turn to, it'll be up on the screen as well, but it's the page marked 8-432 at the bottom right-hand corner. You'll see a slide at the top entitled Reviewing Signatures. Page 432.
Ma'am, if you're having a difficult time finding it, I'll have Mr. Olson come up and point you to it if you'd like.
Thank you, sir. I found it.
Excellent.
You see the slide that begins with, and you can look behind you, it's there as well. If you look back over your right. Is this a document that you reviewed in your training by
Correct.
MAricopa?
Correct.
And what do you think that the purpose of these training materials were for?
To make sure that we were following all of the laws and make sure that we were obviously doing our job.
And when you say you were doing your job, what job are you referring to?
Signature verification, we had a computer screen and it was for the VRAS. We would log in, get into VRAS and then click start, and a batch of 250 green affidavits, well, one at a time would pull up, and then we would use the actual green affidavit that was sent in for
Forgive me for interrupting. I want to just stick with the training right now and the purpose of what you were being trained to do. And so when you look at this exhibit, if you turn the next page, and you'll see at the bottom slide entitled Handwriting Analysis.
Correct.
And if you look at the second bullet point, and I'll read that for the record, the second bullet point at page 8433 states, in the context of the signature verification process for early voting, handwriting analysis is used to verify the identity of a voter by comparing the signature on an early voting affidavit against a known signature on the official voter registration file and past affidavit signatures. Was that your understanding of what you were learning to do?
Correct.
And when it talks about an analysis of the signature, what does that mean to you in the context of your training?
Well, we were looking for the way that the signature was either slanted to the right or the left, the beginning of the signature, the way their handwriting, it could be a loop in the very beginning with their name, or at the end, they did a little loop at the end.
And so, turn to the next page, please. If you turn to page 8434, are these examples of specific characteristics of a signature that you were trained to assess and analyze when you were making your comparisons of the two signatures?
Correct.
And there, if you just keep flipping through to 435, 436, there are a number of different examples here, correct?
Correct.
If you turn to page 8437, the slide entitled Broad Characteristics, Evaluating the Entire Signature. Do you see that?
Yes, sir.
There are 8 bullet points of what those 8 bullet points represent to your understanding of signature verification that you were trained in.
The type of writing, whether it be handwritten or if they were doing cursive writing, the spelling, the alignment, the overall size.
Are these all different factors that you were trained to assess in making a determination whether a signature on a ballot envelope could be verified with the signature on file with the state?
Yes.
If you would turn the page to 8438. You see where the slide entitled Broad Characteristics?
Correct.
Can you, and then the next several slides from 439, 440, all the way over to 441 talk about broad characteristics.
Correct.
What is your understanding of the purpose of assessing broad characteristics of a signature in conducting a signature verification?
I believe that each individual voter's signature, even when they get older, it does change slightly, but for the most part, it should stay the same.
And how would you utilize the characteristics that are identified in your training materials to analyze a voter's signature?
Well, as I stated before, a lot of them would be either slanted right or left, or maybe it's, again, not cursive, it was just hand printed.
Would you assess all the different characteristics?
Correct.
And then if you look over at slide on page 8441, which is up on the screen now, do you see where it says local characteristics?
Correct. The spacing and the size of their handwriting.
So when you say spacing, what are you referring to?
Maybe some signatures, they just flow all together, and others, they would actually have the first and the last name separated, a space in between.
And is that a characteristic that can tell whether a signature should match or not?
Correct.
If you would turn to the slide on page 8446.
These are all different indicia for signature matching, all the different permutations of a person's signature. I was trying to find the slides.
I'd like
so we
to
could see them, but I
discuss
can't find them.
the equipment setup that MAricopa provided for you to evaluate signatures in the for early voting in the 2022 primary and 2022 general election. Do you see the slide at the bottom entitled Voter Signatures Accessing the Voter Signature Images?
Yes.
So when you were conducting signature review, were you looking at computer images or actual hard copies of the ballot envelope?
It was the hard copy that was scanned and was on the computer screen.
Okay. Can you describe for me and for the court how signature verification would work mechanically? Sitting in front of a computer screen, what would you do?
So we would come in every day, log into our computer and log into the VRAS system, the voter signature, and then we would click start and then new to bring up a batch of 250 signatures to go through, the green affidavits. Once we click start, an image would pop up. Once the image popped up, we were supposed to go through our 11 points to verify the name of the voter matched in the history from before. And it could have been a combination of voter registration forms or past green affidavit envelopes. And once we had verified the points, then we needed to scroll down and just look at the signature for characteristics that matched.
So when you say scroll down, what would happen to the computer screen when you scrolled down?
So you still had the recent green affidavit in front of you, but when you scroll down, you could see all the three that we were given, which again, I said was a combination of the voter registration form or past green affidavits that we would verify off of. So you would have to scroll down in order to verify the signature. So a lot of times I would scroll down very slowly and then scroll back up because some of them were very difficult.
Explaining what we were seeing
Once
here.
I verified the
this
signature,
guy.
if it was a signature that didn't match, then I would click exception, which meant rejection of that signature, which would then go to the level 2 managers for them to look at. If it was an approval, then I would press good and that would go on. And my understanding is that ballot would come from run back for ballot processing to process.
See how
Can
this
you
guy's scrolling
describe the
down?
various levels of signature review at Maricopa County while you were employed?
So level 1 was mostly part-time employees of the county just for election. Level 2 were part-time employees that have done worked several elections, and they would verify. They actually had more signatures. They had the full history. So they would spend more time going through those signatures to verify if they could see a match in order to approve that ballot or that green affidavit.
Were there any levels above level 2?
My understanding there was a level 3, and I'm not sure who was handling level 3.
Were there any managers that oversaw your work or the other signature?
Correct. So we were advised several times that we were being, that we were being monitored and they were doing audits on all of us. And we were advised that if we were either approving too many or rejecting too many, that we would be called into the office and just talked to. If it happened a second time, we would be let go. So we were advised, that they were watching everything that we were doing.
Were you ever called into the office?
No, sir. I was actually assigned extra duties from, I guess, doing a good job from the primaries. They assigned me to do missing signatures. So if a green affidavit was sent in with no signatures, then I would scan all those green affidavit envelopes into the system for them to keep track of which ones came in with no signatures. And then I was given envelopes to stick the original green affidavit in the envelope with the letter stating that they forgot to sign their signature on the green affidavit form, and that they had so much time to send it back. We gave a specific date. So I handled this every morning, probably for about an hour to an hour and a half when I first came in.
You mentioned you started off with the 2022 primary election performing signature review.
Correct.
And that was after a week of training, 8 hours a day, 5 days at 8 hours a day, correct?
We didn't. So when we first came in for are you speaking with the general or the primary? I apologize.
The primary.
Okay, so when I came in for the primary, we did the training, but then they sent a large group of us to the county recorder's office because they were running behind on new registration forms we handled, and also voters that moved. So they had sent out notices saying, are you still at this address? And then they would send it back in. So then we would go into the VMO8 to verify their information and then pass it on to whoever was in charge of us at the county.
When you talk about going into the VMO8, was that part of the signature review process or something else?
It was, but that was more at the curing process when we were done verifying signatures. These were the rejected ballots that the signatures were no good. And so we finished on the 11th is when we did the last signatures. And then we started going back into the history just to take another look first, whether or not we could find a signature within all of their history. And once we did that, if we could not, then we would try to locate a phone number and contact the voter to verify their information over the phone.
For the primary, can you describe the setup MAricopa had for performing signature review with levels 1 and 2?
It was the same as the general, only they had more of a sense of urgency because we were getting so many ballots in, and we had a much smaller crew for the primary election. So we were working longer hours.
You said that during the primary you're working longer hours?
Yes.
And where was the sense of urgency that you mentioned? Was it the primary or the general?
The primary.
How many stations were set up by MAricopa for signature review?
During the primary or the general? During the primary, there was probably 6 to 7 in the second room and maybe 6 to 7 in the first room where I worked.
And so that's between 12 to 14 stations.
Correct, plus the 3 managers that were for second level that were on the side.
So that would be 15 to 17.
Correct.
And can you describe the setup for that?
It was pretty much the same. We focused in on handling all of the verification of the green affidavits. Whatever was rejected, we sent to level 2. And then they verified whether or not they could find a signature that matched. With the Am I allowed to, with the general, I felt more of a kind of not a sense of urgency like we did with the primary. And we worked literally to the very last day, to the very last second, where with the general, we ended on, would have been Tuesday, the 14th at noon, they had us go home. Which Wednesday was the last day at 5. So we didn't understand why we were leaving early when there was ballots left in the bins.
Yeah, that's a great
And we had
question.
asked the manager, are you sure that you want us to go home? Would you like us to, keep trying to call these voters to get these ballots cured? And they said no.
Wow.
Do you have an understanding as to the number of ballots being processed for signature verification in the primary versus the number of ballots in the general election that were being processed for signature verification?
There was a lot less for the primary, and there was, I want to say close to 1.3 for the general, but we didn't have as many for the primary election
And you say 1.3 million?
for the general.
Can you describe for me the number of stations that were employed for the general election for signature review?
There was about 24 for the day shift, and that was split between room 1 and room 2. And then we also had a night crew coming in that they hired that worked from 3:30 to 7:30ish at night.
Were there the same number of level 2 signature verifiers in the general as in the primary?
Yes,
So that would be 3.
correct.
And tell me, you mentioned shifts. What shift were you on? normally?
I was on the day shift,
And this is in the general.
correct. And I was also on the day shift for primary.
What were the hours for the day shift
For primary or general?
for general?
For the general, we started every morning at 7:30. And they usually wanted us out the door by 6:30, 7.
And when you say out the door, was that the first shift was out the door by 6:30 or 7, or was that the
Everyone, including night shift.
So when did the day shift end?
It was supposed to end at 4:35 in the afternoon, but then they were asking people to volunteer to stay. And so it was just maybe 2 or 3 of us. My counterpart that sat next to me stayed. And
when did the second shift begin and end?
3:30
And when did it end?
at about 7:30.
So at the same time.
Mhm.
How was it possible to have 2 shifts working at the same time with 24 stations?
Starting at 3:30 because half of my crew would leave. They didn't want to stay. So there was less of us there working.
So at any one time during a day, were there more than 24 level 1 signature reviewers during the general election?
Not that I am aware of.
How many were there more than 3 level 2 signature reviewers during the general election?
To be honest with you, I know just of Andrew, William, and Jeff. I'm not sure who else was working level 2.
For the general election, could you describe your workload, meaning how many signatures you would review on a typical day?
So the batches were 250. I did keep a tally on a sheet. So each time I would finish going through a batch of 250, I would put a mark down. So every day I usually did between 6 to 8 batches of 250.
So that would be about 2,000.
How did that compare to your workload during the primary?
Well, we stayed there much later. Some of us were there till 9 at night, some till 10. So we did a lot more as far as batches because of the long hours.
How many days a week was signature verification going on in Maricopa during the general?
The first couple weeks, we didn't work the weekends, but the last couple of weekends prior to elections, we were there.
Was that Saturday and Sunday or just Saturday?
There was some Saturdays and Sundays. But I also worked, I was pulled to work in adjudication because they were short and had way too many adjudicated ballots. So a lot of times, even though we were let go at 7, I was there sometimes till 10:30 at night.
Wow.
With the adjudication team.
They're going to turn around and say, see, they were
Was
very
there
fair.
any
find tons of
way that
signatures."
the signature, level 1 signature verifiers and level 2 could keep track of the number of ballots that were going to be ready for review?
Can you state the question again? I'm sorry.
Was there any general notification in the room of the number of ballots that would be ready for review by levels 1 and 2?
So for the primaries, Celia Neighbor, the director, would send us an email every morning of how many ballots that we needed to verify the signatures. And then she also would put what we hadn't completed from the day before and added it to that number. So we got emails every day. For the general election, we didn't get emails. They actually had a whiteboard in the second room that they would write down the number of ballots that we needed to verify signatures. So I really didn't see the numbers that they were putting down because that was not my room. We didn't have the whiteboard in our room. But I know that they did write the number of ballots that we had to get through for the day.
Do you
on that
have
whiteboard.
any recollection as to generally what the number of ballots that were to be processed each day?
So I know for the first few weeks for the general, it was sometimes 50, sometimes 60, sometimes 70, those first couple weeks.
And is that about 50, 60,
Yes,
70,000?
sorry.
For those of you just joining us, this is Kari Lake's witness. This
Did
is
you
Kurt Olson
interact
asking
with
questions.
the level 2 reviewers
I did.
during the general?
I did, yes. Mainly because we were having so many problems with signatures and the rejections that I would turn around and apologize and say, I am so sorry that I'm sending you these, because they were getting overloaded with signatures and they were getting frustrated.
Okay.
And when you say they, are you referring to level 2 reviewers?
Yes.
And so how did you know they were getting frustrated?
Well, we would go out on breaks or at lunch, and Andrew and Jeff would complain about how many they were having to go through, and they didn't think they were going to be able to get through those signatures because there was too many and there was not enough of them. I do know there were times when rejected signatures that I did send to them, they actually sent them back to us because they got so overloaded for level 2. So, because we would ask the manager, you know, I just looked at this signature and I rejected it. Why am I seeing the same signatures again? And so they would say, you know, the level 2 managers are they've got too many to go through. So we're just sending them back to you to re-review and see if there isn't anything that matches.
Who told you that to re-review?
Usually it was either Tony, my supervisor, or Michelle would come in, or Celia, because it wasn't just me complaining, it was other people in my room that were complaining of how many, because we kept having to call the managers over to come and look at the signatures of, you know, how bad they were. They weren't matching up. And, you know, what do I do with this?
Nah, it's fine.
I mean, so they would come over and just tell us, you need to be very cautious. You need to pay attention to what you're doing. And remember, that whatever you reject or approve, you could be called in to testify. And I think that's why a lot of us were asking them to come over and look, because there was so many bad signatures.
How do you know that the signatures that had been sent up to level 2 were being sent back?
Because we asked, we had noticed ones that we had already rejected were being put back into the queue. So we asked, I just did this maybe like a half an hour ago. If it's a unique name, you're going to remember. And so a lot of us were stating, why are we seeing these? Is the system not working? What's going on? And we were told by Tony or Michelle or Loma or Celia that they kicked it back because level 2 had too many to go through. They just wanted to make sure, for us to go back through and really verify whether or not we couldn't find a match.
So who is Tony?
Tony was my direct supervisor.
And was he employed by Maricopa County?
He's a full-time permanent employee.
And you mentioned Celia.
Correct.
And who is she?
She was the director, and she's was a full-time permanent employee.
And you mentioned a third person?
Michelle, she was also a full-time permanent employee.
Tony, Michelle, and Celia.
What kind of pressure did you feel in processing signatures for signature verification during the general?
I think we all felt really pressured when they sent back what we had already reviewed, and we really didn't feel comfortable about approving what we had already rejected. We had already went through them. So, when we questioned them about it, they just told us, if you still don't feel like you can find a match, go ahead and reject it. And I did.
Do it again.
Because I did not feel comfortable approving something that I had already rejected. We'd already went through them.
Did everybody else do that there?
Did you ever hear of the level 2 reviewers complaining about the number of ballots that were being rejected and sent up for them for level 2 review?
Yes. It was taking him quite a bit of time because he was having to go through Jeff, meaning Andrew and Jeff, were complaining because they were having to spend more time to try and locate a signature that would match throughout their history. And I asked, I apologized to them, especially for Andrew. He was there when we started in the morning, and the next day when he would talk to us, he was there till 9 or 10, sometimes 11 o'clock at night, trying to go through level 2. I know that Jeff and William always left at 5:30-ish. So he was left by himself to get through those for level 2.
During what period of time in the general election did these complaints occur?
All throughout, especially for the newer people that hadn't worked the elections. They didn't feel comfortable with what they were seeing, and they were complaining. I mean, I know that sometimes I know Jeff was keeping track, like a spreadsheet, an Excel spreadsheet, because we were catching signatures of individuals that didn't even belong in the history. Meaning, say if it's a John Smith, and it was a woman's name, and this wasn't a married couple. This was completely different names.
Totally random.
So they told us to write down the voter ID, the name of the person, and to give it to Jeff, the second level manager, and he was keeping a spreadsheet of all of those signatures. And we were told they were going to clean up the voter history to try and get rid of those out of.
I'm sure.
Because we asked, how did these even possibly get into the history?
Where were those spreadsheet objections last
They're
time?
not even the same. They're not the same name. They weren't a relative. How did this happen?
Good point there,
The
Rob.
addresses were
Brilliant
different,
point. You're
everything.
doing great. Yeah.
How do you feel?
All right, what's up, my friends? We are back. We are checking back in. We're waiting for that countdown to carry us out. Hopefully you're having an amazing lunch. We've got About 19 minutes until the court is back in session. We want to warm the tubes back up and say hello to the chat. Say hello and thank you very much for the support that came in on those super chats. And so that was yesterday. This was Jacqueline, who came in, testified about level 1 signature verification. And we heard previously there was some emotional testimony there saying that she was here speaking on behalf of her kids and her grandkids because there were some serious problems. And some of that testimony was that they were getting totally mismatched names. Like my name would be totally interposed with somebody else's name, and it just didn't make any sense. They'd refer it to somebody else to go clarify what the problem is. Be assured it would be taken care of. And then who knows what happened after that. So that was day 1. Of course, we're back in day 2. Part 2 this morning was a little bit of a doozy. Wasn't really sure what was going to be happening there. Had a little bit of a panic attack right here. As soon as he said, I'm done with this witness or something. What? Fortunately, we came back. We got some good testimony. We are going to be picking back up with the expert witness, which is this guy, Erich Speckin, who has a lot of credentials. And this morning we heard him talk about all of them. Many different countries, many different states, testified about handwriting. We looked him up. He actually also had a pretty considerable background in other corporate cases, Walt Disney Corporation, Exxon, some other banks, different things like this. And we haven't quite gotten to the conclusions yet of, what he has for us. We were just getting into that. We remember that when they kicked us out, or when we thought that they were done with this guy, we hadn't heard any of this. And so this is what I would expect to hear this afternoon. This is from his disclosure. Who is Erich Speckin? What is he about? Saying that he's going to testify that based on 1.3 million early ballot envelopes, so the envelopes that were supposed to be signature compared, he's also going to say on the number of signatures rejected, 25% were rejected, and that the number of level 2 reviewers, a reliable and reasonable review, could not have been made by me or any other similarly trained expert. He's also going to opine that signature verification was either not performed at all. Okay, like that's the key testimony. We have to have that. That is so critically important. We need that point to be made. Opine that signature verification was either not done at all or was done simply by clicking through images without conducting an actual comparison. In other words, it was done, but done so poorly that it might as well be considered not to have been done at all. It was so badly done. Mr. Speckin will also opine that an example of this would be in former AG Brnovich report to Senator Fan, as discussed above. In that letter, AG Brnovich noted an instance that the Maricopa County Recorder verified over 200,000 early ballot affidavit signatures with an average of 4.6 seconds per signature. He will opine that is not a signature review under any standard. So even 5 seconds, they're saying, is just not good enough. The basis for the facts relied upon comes from a whistleblower witness, data provided by the county, the rate of rejection of the signatures, the manner in which level 1 and level 2 reviewers are provided comparisons and allowed to review the signatures. So, that's all good stuff. The rate of rejection is so high, they would have gone up to level 2, but level 2 at 5 seconds is just not long enough. He's also going to opine that in his expert experience, to perform the signature analysis based on the mathematical inputs with a ratio level from level 1 to level 2, so 25 level 1 reviewers to 3 L2s, and if you just calculate the man hours, the hours and days worked, so 26 days, 2 shifts, 12 hours, as they all described. We already heard from several of these witnesses. Yvonne is not testifying, my understanding. She is not going to be here. Jacqueline Oniki, we heard from her yesterday. Andrew Myers, he testified by Zoom yesterday. And an average time of 30 seconds or more for each review or rejected at L2 equals 112,000 reviews. Mr. Speckin will opine that that means, in his expert opinion, that 300,000 rejected to 112,000 maximum reviews would equal at least 187,000 signatures, could not have gone through L2 signature verification process. And he's got other testimony as well. And so remember, we've got a very clear distinction here that we're trying to thread the needle on. The question is about what, not exactly whether it was done per se. Well, Kari Lake's team is trying to say there was some signature verification that was done, obviously mechanically done, but it was done so poorly that the verification process as a whole was corrupted and it cannot be considered to have been completed. So what you're seeing here is a bunch of noise. You're seeing a bunch of little worker bees running around verifying signatures, but they didn't complete the job of verifying signatures. They didn't actually, in the totality, complete the thing. Why? Because it was so catastrophically erroneous at multiple layers. That means you have to invalidate the entire process. And you see this a lot in criminal law. If you've got one bad piece of data, or let's say you've got one bad error in a DUI blood run where they don't run, they don't run your sample by itself. They put it in a big vat of vials, looks like a big pizza tray, and they put the little tubes in there and they put it into a machine, it pokes the holes in them, and that's it. So if there is a major catastrophic failure in that entire batch, well, then you would say that entire batch is a bad batch. You've got to redo all of the samples. You got to redo everything. And so what we're trying to, because you can't trust it. Where was the error? I don't know. Was it in the pipetter? I don't know. Was it in the actual mechanical operation of the crane, the functioning of the machine? Was it in the post-machine analysis when they were doing the analysis by these, the crime lab forensic people? Who knows where the error was, but until you've got to pull the whole system out and do a root cause analysis to get to the bottom of it. You can't just keep feeding vials through there. So in this case, if we've got some pretty serious systemic mechanical errors that are happening at some level in this organization, that might be enough to say the entire process has been tainted. You can't trust it. It's, it's like when you drop food on the ground, or something like that. Sometimes maybe you pick it up and cut it off. Sometimes you eat it. Sometimes you don't eat it. It's tainted. One bad apple spoils the whole bunch. And it is a similar argument that Kari Lake is making. And they're trying to hammer that in there. And that's why we wanted to see a little bit more activity with Valenzuela and this Steve the Pecker fellow. Why was he just tapping away? What was the remedy? What was his party? What did you guys do to go back and corroborate his work? How did you identify him? And did you identify other people? Who was responsible for that identification? What were the criteria? And the whole thing. You could just dig into that and say, oh, okay, so you really didn't have a good system for checking this. So you're telling me that you just happened to catch this guy, but you didn't catch these other people. Or you caught this guy and you moved him out of the line, but you didn't go back and correct whatever he did previously because of the manpower. They didn't even ask that question as far as I could tell. So there's a lot there. You could say this was so tainted and corrupted that the entire operation needs to be thrown out. That's Kari Lake's argument. And you're seeing that here materialize. That basically 187,000 of them didn't go through, meaning basically level 2 just didn't happen. And so we'll see how that carries on. So that's where we're at. We're going to be picking back up with Mr. Erich Speckin, and we'll be looking forward to that very, very soon. We'll wait and see where the court is. They are still hanging on. And so let's say hello and thank you to everybody who is supporting us here today. And I appreciate you joining us and coming back after the lunch and inviting everybody else to come and join us, because we're back in session, baby. And Dreary Your Spider shared this one. Oh, we got some activity from the court. Ooh. Oh, a network error caused the video. Uh-oh, we better better remedy this real quick here. Let's see what happened here. All right, there we go. We've got this one here set from Jerry or Spider. Says, Rob, according to Barnes, shout out to Robert Barnes. Hey, you know Viva's testifying right now? I think he's like testifying in front of Justin Trudeau or something. I don't know what he's doing. But he's testifying right now. I just retweeted it. Yeah, he's like a witness in a fight for freedom, as usual. But hey, Dreary or Spider, the reason I brought it up is because of Barnes here, says, according to Barnes, type signature challenge just needs to demonstrate more mismatched signatures than margin of victory. In my opinion, Kari needs to show the actual signatures to preserve appeal, assuming she got access. Well, it's a, look, there's like multiple layers to this. So when I read the advisory or the under advisement ruling and the under advisement opinion, and we can pull it up, but there's language in there saying that Kari Lake has to show that there was no level 1, level 2, or level 3 signature verifications at all. And there's a distinction between these two types of cases. One's called Reyes and one's, I forget the other one. It's in the order. But they are interpreting it one way and not the other. In other words, they're saying Kari Lake, through this entire trial, has narrowed her argument in her complaint to say that they didn't do it at all. Has reinterpreted it literally that way, that her argument was because of the evolution of it from the original filing of the complaint a long time ago throughout oral arguments. Remember, this went all the way up to the Supreme Court, all the way back down. And so they're all interpreting it. And so Kari, it's like the game of telephone. You pick up the phone, in the game, right? The kids say one thing into the ear of the other one, and then it goes down. And by the end, you're like, what? That's perverse. And then you go, that's weird. It came from him. And you go look at that guy in the middle, like that guy changed it. So you have that situation. And by the time it comes back down, the judge is now reinterpreting it all. And he's saying, okay, this is what Kari Lake has to prove. Now with this very narrowed issue, it's come back down for clarity and for review. Because the Supreme Court also said you can only, you got to go back and do it this way. So the judge reinterpreted that to say Kari Lake has to show there was zero, and we read through the order, no, any, underlined, any, no, L1, L2, or L3. Obviously, that is going to be a difficult standard to meet if the standard is any signature verification. Like if they just did it, if they just signed one of those, does that count, Judge? Like, is that the standard you're saying? And one interpretation is yes. Kari Lake's argument, the only way she can rebundle this is by saying in totality, all of the problems we've seen, all of the testimony, if you add them all up, it's as though the thing never happened. It might look like they did it, but they just didn't do it. So I don't know. Kari Lake can't appeal on new evidence and things like that. And I don't know what access she's gotten. And I don't think she's gotten a lot of access to the actual signatures. But they have done various summations of them. And like we'll see what this expert says, but I'm not sure he's going to get into the actual matching of the signatures. Remember on day one, there were the indicia of signature verifications, the loop-de-loos, the hearts on the eyes. Oh, that's so cute. That whether they're slanty or not, the spacing between the lines, and so on. And I'm not sure he's going to be testifying about that. We'll see. But I think he's more testifying about let me explain it this way. He's not testifying about those indicia specific to individual voters. He's talking about those indicia in terms of processing ballots. So he's not going to say, okay, Rob Govea's signature matches here, and I went through 50,000 ballots and the mismatch was the number. Maybe he will. But I think it's more going to be about, in order to make that match, it's going to take a certain amount of time. And they were doing it too quickly based on the rejections from layer 1. They got to send those back up to layer 2. And that's a much more significant investigation. And if you just do the simple math on it and the volume of all of this, they just couldn't have done it. And they didn't do it. And they're going to try to package that into Kari Lake's argument that it just didn't happen. What you saw was some activity, but it wasn't actually signature verification. So hopefully that makes sense, but it's a good question, Jury or Spider. There's multiple layers, and we have gone up and down a lot. So thanks for the tip. Hey, Gaming Sloshed is here. Gaming Sloshed in the house, first time. Woo, first timer here. We love first timers. What's up, Gaming Sloshed? Thanks for joining us. We had another one from Voice of the People. Says, is this the judge that tried to dismiss the case the first time? Wouldn't it make sense to have another judge oversee to remove bias for embarrassment? It's a good question. Yeah, this judge originally did dismiss the case. He originally dismissed this count in the first place. It went all the way back up to the top. Supreme Court said, Judge, you dismissed it inappropriately, and sent it back down to the judge to do it again. To be perfectly honest with you here, I don't see any bias in this judge. I think this judge has been extremely, extremely lenient. He could have gone the other way on a couple things, and he hasn't. So I don't think anybody's alleging bias. I don't think even Kari Lake's team is alleging bias, as far as I know. So the default is that judges are not biased, just as a general rule. They're judges. You're honorable, they have integrity, and they do, as a general rule. Judges do, and they really are. There are really a lot of amazing judges out there. And this judge, from what we have seen here, this judge could have given a couple backhands today and didn't do that. And he's also holding the government to certain, they're objecting all the time over kind of some nonsense things. He said, what are you talking about? Come on, get out of here. So I think it's a pretty neutral take thus far. And we've seen the opposite, right? We just listened to another case with Judge Kaplan, over on the Trump trial. So judges, you default to, unless there's cause or some bases to make a change. And I just don't think that we're anywhere near that yet. We got, hey, Gaming Slosh is back. What's up, Gaming Slosh? He says, do we know if when level 2 gets sent back to level 1, if it went back to the original level 1 person? So on that question, I don't know if it was for every case, but there was definitely a testimony from Jacqueline, who was the first woman who testified. Her last name, Jacqueline Aniki. And she said that she saw the same names over and over again, and so did Andy Myers, actually. He said the same thing because he testified that people had strange names, very long names, very recognizable signatures, and they would just pop back up and, definitely saw that again. So certainly some of them got it again, but I don't know about if they all got it again. Like, did everything you rejected come back to you? Or, because this is a good question, right? Yeah. If not, wouldn't it just be, this is exactly where you're going. Wouldn't it be a scheme to just keep kicking it down to level 1 until it ended up back in the hands of someone like Steve the Pecker? Great point. It's a great point. Yeah, and actually that would probably be a better strategy, right? So Gaming Slosh gets a list. Rob Gouveia gets a list. I look at them, I reject them, whatever I reject, see if Gaming will allow it through, right? And if Gaming rejects something, don't send it up to level 1, send it back down to level Rob and see if Rob will sign that one through, right? And you just keep passing them around until you get Steve the Pecker, who's like, Rawr! hitting that like button like a Maricopa County worker, It's a great point. And I don't know exactly how that worked. That's a great follow-up question that somebody on Kari Lake's team should ask. But we are back in session. Looks like, the judge is on the bench. Did we miss him? All rise, please be seated. Okay, we're back. Let's pull up the volume.
Present for the record are either the parties representatives, or appearances being waived. With counsel for the respective parties being present, we are in the process of the continued direct examination of Mr. Speckin, who is under oath and continues on the witness stand. So, Mr. Olson.
Thank you, Ron. Good afternoon, Mr. Speckin. Back to Exhibit 47 that we've been looking at.
Yeah, it got removed from my table.
You can retrieve it right there and give it back to him, Mr. Olson. I'm sorry, we had to take it.
And Mr. Speckin, just to recap, since we're starting after lunch, where it says verifications in less than or equal to 5 seconds and 3 seconds and 2 seconds at the top column, that means in simple terms, in less than 6 seconds, where it says 5, and then 3 means in less than 4 seconds. And then where the column says in less than or equal to 2 seconds, that means less than 3 seconds in simple terms, correct?
In simple terms, that's what it means, correct?
Let's pick a couple, and this table is sorted by user number, correct?
Correct.
Okay. So if we took user number 20, can you tell me what this data reflects?
Yes, so you would read across data associated with that user. So 55,888 determinations, verifications, conclusions, whatever you want to say, that were inputted by that user. 96.39% of those would have been approvals or passes, or like we talked about earlier. I hated the word accepted for the reasons that we talked about, so a pass.
Okay, and then continuing on.
As you go to the right, under the column that simply stated less than 6 seconds, there were 36,086 instances where that user did that. In those instances, the pass rate of those was 99.65%.
Objection, Your Honor. Again, what I'm hearing here is a summary of a document, or I should say of CD-ROM, leading to what I'm hearing is our statistical conclusions. Again, I think we've made our record, but I just want to read the.
True. The objection should be foundation, I believe, as to if he's
Correct.
going to use a number, he can do the math and show his work. So that's the objection on foundation. So how did he get the 99.65% for the last thing he testified to? That's the objection. If you could have him show his math.
Yes, ma'am. Mr. Speckin, with respect to the 99.65%, with this table, we're just talking average, correct? Average and averages and percentages, correct?
Not even average, just percentage on this table. Correct, yes.
Where does the 99.65% derive from?
That's the number of passes or accepted signatures, good signatures, compared to the overall number of determinations made. So in simple terms, if they made 2 determinations and one of them was a pass, 50%. Made 2 determinations and 2 determinations were passes, 100%. They made 10 and one was a pass, 10%. It's super easy.
Not for them, it isn't. Somebody get them a
question.
Slide rule.
Continuing on with, in simple terms, the column which is less than 4 seconds, can you just continue to the right with user number 20 as to what this data shows?
Yes. So for that user, 24,904 were done at that speed or faster. In other words, the less than 4 seconds. So obviously the ones that are included in that column were previously included in the one where we had a larger time that we're analyzing. This is a smaller subset of the same data. And of those, the approval rate, 99.87. So we get 13 out of 1,000 are not included, 9,987, or I'm sorry, out of 10,000. 9,987 out of 10,000 were passed.
Amazing. Wow, that's amazing. That's like almost a hole in one.
The column less than 3 seconds.
All 18 holes.
So that total number of instances where comparisons were done, where the keystrokes were entered in that amount of time is 13,749, and 99.88%. Simple conversion, 12 out of 10,000 were not passed, the rest were.
12 out of 10,000.
If we selected number, let's take user number 31. Could you go through the same recitation that you just did with respect to that user? as to what this table reflects?
Sure. Same principles apply. They did 46,854 determinations. The overall, call it approval percentage, passing percentage, 97.23%.
Amazing.
At a time of less than 6 seconds. Of those 46,000 instances, 37,588 of them were done at that rate of less than 6 seconds. And for that, the approval percentage for that subset, 99.37%. Moving to the right, less than 4 seconds, 29,751 instances. Approval percentage, 99.72.
99.72.
And then even faster rate of less than 3 seconds, 21,471. Approval percentage, 99.84.
Let's, if you would move over to the third page with user 72.
Amazing. Wow. Man, Arizona knows how to
Strike that.
sign
Let's
your
go to
documents.
user 79.
Don't tell us we don't know how to sign things, okay?
Objection, the witness
Perfect.
testifying to these numbers as if they are admitted for their truth. They are not admitted.
We're perfect with our signatures.
No, these are his opinions based upon what he's reviewed.
Is it-
So overruled for that.
Fabulous too. Fabulous
Go ahead.
signatures. Flamboyant.
So
Just
user 79, Mr. Speckin?
with the,
Same takeaway.
I'm trying to dig these
79,
charts up.
54,298 in total, the total body of work. 98.9% approvals. You go to the next column of what we're calling less than 6 seconds. 45,217. Approved at 99.91. So in simple terms, 9 out of 10,000
99.91.
would not be approved. At the next fastest rate
Amazing.
of less than 4 seconds, 37,524, 99.97. And the last column of 3 seconds or less, 27,196 instances with 100% approval rating, approval percentage.
Perfect.
Looking at the approval ratings going from less than 6 seconds to less than 3 seconds, what do you see about the approval rating?
Well, they're all very high for this user, but the faster they go, the more they get approved, the higher the rate for this user.
Does that seem unusual to you?
It definitely seems counterintuitive. It's also against my experience. The faster you go, it would be a rejection. It's easier to tell something doesn't match when you're doing a comparison, not that it does match.
Unless you don't care.
Turning to the last page, Mr. Speckin, and the total verification.
We are
Under
back
the
from
total-
lunch. This is live now.
Can you read the totals for the various columns, less than 6, less than 5, less than 4, less than 3?
Well, we only have 3 columns. So we have less than 6, less than 4, and less than 3. And the first one, less than 6, 779,330, 779,330. The next fastest time, 512,597. And the fastest time on the table, less than 3 seconds, 321,495 instances or times that occurred.
And my recollection is there is a lower figure for comparisons at less than 3 seconds, around 276,000.
Well, my opinion for the comparisons that were actually done in less than 3 seconds is less than the 321,495 number, because user 26 and user 9 had some activity that appears to be inputted through a computer by some algorithm or some script. I didn't think it was fair to count them, or it would be misleading if I did count them, if indeed they were put in through a computer or some algorithm, as saying that the keystrokes were done in that time. If I'm wrong, the number would go up, from my opinion, to what's on the chart. I just believe that's what was inputted.
So your opinion, would that subtract the number of ballots processed by user 9 and 26 from the total of 321,495?
Yes, so for the rate, the count or the instances or the rates, I think it would be correct to subtract that number to arrive at a smaller number. As I said, 321 minus 44, or it might be 45 when you add them up, 45,670 from that number.
Did you assess any rate of less than 2 seconds?
I did. I ran the search further out than shows on this table, yes.
And what did the data reflect?
There were about 70,000 instances, accepting or removing the 26 and 9 that I just talked about, that were lightning quick. Removing that, roughly 70,000.
So roughly 70,000 signatures processed in less than 2 seconds?
No, I would use the word compared.
Compared, excuse me.
Process would be a bigger number because you'd include 26 and 9. Compared would be the lower number, yes.
And do you recall any figures with respect to the approval rating?
So I did look at the users that had over 1,000 instances of that less than 2 seconds comparison, and 7 of them had 100%. I remember that.
Nice, perfect matches, 100%. Man, they're good.
What is your expert opinion as to the physical ability to compare a signature for consistency in less than 3 seconds?
I don't believe it can be done. I look at this all day, every day. This is what I do, and I've done for 30 years, handwriting and signatures. I'm not going to sit here and tell the court no one in the world could be better than me, but I really do believe I'm at the top of the pyramid of who could do this and how to do it. If I can't do it, I don't see how anyone could do it on a mass scale, day after day after day, hour after hour, at these rates. It can't be so.
And how are you using the term compare?
Well, compare to me, this morning I just Googled what does compare mean, and it says to look at carefully to see similarities and differences between two items. Obviously, in this case, we're talking signatures. That's what it means to me anyway, but to give you the definition that I read this morning, that's what it said.
And what is your understanding of the Arizona statute that governs signature verification 16550?
Well, it says that they should be compared, and then it infers after that for consistencies or inconsistencies based on this is the path for an inconsistency. It uses the word compare. The standards that I use in my field and the standards that are written use comparison and compare. The training manual use it. It was at least had input from someone like me. I don't want to drag her down to that level if she feels differently, but someone with similar background to me. It's a common word that we use in the English language, and it's no different in my industry what the word compare means.
Your Honor, at this time, we have no further questions.
Very well. Who will be conducting the cross?
I will, Your Honor.
Morgan, go ahead and proceed as soon as you are ready, sir.
Your Honor, may I use the podium?
You use the podium, sir.
Okay, so that was it.
I want to make sure I say your name right because I'm not particularly great with names. Speckin?
That's actually right. I was going to say use Eric if you feel comfortable, but Speckin is correct. Yes.
Thank you, Mr. Speckin. You'll agree with me in your profession, detail is a thing. It's important, right?
Absolutely.
Devil's in the details, as they say, right?
Perhaps an overused phrase in our language, but I don't disagree.
Okay. And you'll agree with me then that in connection with the signatures that we were just hearing you testify about in Exhibit 47, which is a demonstrative, you didn't personally do any of these signature comparisons yourself, correct?
That's right. I wasn't the level 1 reviewer or level 2 or whatever.
You haven't seen any of those signatures, correct?
Correct. I haven't seen a one.
And you'll agree with me then, in the realm of possibility, it's entirely possible that many of those signatures completely matched.
Well, I suspect some would have, yes.
Okay. Now, again, I want to talk about details. Earlier in your testimony, my colleague brought up a case in Hong Kong. Do you remember that case?
I remember very well.
It's Nina Kung versus Wang Dinxin. Does that sound about right?
That sounds correct. More or less, yeah.
More or less. All right. You had testified that there was an opinion from a higher appellate court that essentially said the intermediate or the lower appellate court got it wrong with respect to you. Is that right?
I said the initial trial court. I didn't say the lower appellate court.
Okay.
There was an intermediate appellate decision, but I didn't say anything about that.
And you, if I understood your testimony, and I'm summarizing, you feel like that appellate decision vindicated you essentially.
No, I'm saying it backs up the fact that the judge copied what the other side wrote.
Okay. Well, I would like to show the witness, Your Honor. I'd like to approach the clerk and have
the judge
this
copied what the
marked
other side wrote.
as next exhibit. It's the it's the court case that he mentioned in his direct, Your Honor.
Well done.
May I approach him?
You can mark it and you can approach him with it right now for
Thank you.
impeachments. We'll talk about admissibility later.
Not saying anything about the opinion. I'm just saying the judge copied what the other side wrote. That's all. I'm not making any judgment about it. That's just a fact, statement of a fact. Hilarious.
Got another copy.
So this is Erich Speckin, who is on the stand, and this is Kari Lake's witness, now on cross-examination by the government. Finished testifying. Should be the Kari Lake team's last witness.
I believe exhibit 48. Do you have that in front of you?
It doesn't say 48, but oh yeah, it does. I have it, yeah.
Okay. I want you to turn with me. There's some numbers there at the bottom, okay? I want you to turn with me to page 91. Would you let me know when you're there?
I'm there.
All right. I'm going to read aloud paragraph 452, okay?
Okay.
This is the decision from this appellate court in Hong Kong. I do not find these arguments excusing the judge convincing. Not only was the evidence on EEC dating wholly unsatisfactory, Mr. Speckin himself was wholly discredited as an expert witness for, among other things, claiming professional credentials that he lacked, claiming acceptance of his methods by the scientific community when that was false, and having been trapped into demonstrating that his opinions were quite unreliable. It would therefore have been wholly perverse for Yam J to do other than reject that evidence. However, even then, Yam J did so by copying verbatim almost the whole of the appellant's submissions inviting such rejection. Did I read that correctly?
Absolutely.
And you'll agree with me then that what the appellate court is saying is that the judge got it right.
I don't believe that's what's in the entire opinion.
Well, let's talk about what I read. I only want to talk about
For that one paragraph, does it
Yes.
say that? Of course.
If you like, you can take a moment to point to me anywhere in the opinion where the judge vindicates what you did and says you did a good job.
I don't have one that says exactly that, but we have wholesale copying and an unfair trial is paragraph 445
Sure.
and paragraph 90.
Yeah, but the paragraph we read said to declare anything other than you falsified your credentials would be perverse. Those are his words, not mine, correct?
That was the words of the person who wrote that. Yes,
Okay.
I'm saying there are other paragraphs that don't say the same thing. Is what I'm telling you.
Can you point me to one that contradicts that paragraph?
It just did. 445 on page 90.
Slow down.
Just trying to impeach him right now with other
Now,
external evidence.
you recall testifying earlier about your involvement in a case called EEOC versus Ethan Allen. You recall that?
I do.
And that's in the federal district court in the Northern District of Ohio, correct?
It was. Yeah, it's 20 some years old.
Honor, may I ask what time?
You can approach the exhibits, but ask about approaching the witness, please.
Exhibit 40.
I do.
Okay, let's talk about Exhibit 40. Is this the case that you were giving testimony as an expert in?
I never gave testimony as an expert. I gave a deposition, but never.
That's right, because you were excluded as an expert in that case, correct?
Correct. That's what I said.
Okay. Now, let's talk about this case for a minute. You gave a statistical opinion in that case, didn't you?
I did.
And the court discredited you based on your lack of qualifications to give a statistical analysis, correct?
I don't believe so, but you could point me to the paragraph
Sure.
that says that.
I'm happy to do it. Let's take a look at page 6. I'll read it aloud. Many of the criticisms leveled at Speckin by the Wayne court could also serve as a basis for this court's conclusion that, based on the standards imposed by Daubert, Speckin's testimony is inadmissible in this case. Ultimately, however, the court finds two particular grounds especially compelling and independently sufficient to justify its conclusion. And the first being Speckin's statistical analysis is deeply suspect. Now, I ask you again, you were excluded from testifying in that case because your statistical analysis was suspect, correct?
The analysis at one standard deviation. Yeah, I thought you asked me if because of my knowledge. I
Is a
misunderstood.
yes, no, we're fine. Your Honor, I move exhibits 40 and 48 into evidence.
So he's been qualified as expert many, many times, many countries, many
Objection.
places, but they're trying to do some credential busting to pick out a couple areas where in some
You're
cases
admitted.
the judges didn't appreciate him as an expert. Maybe not because of
Now,
his knowledge
let's
at all,
walk
but just
through-
because of
I want to revisit
its
the Wang case.
applicability to the
And let's
case.
walk through the information that the trial court
So,
said
okay, whatever. You single them out, whatever.
and that the
Throw that
appellate
away.
court found
Meaningless.
it would be perverse to have concluded that you could be an expert otherwise. They conclude in the Wang case, he did not study, well, actually, handing you what's been marked as Exhibit 40.
Walking around, flipping
Exhibit
through
43
papers.
is a copy of a decision from the Court of First Instance
Another one. Okay.
in the Wang case. Do you see that?
I do.
Can you please turn to page 211? Just let me know when you're there.
I'm there.
Now, at paragraph 29.5, the trial court in Hong Kong said he did not study statistics either in his BA degree, and that is why he was not awarded a BSc degree. He is plainly deficient in his knowledge of statistics and chromatography disciplines, one would have thought essential for an analytical chemist, essentially one who offers himself to the court as an expert, even more so for one who claims to be that one of the world's leading experts in one particular branch of analytical chemistry, i.e. ink analysis. Did I read that correctly?
You did.
And do you disagree with that statement?
Absolutely.
Let's go to 29.8. Same page. He attempted to magnify his experience by claiming to have examined over 100,000 documents. When the sheer mathematical impossibility of this was pointed out to him, as it would have taken him 274 years to do it, he claimed that simply flicking over pages looking for something else amounted to an examination. Remember giving that testimony?
Absolutely not what I said.
Didn't tell the court that, in your opinion, that you flipping over the pages amounts to an examination.
That's absolutely correct. I did not say that.
Okay. Goes on to read, obviously has examined many documents in his short experience, but there's no way that this court can evaluate the extent or depth of that experience. This lack of experience may account for the reason why neither he himself nor his laboratory are included in ASTM's directory of scientific technical consultants and expert witnesses. Did I read that correctly?
You did?
Now, other courts have taken issue with what they consider to be misrepresentations about your experience, correct?
I can recall one court that sent me a letter.
Uh-huh.
Clarified with the judge by replying. But that's the only time I can think of that.
Okay. Your Honor, I move into evidence exhibits 43.
Any objection on 43?
There you are.
43 will be admitted. You may.
Thank you. Okay, that's been marked as exhibit 41.
I do?
Is this the letter you were just referring to?
Yes.
And this is a letter that was sent to you from the 13th Judicial Circuit from a judge, Philip E. Rogers Jr., Circuit Court Judge. You see that?
I do?
And this was a case called People versus Douglas William Adrian, correct?
Yes.
And you were appointed as an expert by the court in that case, correct?
Yes, the court appointed me as the expert. That's
Court
exactly
appointed
correct.
you.
That's
Right, and
exactly
this is a letter
correct,
from the
he
court
says,
that
yeah.
appointed you.
That's exactly right.
Nailed
The
it.
first sentence
They
says,
did.
the court authorized your retention to provide expert witness services to this defendant. Next paragraph. However, I was extremely disappointed in your presentation. While I initially found you barely qualified to offer an expert opinion in this case, upon the completion of your examination, I came to the conclusion that I had made an error. The last paragraph on that page says, you also need to address the issues associated with your resume. You certainly did the defendant no good whatsoever when you were confronted with an affidavit to which a Lawyer's Weekly article had been attached. This was a clear indication to the court and the jury that you countenanced an overblown statement of your credentials as they related to your work with the IRS and the Secret Service. You recall reading that when you saw it or when you received it?
Of course.
I move exhibit 41 into evidence, Your Honor.
Any objection?
So the judge didn't like the presentation.
41's admitted.
Now, you testified earlier, I think I heard correctly,
Another one? Come
that
on.
you were a part, you gave testimony before one or both chambers of the legislature in Arizona.
Yes, I said I wasn't sure. I thought it was.
Yeah,
at the
of
same
course.
time, but
Yeah,
I said
one
that.
or both.
Yes, I said that.
That was when?
I don't remember the date, a couple months ago.
Okay. And that was in connection with work that you performed for an audit in 2020, right?
I don't know if I would say audit. It was work that I performed on the 2020 ballots.
Was that related to what might be commonly referred to the Cyber Ninjas audit? Does that sound familiar?
Well, it was completely different from what they were doing. It was happening at the same period of time. So in that sense related, I mean, I wasn't working for them and they weren't working for me.
And your ultimate conclusion in connection with your findings was that you couldn't really make a conclusion. You needed more information, correct?
I wouldn't say that, no.
Okay.
You may.
Handed you what's been marked as Exhibit 38. You recognize this?
I do?
Did you create this?
Did?
And this is your executive summary related to the work we're discussing now, correct?
Right. I testified to more districts in front of Arizona, but specifically related to what happened in Arizona. This is the summary.
Okay. Your Honor, I move Exhibit 38 in evidence.
Objection?
There, Your Honor.
Okay,
38 submitted.
thank you, Your Honor. Okay, can we please turn to the second to last page of this exhibit?
It's two-sided. Do you mean, what is the first word at the top?
The first word at the top is going to be when the contents of the box were examined.
I'm there.
You there? All right, let's go to the bottom. You see the section that says summary and discussion of further forensic review.
Yes?
Based on the forensic findings, it is my opinion that further work and review of the ballots, or the images at a minimum, should be conducted to determine what significance these findings have on the whole of the ballots cast, as well as possible statistical significance of the votes contained for a particular ballot item. Did I read that correctly?
Absolutely.
This is your conclusion.
Well, that's one of many, but you read that
The
correctly.
conclusion then was that more work needs to be done.
Well, it's my conclusion I would do more work.
Okay, now, the testimony, and I'm calling it testimony loosely, I understand. I don't know whether you're under oath, I wasn't there and you didn't say you were. But the testimony you gave recently in front of the legislature, okay, you with me so far?
Yeah, I know what you're
All
talking
right,
about.
good. You were invited by whom to give that testimony? Liz Harris?
No.
No?
Sonny something?
Sonny Boreelli?
That sounds right.
Okay.
Yes, I think so. I think that's the name.
I think we might want an
And when you were
objection.
there,
Where are we
you
going with all
told the
this?
legislature,
What's
you
the
couldn't
relevance
determine
of
for
this?
sure if any votes in that election that you were reviewing were illegally counted. Fair?
I don't recall saying that, but I would say that if I were asked the question now. I don't have independent recollection to that.
Do we talk about
statement,
this on
But
But
direct
it's a fair
exam?
statement.
And based on what you've reviewed in connection with the opinion you've given today with the 2022 general election, that would also be your answer, correct? You can't say with any certainty that an improper vote was illegally counted or rejected.
I can't say one way or the other. I'm not drawing opinion that it was or was not.
Okay. Are you aware that after that hearing you testified at, the representative was eventually expelled from the House of Representatives for that hearing?
Did we get into this at all?
Something in my travels this week that someone came in and was,
Should be objections on this.
I don't know what the word is. Maybe you have a better word than me. Ultra excited. And I don't know. I wasn't there. and I haven't seen
Objection,
it. I'm
totally
not trying
outside
to be
the
funny. I just
scope,
don't want
totally
to use an
irrelevant,
inflammatory
unrelated
word.
to anything here.
But something like that, and then the person who invited him got in big trouble. I didn't know the extent
that
of the
to do with
trouble, or
signatures?
maybe remember it, but I heard
That's
something about
cartel
it.
Katie.
Now, forensic, okay, that word, that means the application of scientific principles to legal cases, right?
That's what it means to me in forensic science, yes.
Okay. Now, ultimately, the opinions you gave today through your testimony, they are based on a set of assumptions. Fair?
Spreadsheets. Say spreadsheets.
Objection, Your Honor.
Oh, there we go. We get one.
Would ask that the witness say, or counsel lay a foundation for what assumptions he's referring to.
Well, he can answer if he understands. If he doesn't understand, we can have it rephrased.
I understand the question. I'm just taking time to think what the assumptions could be because I don't
Yeah,
have.
take your time.
Give me just a second.
Sure, take your time.
Your Honor, may I also ask that counsel stop interrupting witness and let him finish his answer?
If I'm doing that, Your Honor, I apologize. I'll be better.
For the sake of my court reporter too, please.
And slower.
Both question and answer need to slow down, please.
Of course.
I think I'm equally at fault for the pace, so we can share.
You all have better places to be, Mr. Speckin.
I agree with you. I'm at a loss as to what an assumption would be. I'm not saying there aren't any,
Okay.
but I can't think of one, and I'm not sure if I'm missing an obvious one, but perhaps you can
Sure.
give me an example and I can run from there.
Well, your opinion assumes the information you were given is adequate. It's correct.
Oh, in other words, what was asked for is what was given by the county? That's
Yeah,
an
boom.
assumption.
Right
Yes,
answer.
That's
Boom.
true.
Yeah, it came from
And
you.
it assumes the people you spoke with told you the truth, for example.
At the county?
I
Yeah.
would say assume, yeah, I see where you're going. It would assume that the totality, not only of the people that I spoke to, but the other witnesses, the videos and all that would corroborate one another, which I believe it does, but could there be one aspect that doesn't? I can't say.
In general, assumption then is that the information that you've relied on, that you testified to today, that you relied on in forming your opinion here, the assumption is that all of that's accurate, it's reliable. Is that a fair statement?
Objection, Your Honor. I just don't know what opinion he's referring to. I would just ask that he would clarify and be specific.
Okay, if there's a specific opinion, you can rephrase it if you mean all the opinions.
I mean every one of them, Judge.
And re-ask the question so that he understands that.
Thank you, Your Honor. With respect to every opinion you've given here today, whatever it may be, you would agree with me that an underlying assumption, as I've been using the term, that a foundation, if you will, to the accuracy of your opinion is that the information you relied on to form that opinion was accurate and reliable. Is that a fair statement?
That the foundation for that specific opinion
Correct.
would be. Not everything that you gave me that I said I evaluated is the foundation for every
We're
opinion.
on the same page. It was a general question. I think we're on the same page. So it must follow then that if with respect to any specific information you relied on in connection with any specific opinion you gave today, if that information is unreliable, then your opinion is unreliable to that extent as well, correct?
To whatever limited extent or large extent.
Is unreliable to that extent as well, correct?
To whatever limited extent or large extent, depending on the nature of the unreliability or questioned, it could have a small to negligible impact to a large impact. That is correct. It would be variable as to the exact situation.
And you'll agree with me, and I think you said this a moment ago, and I appreciate the candor. At this point, with respect to this case and your opinion on the 2022 or 2022 general election, you really can't say one way or the other based on what you've reviewed, whether a single vote was improperly counted, one way or the other. Fair?
I'm not here to draw that opinion, and I'm not saying that.
You're not here to, so you're not giving an opinion on that.
I have not, and I intend not to, if at all possible. That is correct.
Okay, thank you. You agree with me that one relevant factor in your analysis here today with respect to your opinion as it relates to Exhibit 48,
The table?
the table, is that Exhibit 48? 47, thank you. Exhibit 47, okay? You'll agree with me with respect to your opinion as it relates to Exhibit 47. One factor relevant to that is the number of employees, either full-time or part-time, that Maricopa County had engaged or hired to do the ballot signature comparison. Fair?
Not sure about one factor. I mean, the more they employed, the more pieces of paper it took up, if you mean that. If they had less, it'd be a smaller table. If they had more, it'd be a bigger table.
Okay, fair enough. Do you know how many employees Maricopa County hired to engage in ballot signature comparisons in the 2022 election?
For ballot signature comparisons,
Yes.
based on the data and the testimony, was 155.
Okay.
I didn't specifically mean the testimony of Mr. Valenzuela, or Ray, as he has to be referred to, 155 in this jive, or
Okay.
a line, I should say.
Now, I don't know that I heard this on direct. Who retained you to give testimony in this action?
My retainer agreement's with Mr. Olson.
With Kurt Olson?
Yes.
Okay, counsel.
Yes, the person who's asking me the question.
Yeah, and you're being paid for your testimony?
I'm being paid for my time away from my family and my time involved in the case.
As you should be. How much you being paid?
The hourly rate my firm bills is $600 an hour for my time.
Okay.
For every minute spent, whether it's in travel or here, I'm not charging for the time that I'm sleeping and things like that.
And you'll agree with me that your job, essentially your gig, is you're a professional expert witness, fair?
I would I wouldn't pigeonhole myself that narrow that that's what my whole life is about, but that is the source of where I go to work every day. And that is what I do for the hours in the day when I'm not being a husband, father, and that sort of thing. Yes.
Right. And you testified you're a forensic document analyst. Am I saying that right?
Yes, I said forensic document analyst and chemist.
Okay. And chemist, that your undergraduate degree, now remind me, that's a Bachelor of Arts,
Yes, from the College of Natural Science with a major in chemistry.
not a Bachelor of Science.
It is not a Bachelor of Science.
And now forensic document analyst, that a title you just gave yourself?
No, it's a common title that's used by people in my profession with the similar background and training that I have.
And no regulatory organization gave you that title, correct?
That's right.
And there's no specific licensing requirement to call oneself a forensic document analyst, correct?
I agree, yes.
And you weren't conferred a forensic document analyst by any organization or school, correct?
I would say no, I was not. Would be fair, yes. I mean, I've been called that by organizations, but not conferred that. So the answer to the question is I have not. That's right.
But you'll agree with me that essentially in your line of work, you can call yourself whatever you want, right?
Could I call myself whatever I want? Sure.
Right.
I mean,
It's
in court,
2023,
the object
baby.
is you have to be
You can
proven to
identify
back
however
that
you
up,
want to
which
in
I
this
have
country.
hundreds of times. But yes, I could call myself what I want, I think. I mean, I wouldn't call myself a doctor or a lawyer, but I mean.
Or an
Related,
Apache
yes.
attack helicopter, maybe, huh?
You're
Sometimes
related
I
to a
feel like
doctor or a
that.
lawyer? I'm sorry.
No, related to what I do.
My condolences if you are.
I don't think I am. That's not what I meant. I'm sorry.
You don't have a formal degree in any sort of forensic document analysis, fair?
Fair. True and true.
And true. And you're not certified as a document examiner or a signature comparison person, fair?
Fair and true. Yes,
And you aren't, sir, have you heard of the American Board of Forensic Document Examiners?
I have.
And do they give a certification of any kind for forensic document analysts?
I think they call it forensic document examiners based on the name. I don't have that, but I believe that's what they call it.
And you don't have that as well, correct?
Correct. I do not.
Okay. Now, at one point, were you a member of the American Academy of Forensic Scientists?
I was.
And as a member, you had an ethics complaint lodged against you. Does that sound right?
I did.
And shortly after that, you no longer continued to be a part of that group. You didn't renew your membership, correct?
That's exactly correct.
Okay. How many, you testified earlier that you'd taken some training courses, continuing education, is that what they are?
Sorry, when you turn around, I have a hard time hearing.
Fair
the
enough.
middle.
No, that's fair. That's fair. My apologies. I'm sorry.
That's all right.
You testified earlier, I think, that you've taken some training courses. Did I hear that correctly?
Yes, continuing education was the other
Okay.
thing. Yeah, I agree with that.
And none of those continuing education courses were in connection with determining how long someone who is working for an election department, state or county, can or should take to review signatures in compliance with the law. Is that a fair statement?
That's fair
Okay.
and true.
How many of your training courses were specifically on the speed it takes to verify signatures?
There were none of the training courses that I had or have taken that exact topic was covered.
Okay. Can I have a moment, Your Honor, to confer with counsel? I may be finished.
Okay.
Thank you, Your Honor. So I want to talk for a moment again about the assumptions we were talking about earlier. Do you remember that conversation?
Do.
Now, you'll agree with me that a pretty critical assumption, if you will, in connection with your testimony related to the table exhibit. You know what I'm talking about? The table of the, you call it the click-through table?
I didn't call it that. I know what table you mean because there's only been one.
Right, right.
But when you said the critical assumption, I'm not.
I haven't
sure.
gotten to it yet. I'm
Oh.
I'm asking the question. I just want to make sure we're on the same page, Mr. Speckin. Are we on the same page so far?
Same page, meaning I know the table that you're talking
Yes.
about, whatever title you give it.
Correct.
Exhibit whatever.
Exhibit, sorry, Your Honor, Exhibit
47?
47, yes.
Thank you.
You'll agree with me that an important assumption there in the conclusions that you reach based on that exhibit is that in fact, the act of a signature verification, one way or the other, occurred. I should say signature comparison occurred.
Well, first, there's one problem with the question, and I'll just try to shortcut it if you'll let me.
Of course.
And that is, you said my opinion was based on the table, and that's not exactly true. As we know, it's a demonstrative, so I had the opinion the table is demonstrating it.
Sure.
I'm not trying to be nitpicky, I'm just saying.
That's fair.
The second part is you said that it's, I don't totally understand it, that it's based
Try again.
on.
Yeah, if you mind, because
Yes, please.
it's my fault.
Oh, no, it's fine. It's fine.
You'll agree with me that in order to reach any conclusion about the speed, one way or the other, with respect to what's being shown in Exhibit 47, that assume that in fact, the act of a signature comparison, whether you agree with whether it was adequate or not, the act of the signature comparison occurred.
I understand what you're saying. So yes, it does assume that the keystroke that's being logged from the computer and timestamped is the action of some sort, whether it be a pass, a fail, a spousal exception, a no signature, a curing, whatever. There's a lot of different codes.
Sure.
But it's entering a code that relates to the signature verification process. And that was told in the response, and that's what was asked for, but I'm assuming that's what it is. You're right.
Perfect. Thank you. Your Honor, for the Secretary of State, there are no further questions. I do believe Maricopa County might have a couple.
Okay. All right. So, Mr. LaRue, you have cross-examination as well?
I do, just very brief, Your Honor.
It's going pretty fast. We might get into their witness today.
Good afternoon, Mr. Speckin. How are you?
I'm good.
Good. I have just a few questions for you, and I just want to be sure that the record is clear is why I'm asking them. You alluded to some of this earlier, but I'm asking the direct questions because, as I said, I want to be sure that it's in the record clearly. You've never, well, strike that. Earlier, you were, in your testimony, you were talking about comparing signatures. Do you remember using that terminology?
Yes, I remember the word compare many, many times.
Okay. You've never compared signatures for elections under ARS 16550, have you?
Correct, I have not.
Okay. In fact, in general, when you're called to give an expert opinion about signature comparison, it generally has to do with fraud or areas such as that, not elections. Is that correct?
There aren't many election claims.
But it is not a large percent of my overall body of cases based on handwriting. That's a true statement.
Would you say that the majority of your cases relate to fraud?
I'm not a fan of the term because it has a predisposed connotation. Perhaps determining if there was fraud, dishonesty, whatever. It's an inflammatory term, and I try not to use that in my life, let alone when I'm testifying. I get what you're saying, and I would answer generally yes. I just don't like the term fraud, but I know what you mean.
Okay, fair enough. How would you describe it?
It's trying to determine if forensic science can assist the trier of the fact with a specific question, whether somebody did or did not do something, or whether somebody did or did not write something, as we're talking in this case. In other cases, it could be when it was written, altered, changed, added to, all those things that I talked about, but I don't think you want to rehash them. But specific to handwriting, did they or did they not? I don't use the word fraud in my opinion, like, since my opinion is this, it's a fraud. Like, I would never do that.
Okay, I understand. I'm going to use the word fraud because we both I think you just testified, you understand what I'm meaning when I say that, even if it's not your preferred term for getting at this. Is that correct?
I'm fine answering your questions as long as you understand it's not a term that I would use, but I know what you mean.
Okay.
I'll do my best to answer it in that context.
Fair enough. Thank you. Is there a set number of signature exemplars that you are supposed to use when you do fraud examinations?
Back what we said about, there was an argument earlier about best practices or wish lists or wanna haves. There's an idea that I would like to get, but not a standard of must have. I mean, you must have one unless you're comparing multiple signatures at issue to one another, like I talked about on a ballot or a petition, which is a different scenario. But you can do it with one.
Is
have a wish list, personally, yes.
Do you know if there's an industry best practices standard?
Yes, there is.
And what is that?
An amount sufficient to make a determination.
Okay.
So it's not a numerical amount, just for the reason that I said.
Okay. Would you agree with me that, strike that.
So it's a general standard. It's not a 1
When
second, 5 seconds, 3
you are
seconds, whatever.
Doing a signature comparison for purposes of a fraud determination, say for a bank or, on a check or whatever the case may be. Would you agree that the more exemplars you have, the better?
Oh, absolutely. I mean, with obvious certain limitations and ridiculous exceptions, but as a general term, 10 is better than 5, 6 is better than 3. I agree.
Okay. When you do that type of signature comparison that you and I are talking about right now for a fraud examination, say for a bank with a check that may have been fraudulently written, if you have 10 signature exemplars, is best practices to look at all 10?
If you are satisfied that those 10 are known signatures, absolutely.
Would you agree with me that if you're doing a signature comparison and you look at 10 signatures, that will take longer than if you look at 2 signatures?
It absolutely should.
And you would agree it would take longer than if you look at 1?
It absolutely should, yes.
You may not know the answer to this, and it is perfectly fine to say, I do not know. I'm not trying to lead you to say something that you don't know, okay? But are you aware of whether under Arizona law, those who do signature comparison for early ballots are required to look at a set number of exemplars?
Well, the only standards that I'm familiar with would be the EPM and the 16550A, I believe.
That's the Arizona
You're nodding your head,
Elections
so I think I got that right.
Procedure Manual.
And in those two, I'm not aware of a numerical
and this
requirement, just like in the standards in my field, that's set forth. You could surprise me and tell me there is one that I didn't see, but I'm not aware of one.
I
don't know if there's other laws in Arizona that pertain, so I have no way to answer that question other than those two.
Okay, fair enough. Very good. I want to go back to the table for just a moment, and it's the only table we've been discussing. So you're aware of what table I'm speaking of, correct?
I got you. Yeah.
Okay. As you see here right now, can you say with 100% certainty that any of the workers that were identified in column 1 failed to conduct signature verification.
Objection, Your Honor. The table has a number of references. Are you referring to the whole table or with respect to certain rates?
I'm referring to the table as a whole. Sorry, I turned around and I realized my voice may trail off. I'm referring to the table as a whole. The left column has workers, and there were a number of workers listed, and then there were lines going across saying, left column has workers, and there were a number of workers listed, and then there were lines going across saying, you know, less than so many signatures, less than so many seconds, less than so many seconds, less than so many seconds. My question is, the table as a whole, the workers on that table, can you say, as you said here, with 100% certainty that any of those workers did not conduct signature verification? Any of them?
I don't believe any of my opinions today are expressed to 100% certainty, nor can I think of any in the last 30 years that I've expressed to a 100% certainty. I generally like inflammatory terms. I try to stay away from 100% as well.
Okay. And I realize based on the answer you just gave, and I know what your next answer will be, but so that the record is clear, and then I'm done, Your Honor. As you sit here today, can you say with 100% certainty that no signature verification occurred in Maricopa County for the 2022 general election?
I would say the same answer for the same reasons, meaning no, I would not say that.
Thank you, Your Honor.
Okay. Is there any other cross-examination by any other defendant? Very well. Okay. Redirect, Mr. Olson.
Thank you. Mr. Speckin, you were asked a number of questions where your answer was cut off regarding some cases in which you had been criticized. Was there anything that you wanted to say that you were not able to say?
Well, yes, like for instance, the letter from the judge that he read from the 13th Circuit, he skipped over the paragraph that says you clearly have some specialized knowledge and training with regard to ink identification and document examination. Your experience in grease analysis, which is what I was appointed as an expert in that case, is woefully lacking. I never disputed it in that trial. I don't dispute it today. I'm not an expert in grease. In that case, I testified to FTIR results.
Nice.
As a chemist, that's what I look at. I was trained in that as part of my education. I do that. It was a very simple analysis. The judge didn't like the bill and wrote me this letter. I wrote a letter back. That was the end of the issue. I've testified in this jurisdiction, but again, I mean, the judge even says here, I have specialized knowledge, skipping ahead to document examination. It was unfair the way it was read, and I understand it's cross-examination, but that's how it goes.
Any of the other cases that were presented in front of you that you'd like to comment on? One of the opinions was quite lengthy.
Well, the Hong Kong opinion, I got thrown a Court of Appeals opinion. It's this thick, double-sided, and asked if I could point to a paragraph that said something to the opposite. Obviously, I can't, as I sit here right now. I read one because I knew where it was.
And what, could you read that again? And
I'm not sure I can, oh, that's the wrong one. Let me correct my answer and say, this is one that was handed to me from the Court of Final Appeal, not the one.
which exhibit number is that, sir?
This is 48. And there are, I'm not an expert in legal opinions, especially from Hong Kong, nor am I from the United States, but definitely not Hong Kong. I can tell you that It appears that different judges wrote different things like our Supreme Court does in some occasions. I don't know that for certain. That's just the way I take it. But the paragraph that I read just says an extraordinarily large portion consisted of pages copied verbatim from the submissions. Like in one of the paragraphs that he read from the opinion, it had the number 2, which he didn't read because it's not an audible sound, because it was actually copied a typo from the previous ones. It talked about a testimony of 100,000 examinations. It isn't at all what I said. It was quoting a testimony from a case in Tulsa, Oklahoma, called Utica Square versus Renbergs that I had testified on in 1998 about a case that I had looked at for General Motors, and there were 100,000 documents involved in the case. Then they twist the words without including the transcript and put it in their submission to the judge, and the judge photocopied it. It's completely unfair. It's from over 20 years ago. I mean, I don't know what else to say. It's demeaning and upsetting, and it's not at all a reflection of what happened, but that's just my opinion.
Good.
Any
Opportunity
other
to
opinions
defend
that were
himself.
put in front of you that you'd like to comment on?
The last one was the EEOC opinion, and if you read the last part of the opinion, it wasn't that I'm not an expert at all. It says, I'll just read it exactly so I don't paraphrase it incorrectly. Speckin's deposition testimony suggests there may be other methods to determine age that would be admissible in this case, but and go on to say, I'll just paraphrase and say, but I didn't have them in that case. There's only one method, and the judge said that method was not allowable. Keeping in mind, that's what everybody uses today, by the way.
You've qualified as an expert, I believe, and I don't want to go through everything, but you've qualified as an expert in hundreds of cases, correct?
Multiple hundreds of cases in court, yes.
And that's with respect to forensic document examination and handwriting analysis?
Yes, and ink dating, yes.
And you've also been retained by various government agencies to
Yes,
give opinions about forensic document analysis and handwriting analysis?
yes, and continue to be.
Council asked you some questions about the touches with respect to the data that MAricopa provided. Do you recall what?
Sure.
So that's what I want to refer to. And I believe you've probably seen in some of the testimony yesterday, there is the notion that the signature verifier will go back and check the batch of signatures that they have already compared as part of the cross-check. Do you recall that?
I remember that testimony, yes. That was from Mr. Valenzuela.
Yeah. And when the reviewer, the verifier is going back, does that result in a change that's reflected in the data?
Objection, Your Honor. I think this is beyond the scope of my cross-examination.
I don't believe it is.
Fair enough.
Thank you.
No, the request was for keystrokes of determinative outcomes, good signature, bad signature in simple terms, and there's others, and a date and timestamp associated with those. It's not date timestamping, left and right arrows, scrolling, things like that. But you do see when people are going very fast, times where there's 200 seconds with nothing, that could very well be that time when someone might be scrolling back in 150 seconds, 200 seconds, whatever the case may be. And it's not logging a keystroke for that. It's just a long period of time where it doesn't log any keystrokes because there were no determinative outcomes.
So if a signature verifier is going back to review their work and not making any changes, but just going back quickly without making changes, that activity is not reflected in the data that MAricopa County provided.
Other than the increase in time for those two sequential keystroke entries, the last one before they scrolled back, and the first one, perhaps when they start a new batch, or change one very far into the batch. I mean, I don't know what they did, but it's only by a lag of seconds. It's not date time stamping those right, left scrolling clicks, whatever you want to call them.
So does the act of going back without making a change affect the rate of comparison as reflected in your analysis and in what was reflected in Exhibit 47?
No, 47 is not affected at all by whether someone did or did not scroll back, how fast they scrolled back, nothing like that.
I'd like to pull Exhibit 21. And Your Honor, if I may, can I get that exhibit and give a hard copy to the witness? It may be just easier. This is the it's a set of emails.
I don't think that's exhibit.
If you want to use Exhibit 21 to show him?
Yes, Your Honor. I want to make sure it's the right number.
Exhibit 21 was that public records request that we heard Valenzuela talk a little bit about, public relations request 1482 and various communications. I think they're a set of emails.
Mr. Speckin, you've just been handed Exhibit 21, which the first two pages are the original public request sent to Maricopa County on February 3rd, 2023, which underpins the data that was ultimately received in PR 1482, which underpins the data that you have drawn for your opinion, correct?
Yes,
Have you seen this document before?
I have.
Is there anything in this document that assures you that the data that Maricopa sent was complete for purposes of your analysis and opinion?
Yes, there are multiple responses to the request saying this fulfills your request. This is what it is, to that effect, that it fulfills the request of what you're requesting. And nothing to the contrary.
And what was the data that was being requested as it relates to the opinions you have offered here today and the data that is reflected in Exhibit 47?
The data that's reflected in 47 is the unique identifier. So that would be the worker, the anonymized user number for the worker, and the calculation from the date timestamp as to how much time elapsed between successive entries of date and timestamp, and then what the disposition is. That's where the percentage comes from. What percentage?
You okay?
Yeah. I have a new hip and it just popped out. So I think it just popped back in. So we're okay. It just didn't feel good for a second. Sorry.
Oh, no.
Okay, if it's your hip.
Yeah, no, I'm fine now.
His hip just
Stand
popped
up and
out.
stretch?
I think that's the last thing I want to do, Your Honor, but thank you.
Okay, well, hold on a
Man,
second.
there's a lot of stress in these trials, man.
Take a break.
A lot of
No, thank
pressure.
you. It just got me for a second there. It
People's
was like
joints
a
popping out.
stabbing pain. Sorry. I wasn't trying to give anyone else a panic.
Like a pressure cooker.
Well, I'm just trying to make sure, number one,
Gosh.
you're okay.
Let me
I'm
pop
okay,
it
Your
back
Honor.
in. One second,
you.
Judge.
You're under stress and you don't need a break because I'll give you one if you want.
No, I'm good. I'm good now. Thank you.
But just continue.
Pop it back in. Let's go.
Okay.
Pop your hip back in.
I'm
Walk
sorry.
it off.
Before that, what was the question? I don't remember.
You don't need to apologize. He's going to ask another question.
Man, I hope he's okay for real. That got to be painful.
The data that
Sheesh.
that Maricopa produced in connection with PRR 1482, you were referring to certain data. If you turn to the page identified at the bottom right-hand corner, Lake 21, 896, and then 897, we'll move to that as well. And this is a document that's in reverse chron order, correct? The email string?
Right. It's an email string with the newest at the top or the front.
And do you see at where it says Lake 21, 896 at the bottom right-hand corner?
Yes, I'm there.
Okay, and if you move to the top of the page, you see it's cutting off. And so it's, as you go in reverse chron order and you flip to forward to 895, where it has at the bottom of 895 a date on 5/4/2023, PRR MCRO wrote Good afternoon, we the people.
Yes, I see that.
So flip back over. Do you see that on 896? That's part of the Maricopa's response to we the people.
Right, the May 4th, 3:47 PM response continues on to the top of 896. I follow.
And do you see the 5 items of data?
Yes.
Okay. Is this the data, or at least some of it, the data that underpins your opinions and the data reflected in Exhibit 47?
Yes, specifically points 2, 3, and 4.
Do you have any reason to believe that the data in points 2, 3, and 4 that Maricopa provided was not complete and accurate?
No.
Turning to the Exhibit 47. Mr. LaRue asked you some questions about the overall chart that was displayed here and your opinions thereon, and said, can you say with 100% certainty that every vote, I've got his exact words, but not every vote was properly counted or some such. Do you recall that?
I remember the 2 questions about 100%. Yes.
Okay. Are you offering an opinion as to whether or not a signature can be compared in 6 seconds or less?
I didn't express such an opinion. I have one, but I didn't express that. No.
But you didn't offer and express an opinion on that.
Correct.
Are you offering an opinion as to whether or not a signature can be compared in 4 seconds or less?
No, I didn't offer an opinion on that.
The opinion that you offered was with respect to comparing a signature, I think as we used before in simple terms, less than 3 seconds, correct?
That was the opinion that I expressed, and further with less than 2 seconds, you asked me as well.
And your opinion was that it was not possible to compare signatures in less than 3 seconds in the context of why we're here today, correct?
On the mass scale context, I said it cannot be done. Could you pick one time out of 10,000 where someone could do that? Maybe you could, but not on a mass scale, like in the thousands and thousands. No, it's my opinion, you cannot do that. You cannot do a comparison in that time.
That's good. That's what we need.
Mr. LaRue asked you some questions about
the whole process is invalid.
Having more than one reference signature. Do you recall that?
I do.
Is your opinion predicated on the existence of more than one reference signature, or that it is one signature from a ballot envelope compared to one reference signature?
Well, my opinion is not predicated on either. I gave the benefit of the doubt saying the time of only comparing one. Clearly in 2 seconds, you're not scrolling and finding 3 and comparing all 3 in 2 seconds. That's even more preposterous. But that wasn't what the opinion was based on. It's that you can't even compare one in that time. Obviously, it follows you can't compare 2, 3, or 4, because as I answered his question, that obviously takes more time.
We need something like the whole process is so bad that it's as though it wasn't done.
Opinion on the inability to compare 2 signatures in the context of the system that Maricopa County has employed for the 2022 general election?
My education, training, and experience. I mean, that manual or the training program does a nice job of spelling out the basics of what you would look for in handwriting. It's what I would look for. I know what to look for. I do this every day. I can't believe there could be thousands of people, and I'm not trying to be offensive when I say this, in Maricopa County that don't do this every day and had a 4-hour training or a 40-hour training that can do it so much faster than I ever could. I don't believe that. No.
So based on your observations, would you
In
say that
terms
signature
of
verification was completed in
The
Maricopa
training that
County?
you saw, Maricopa gives signature verification workers to compare handwriting. You recall that?
I recall the training, yes.
Are you saying that the time to compare a signature for a signature verifier would have to follow, for example, all 11 steps in order to be a valid comparison?
No, I'm not assuming they would have to follow all 11 steps. I mean, it's a guideline. I have guidelines in my industry in which in certain instances, you might not follow all 11 or all the steps. I understand that. Specifically, if you have an exception, I'm not going to say that word. If you have a fail, if you see that two are drastically different very quickly, that could be a fail quickly. I understand that. What is in this table and what we're talking about are the times and the percentages where it's passing, where people are saying they compared and they're consistent.
When you say they, you mean they compared the two signatures and came to a determination that the two signatures were consistent.
Right, the ballot envelope, and whether it be one or more, but at least one of the historical exemplars, I think is what people call it, reference exemplars.
And when you use the term compare, are you using that in the sense of what we see, talked about the steps of signature comparison, or as the term compare is used in the normal English language under the definition, say in Webster's, of compare?
So when I say compare, I'm not saying you have to follow the 11-step procedure to make a comparison. I'm using the word compare as you use in the English language, but it's also the same that I use, and they're in the standards in my industry of compare. To look closely to determine if two things, or in this case signatures, are similar or dissimilar, or in the form of 1550, consistent or inconsistent is the way it's phrased there.
So merely because two signatures flash up on a screen, is that a comparison in your mind?
That's my point. It's not.
And why is that?
It would be like thumbing through this opinion like this and saying, I just read it. I say I read it and you say you didn't, and you're arguing. The simple fact is no one could read it that fast. No one that I've ever encountered in my life could read it that fast. So the answer is you did not read it.
We're talking about things that didn't happen now, right? And it's got to be tied back to a bigger, broad, disqualifying.
I must hesitate to say this, but I'll just say thank you. We have no further questions at this time.
Okay. I was just going to say,
Can we excuse the witness?
I have nothing further for the witness, Your Honor. Thank you.
I was wanting to
Thank
see
you,
him bring it
Mr.
all the way
Speckin.
back.
Are you okay to stand up?
We're going to know in a second.
Well, don't, wait a minute.
Yeah,
We're not doing it that way. Let's not just see and find out. Let's.
I'm okay.
I'm good.
I had a good doctor. It's fine.
I got to imagine this guy's in pain, man. I don't know
Thank you for
what
the
that
concern,
feels
man.
like.
Surprisingly, it's good.
Watch your step.
Thank you.
Your Honor, would the court like me to retrieve the exhibits and put them back?
Yes, please. That'll be fine.
Afterwards?
Yes, you can do that.
He's on his feet. He's up.
Do you have any other witnesses?
He made it.
You're not, Your Honor.
Okay, so plaintiffs rest.
You do, Your Honor.
That's it.
Coincidentally, this is the time we'll take the afternoon recess. Okay, for 15 minutes, and then we'll come back and I'll address defendants.
All right. Looks like that's about it. We're wrapping it up, and we're going to see if we get into the defense testimony today. I think we should. We got plenty of time left. It's not even 3 o'clock. So what I wanted to see was coming full circle. Remember, The judge has said in his under advisement ruling, and again, that Kari Lake needs to show. All right, sorry, Judge, didn't mean to. No disrespect. All right, sorry. Stop talking. Stop talking. All right, please be seated. The distinction here is that we can't just show that the process was bad. We can't just show that a bunch of people clicked around. We can't just show that maybe some signatures got problematic. We can't say that 150,000 of these should be disqualified. Like, all those are great arguments, right? Yeah, maybe 150,000 of them should be disqualified, and that does change the outcome because it's bigger than the margin. But the judge is not considering those arguments, okay, individually. So you might be able to go in and say, yeah, there are 50,000, 100,000 ballot, whatever it is, or this person inserted whatever. But that is not the threshold that we've got right now. The judge has said that you've got to show that there essentially was no signature verification. So the theory is you've got to bundle all of this up into a conclusory statement that there, practically speaking, there was no signature verification that occurred. Why? Well, because they were verifying things at level 1. They got pumped up to level 2. Then they got kicked back down. We heard that from Jacqueline. We heard from Andy Myers that there was just not enough processing capability. In the primaries, they were busy. In the generals, they were not. They were there to work later, and then they got booted out. There were other problems with just the sheer volume. We saw the numbers and the different calculations, and we heard the different indicia, 11 different indicia. We saw all of the click, click, click from Stephen the Pecker and all of it. But we've got to bundle it all up to say that in totality, it's so catastrophic that it is as though there never was signature verification that happened. The process has been so corrupted that we can't say that this was valid. It's like, just doing the thing, but not actually doing the thing. Like, it's a car, it's got 4 wheels on it, but it doesn't have an engine and it doesn't have a steering wheel. So it's not really a car. You do have signature verifiers, but they're just sitting here tapping all over the place. And they're not actually doing signature verification. And when you identify somebody, you don't remove them quickly enough, and you don't investigate what ballots they touched, and all of the different problems need to be added up. And I wanted to hear from Kurt Olson. I wanted to hear in close. So what you're saying is, based on your observations, tell me what you believe, whether you believe there was signature verification or not in Arizona. And they probably get an objection leading on that. But what is your opinion as to what happened with signature verification? Or maybe he's an expert, so he can talk to that. But based on everything you've seen, long story short, did signature verification occur in Arizona? Did it occur? And he would say, no, it didn't. Because in order for signature verification to occur, you've got to have a threshold of competency in the performance of the thing before you can say it's there. At what threshold do you achieve signature verification? And I wanted the argument to be that this was not that. Honestly, we heard a lot that there was signature verification. There are a lot of people were doing a bunch of things, but in totality, and now they're going to bring this home in their closing argument, right? They're going to say all of what I just said, but I wanted to hear that from these other witnesses. I wanted to bring him home. It's the so what. So based on everything we talked about, did it happen? I mean, did signature verification happen here? No. And they need to go back to that in their closing arguments and reference it. And so, all right, well, we've got just a short break. We'll be back in a few minutes. And so let me get a quick clock up on the screen, and then we'll come back in just a few minutes. I'm just going to step away for just 5 minutes, if that, and then we'll hit some super chats as we wait for the court to come back. And I will mute this so that there is no problematic problems. Trials on break. Stand up, stretch those legs, and we'll be back in just 5 minutes. See you guys, 5 minutes. All right, my friends, we are waiting for that timer to count on down and for the court to come back in session. We are just finishing up with Kari Lake's entire case. So they wrapped up with the expert witness, Erich Speckin, and he is done. So that means the plaintiff's team has rested, and it's going to go over to the government. So they have, I believe, just one witness they're calling, which is Ray Valenzuela, which is the same guy we started this morning off with. And they're going to, remember, they didn't do the cross-examination of him because they were just going to deal with it all on direct. And so we'll see what that looks like. It could be a pretty short day. My question is, are we going to be done before the day is over? And is tomorrow going to be necessary? Let's say hello to the super chats, and I appreciate everybody. And thank you to Gaming Slosh for that one. Lil Mandy's in the house. What's up, Lil Mandy? I appreciate you, Lil Mandy. Says thank you for the commentary and the coverage. Thanks for being here, Lil Mandy. We saw you yesterday too. Appreciate it. Catwoman MN says $5 for the hair products for Robert. He needs to keep the hair perfect. I'm getting a haircut. Well, the plan was to get a haircut tomorrow. Depending on what happens with this trial, tomorrow afternoon. We'll see. We'll see if we can get it done. If trial's still going on, then haircut's going to have to wait. But thank you, Catwoman. I could always use it. Refill, my plastic containers of goo. Appreciate that one. Cat MN. Based Shaman in the house. What's up, Based Shaman? Says, has any of these witnesses been subpoenaed? And I don't know which witnesses you're referring to, Based Shaman, in particular, but several of them I'm sure were. I just don't know which ones you're talking about. So, like, are you asking about Stephen? About Stephen the Pecker? Whether he got subpoenaed or not? I'm not sure about that. It's a good question. I don't know if they can't find him or what. I'm kind of curious why we're not hearing from Bill Onesie Twosie Gates or from Scott Jarrett. But I don't know. May have just been decisions by Lake's team to not call these people. Good to see you. Thank you, Bay Shaman. And hey, Dolphin Fan is the man, is the house. Thank you, Dolphin Fan. What is going on, Dolphin Fan? Brought 5 new membos into the house. Brought in Eric V. Just Cause is coming in. We got Brandon Rudder, N7, and Eclectic Divergent all becoming members on YouTube. And we love that. When we're not in trial season as we are today, we do member-only morning streams. We do a morning session before we do the night session with the show. And so Dolphin Fan, and hey, don't forget to grab the Telegram link if you're on YouTube. Just go over to the community tab and navigate over there. Hey, Gran McKearley's in the house. What's up, Gran? Gran McKearley says, I wish Lake had more competent counsel. This lawyer doesn't know how to lay foundation, introduce evidence, refer to evidence already admitted, or ask questions in clusters instead of being all over the place. Yeah, I hear what you're saying there, Gran. Gran McCurley in the house, I think is right about that. And I don't know, it got me thinking today about what their background is. I'm not sure, are these litigators? Are these people that have experience litigating? And I don't know. I don't know. I always want to show attorneys grace when they're in the middle of stuff like this. And so we always try to do that. I'm not saying you're not doing that, Gran, but I do agree. I think that in general, the right is outclassed with counsel. I think that the left, generally speaking, has entire divisions and teams built up like the Elias Law Group, which was run by Mark Elias, that are just dedicated purely to election litigation. That's all they do. Meaning you put up a team like that, it's like putting up somebody who plays, basketball for a living, is a pro player against somebody who's, in high school, who doesn't even play basketball, like against a soccer player, and say, hey, you're now playing basketball, who's going to win? Obviously, they're going to be a little bit, more practiced. It's all they do. So I agree that there feels like there's a little bit of a mismatch here. And it's, it's too bad. I agree with you there on that one, Grant. More competent counsel would be good. But I know these guys are working hard. I know that they are probably up all night fighting this stuff, and it's also hard to be in their position. It's easy, like it's very easy for me, for me to sit back here and objection and do this thing and do that and the other thing, but they're in the thick of it. But you're right. Some of these things are basic fundamentals, and yeah, it was just kind of painful to watch. There was a lot of questions that I thought should have been kicked in goal that just weren't, and I'm not real sure why. Yeah, Base Shaman says, in your opinion, how well do you think each side is doing? Well, to be honest, I think both sides are pretty underwhelming, I think is probably the right word. I thought Lakeside could have had a lot better organization and presentation and structure to their examinations of all of their witnesses. I would have liked to, as we just mentioned before the break, come full circle and close the loop on this thing. There's two things happening. The judge has set the standard for what needs to be proven in this case. And I think that Kari Lake's team started at that. Like the opening statement I thought was great, man. They've got this figured out. They're going to bundle it into this tainted argument that the entire process was tainted, therefore it didn't happen. And we've sort of veered away from that line a little bit. I think the government essentially just has to sit there. They could probably not do anything. And if Kari can't meet that standard, the burden's on her to prove the case. So if they just sat there and didn't do anything, they're in the advantageous position. But they've also made some blunders too. I think that when Kurt Olson sat down to say, I'm done with this witness, they should have jumped up, asked one question, and then sat back down. And then really latched into their objection on that. And I think it would have been a harder time. Like the rest of Erich Speckin's testimony may have been precluded at that moment. So, and again, these are not common things. So both sides, I like to show a little bit of grace to, because these are not things that happen often, these types of challenges. And the judge too, it's kind of a whirlwind for everybody. So they're all getting through it. Rocky Waters in the house. Hey, thank you, Rocky Water. This came in over on Locals. Says, God bless you, Govea. Well, thank you, Rocky Water, and God bless you, my friend. Says, thank you for covering these trials and for spreading the word. Well, I appreciate you being here. I do appreciate you being here. We are covering this stuff as far as we can go with it, but it's very important. I think this stuff is reviewed. The last thing we want is all of this to die in the darkness. Grand McCarley says, sir, how many onesies and twosies have you analyzed? I think that may have been a question for the person on the stand. Yeah, Bill Gates, Bill Onesie Twosie Gates. Oh, and I thought I had that clip. What did I do with that? CNN. I was trying to find that clip. If we had Bill Gates.
Now, according to county officials, the problem had to do with passwords being entered too many times. But after they won, it was all counted, Wolf.
No, that's not it. Yeah, I was trying to see what Bill Gates. Remember, we were trying to find the Bill Gates, Onesie Twosie Bill Gates.
Hello, MAricopa County. I'm Bill Gates, the chairman of the MAricopa County Board of Supervisors.
And I'm Stephen Richard, the MAricopa County Recorder.
And we're here to give you an update on how things are going so far with the election, to tabulate them.
So this would function much like early voting functions, in that we would get your ballot.
If there are lines at the location you're at or issues with the tabulator, if you would prefer to go to another location, you can do that. Doesn't matter where you go, as long as you're a registered voter here in Maricopa.
Yeah, so all Kari Lake's voters on the day of elections, he knows their problems.
123 vote centers across the county. So if there are lines at the location you're at or issues with the tabulator, if you would prefer to go to another location, you can do that. Doesn't matter where you go, as long as you're a registered voter here in Maricopa.
Yep, you don't get convenient access to voting because we botched the whole process, idiots. How many onesies and twosies have you analyzed? Personally, I don't know what the hell Bill Gates is talking about, onesies and twosies. That's not how we talk here in Arizona. I don't know what he's analyzing, but we are talking about ballots and signatures in an Arizona election that has proper procedures and rigor around it, not onesies and twosies. I don't know what the heck he's doing over there. Anyways, good to see you, Grand McCarley. We got American Dreamer says these lawyers are brave. Helping Kari can ruin your career. Please send your positive thoughts. A great point on this, right? Yeah, there's an effort, by the way, of people who want lawyers who help Trump to lose their law licenses. Okay, Christopher Krebs from CISA, the cyber intelligence idiotville, he was out speaking specifically about removing law licenses from people who are helping Trump. So
Mr. Liddy, Your Honor.
definitely send some love to the lawyers, send some positive energy their way, because man, it's a tall, this is a tough road.
He'll be along presently, I'm sure.
I'm sorry?
Tough road.
He'll be along presently, I'm sure.
He's right behind me.
Okay. All right, this is CV 2022-09-5403. This is Kari Lake versus Katie Hobbs et al. The continuation of the trial in this matter. Present for the record are either parties, their designated representatives, or their presence having been waived. And we have counsel for each of the respective parties. So for defendants, plaintiffs have rested. Defendants,
Your Honor, Elena Rodriguez Armenta for Governor Hobbs. We would now move the court for a judgment on directed verdict characterized by the Arizona Rules of Civil Procedure under 52C as a motion for judgment on partial findings.
go ahead.
Your Honor, we would oppose, of course. And I couldn't, my hearing
Is that your motion?
No, Your Honor. No worries.
Yeah.
Your Honor, may I ask, would you prefer that I address you from the lectern or from?
Doesn't matter to me as long as you're in front of a microphone.
Great.
So standard process here, every time one side
Ms.
finishes.
Lake has rested her case in chief, and for the second time before this court has failed to meet her burden. Based on this court's two orders and the Arizona Supreme Court's order granting remand as to this one issue, in order to succeed, Ms. Lake was required to prove this week by clear and convincing evidence her allegations that no signature verification was conducted as to level 1, in addition to allegations that level 2 and 3 verifications did not occur, and establish that votes were affected in sufficient numbers to alter the outcome of the election based on a competent mathematical basis. Because Ms. Lake has been fully heard on an issue during a non-jury trial, Governor Hobbs, Secretary of State Fontes, and Maricopa County jointly moved this court to enter judgment on partial findings against Ms. Lake on her signature verification claim pursuant to Arizona Rule of Civil Procedure 52C. As Ms. Lake has failed to meet her burden regardless.
Slow down.
Sure, certainly.
Follow you, but the court reporter.
Thank you. As Ms. Lake has failed to meet her burden, regardless of what defendants may offer in her own case in chief, this court should deny Ms. Lake's count 3 and dismiss this case. Simply put, the testimony of Lake's witnesses cannot support a finding that no signature verification was conducted at levels 1, 2, and 3. Ms. Lake called 6 witnesses total, including co-director of elections for Maricopa County, Mr. Ray Valenzuela. Neither the testimony of Lake's witnesses nor any admitted exhibits can support a finding that Maricopa County did not conduct any signature verification and any curing at levels 1, 2, and 3. Indeed, the testimony at trial thus far supports a finding of just the opposite. Beginning with Ms. Jacqueline Onekite and Mr. Andrew Myers.
Oneki.
Ms. Onekite and Mr. Myers both worked as level 1 signature verification workers during the 2022 general election.
Rude.
Ms. Onekite and Mr. Myers testified that they did conduct signature verification and curing as level 1 workers. Ms. Onekite, in fact, testified that she performed her job well and that she was focused on quality over quantity. Both Ms. Onekite and Mr. Myers also provided testimony as to the signature verification and curing conducted at higher levels of review. Both individuals described a process consistent with Arizona's signature verification law and offered no testimony supporting a finding Maricopa County failed to conduct any signature verification at levels 1, 2, and 3. Mr. Hansel, the Data and Technology Director for the We the People Arizona Alliance, was called to authenticate data received from a public records request made to Maricopa County, which shows the time spent by anonymized signature verification workers on signature verification. Mr. Hansel offered no testimony supporting a finding that Maricopa County did not conduct any signature verification and curing at levels 1, 2, and 3. Ms. Bush, the chairman of the We the People Arizona Alliance, was called primarily to authenticate a video purporting to show a signature verification worker working too quickly to actually be verifying signatures. Ms. Bush had no personal knowledge of the events taking place in the video. Ms. Bush ultimately offered no testimony supporting the finding that Maricopa County failed to conduct any signature verification at levels 1, 2, and 3. Mr. Ray Valenzuela testified in detail as to the multi-level signature verification and curing process in Maricopa County, including the signature verification and curing at levels 1, 2, and 3 conducted during the 2022 general election. Mr. Valenzuela testified as to the possible contents in the video shown at Exhibit 19, including 1, testifying that every single person is required upon finishing their signature verification batch of 250 to click back through their batch as part of finishing the work at level 1, and including 2, that a signature verification worker who was found to be performing his duties incorrectly by Maricopa County was reassigned to a different post for the 2022 general election. Mr. Valenzuela testified as to the movement of signatures from levels 1 to 2, and further testified as to level 3, which is a randomized audit designed to serve as a check against other levels of review and ensure accuracy. Mr. Valenzuela also testified that it was possible for signature verification to be performed at an average rate of a couple of seconds. And finally, Mr. Valenzuela also testified that he himself performed signature verification of approximately 1,600 affidavit signatures during the 2022 general election, excuse me, Your Honor.
Right.
Finally, Mr. Erich Speckin. Mr. Speckin offered no testimony supporting a finding that Maricopa County did not conduct any signature verification or curing at levels 1, 2, and 3. For those reasons, Your Honor, Governor Hobbs, Secretary of State Fontes, and Maricopa County jointly move this court to enter judgment on partial findings against Ms. Lake on her signature verification claim pursuant to Arizona Rule of Civil Procedure 52C. Thank you, Your Honor.
Motion for a directed verdict, kind of like summary judgment.
You may.
You hear this as also from the defense oftentimes as judgment for acquittal, move for judgment for acquittal.
Your Honor, the Supreme Court mandate was that Plaintiff Lake was required to establish that quote, votes were affected in a sufficient numbers to alter the outcome of the election based on a competent mathematical analysis to conclude that the outcome would plausibly have been different, not simply an untethered assertion of uncertainty.
There's more to that.
The issue in this case.
There's more to that order.
Has been ARS 16550 about signature verification and the associated EPM. Counsel for the defendants just say signature verification occurred. But what exactly is signature verification as required by that statute? And signature verification is not just simply whatever we think it is. It's not simply sitting in front of a desk
Here we go.
tapping on a keyboard and scrolling through signatures. The statute is very specific. 550 uses the word shall compare. And that's further, the two signatures, and that's further modified by the finding of the verifier that the signature, whether or not it is consistent. Supreme Court case law in Arizona states that the words of a statute are to be given their ordinary meaning unless it appears from the context or otherwise that a different meaning is intended. Shall compare. Webster's dictionary defines compare as, quote, to examine the character or qualities of, especially in order to discover resemblances or differences. Webster's dictionary defines consistency as marked, quote, marked by harmony, regularity, or steady continuity, free from variation or contradiction. Even Mr. Valenzuela said yesterday that you could not compare a signature in a half a second. He thought it could be in 2.5. Even Mr. Valenzuela said yesterday that you could not compare a signature in a half a second. He thought it could be in 2.54 seconds. So defendants, and Mr. Valenzuela is not a handwriting expert. He's not an expert in signature comparison. He was simply recognizing the obvious, that you cannot just throw two signatures up on a screen and do a comparison. What is the purpose of the Arizona legislature in mandating signature verification in the first place? It's the first level of security to ensure that illegal or fraudulent ballots aren't being injected into the system. As I mentioned at the opening, the Carter-Baker Commission found that mail-in fraud is mail-in ballots are the single greatest risk of fraud. And it's that check of the signature through which Maricopa County puts its employees through some fairly significant training in order to recognize the differences in handwriting and to be able to assess whether or not a signature is consistent and in order to compare them. Defendants would have this court believe that the word compare has no meaning. That is not in the context of the statute and the intended purpose. That's a critical distinction, Your Honor.
No meaning. Okay.
The issue here is not whether two signatures flashed up on a screen or that there was somebody seated at a desk and just tapping on a keyboard like we saw in the video. We have offered concrete evidence which defendants don't dispute, and that's key, Your Honor. This was their own data. They had it. They've known about it for at least since Friday when we disclosed in our expert disclosure that 1482 would be one of the bases of his opinion. If there was something wrong with that data, don't you think they would have come and said, hey, plaintiffs are wrong. The data doesn't show that more than 70,000 signatures were approved in less than 2 seconds. That's a range, Your Honor. That's less than 2 seconds to 1 second to a half a second. That as plaintiff's expert testified, that over 274,000 ballots were verified. I don't want to say approved, but verified in less than 3 seconds. And Your Honor, as noted in that table and as testified to by Mr. Speckin, this isn't simply a comparison where you had a very obvious rejection. These were at a rate of 99 to 100% approval. And so it takes longer to approve, to find that they're consistent than it does to reject a signature. We had, as Mr. Speckin testified, at 2 seconds, less than 2 seconds, 70,000 ballots were approved. The rates of the top 7 were 100%. That's not signature verification, Your Honor. This is the first line of defense that gives people
That's not signature
confidence
verification.
in the system.
More of that.
That's what this is about, and that's what's been lost. This is Oniki. When she teared up on the stand, she came here from Colorado to give her testimony and to testify what she saw. The confidence, the laws, 16550 is designed to give people confidence in the system. It isn't simply anything goes with respect to signature verification.
It's starting to sound a little like a closing argument.
The issue, Your Honor, was not disputed by defendants. They didn't put up an expert to say, well, you can.
Their case is coming up.
A signature, as that term is commonly defined by Webster's, to determine whether the signature is consistent. They had their opportunity. They knew it was coming. They didn't dispute it. That is fatal, Your Honor.
They're going to dispute
If anybody were to take
right now with their witness,
as Mr. Speckin demonstrated on the stand, and flip through pages and say, I read it, that's not reading. This, for the same reasons, to say that a comparison is being conducted, there is a standard. And in fact, MAricopa recognizes the standard. That's why they put their employees through this training to determine whether the signature is consistent or not. The issue under Race is whether or not the law is being followed. Statutes are interpreted or read by their plain meaning. Here, the undisputed evidence shows that you cannot compare a signature to determine consistency in less than 3 seconds. And we could even take it in less than 2 seconds. And Mr. Valenzuela would agree that you can't do it, in his words, half a second. He kind of just pulled that out. The other issue with respect to the evidence that plaintiffs presented from the whistleblowers that counsel didn't mention is we talked about the flood of ballots that were coming in. Undisputed testimony that the level 2 reviewers were so overwhelmed that rather than conduct any signature verification, they would kick the ballots back to, or the signatures back to level 1 to be re-reviewed when they'd already been rejected. That's not signature comparison, Your Honor.
That's not signature comparison.
I would also note that getting back to the statutory requirement to compare, in the case, Your Honor, that I'd like to cite for terms being given their ordinary meaning is State v. Miller, 100 Arizona, 288, 1966. Long-held precedent. Maricopa County hired a signature expert to train its workers, Kathleen Nicolaitis. Why didn't they said, oh, they could have put an expert up to say, well, yeah, I believe you can compare a signature. None could. That's just a fact, Your Honor. It's an undisputed fact at the moment because they didn't put anybody up. It was their Maricopa County is required to show that they complied with the statute. The undisputed evidence shows they did not. The numbers are outcome determinative. Whether it's 274,000 or 70,000. If you could pull up a 2-second. Your Honor, may I just show a quick demonstration to show what 2 seconds looks like to flash on a screen?
It's starting to feel like a closing argument, and we should just, she's standing up. Yeah. This is just really just a motion for a directed verdict.
That's 2 seconds, Your Honor. 70,000 ballots approved it.
And I believe the defense is still bringing in Ray Valenzuela. He's going to be their expert. So he's speaking, but he's away from the mic. We can hear him barely coming in. It's just not even rendering.
Concerning of elections. There has been a massive push, even Mr. Liddy back in December. If you recall, Wayne.
Walk back to the microphone, Kurt.
Yes. With the increased usage of mail-in ballot makes the importance and the significance of having security measures as outlined and stated clearly by the Arizona legislature to give the public confidence that their votes are being cast and that the elected officials have been rightfully elected is paramount. Your Honor, with that, I submit we have met our burden. The directed verdict should be denied. Judgment should be granted in plaintiff's favor, and this election should be set aside. Thank you, Your Honor.
Your Honor, may I briefly? First, as a point of procedure and actually a couple of points of procedure.
Here we go. Here we go.
And also some references to the basic rules of evidence.
Yeah,
I note that the chart Mr. Olson repeatedly referred to is not an evidence. Second, I note that no, we have not technically disputed anything. We have not yet put our case in chief on.
Yeah.
Because we are presently before the court on our joint 52C motion, which rests on partial findings. And now, Your Honor, briefly again, before I offer other defendants also an opportunity to speak on our joint motion, we are not here before the court to argue statutory construction. If we were, just like we need to read the statute, Arizona case law has also said that we cannot read into a statute that which is not there. The statute does not call for a specific set of seconds to review. It does not call for a specific set of levels beyond that first to review. And beyond that, we are not here on a process challenge, as we and the court have repeatedly reminded plaintiff. And respectfully, nothing Mr. Olson has just said changes the evidence presently before the court and that which is actually in the record, which is not nearly sufficient to show that the outcome of this election would have been different based on a competent mathematical basis. Respectfully, again, I refer the court back to the testimony and the record, which I have just briefly reviewed, showing that Ms. Lake did not meet her burden as articulated by this court and by the Arizona Supreme Court. I renew my motion for partial findings, and I would like to provide other defendants' counsel the opportunity to speak.
Just deny it. Let's hear their case and let's get to closings.
Your Honor, Maricopa County joins the Rule 52 motion. Supreme Court said that plaintiffs, and rather this court said that Lake must prove by competent mathematical basis to win a trial, but she need not plead specific numbers in order to meet the 12b6. But she did need a competent mathematical basis with specificity to prevail in this hearing. Not a single witness put forth by challenger Lake put forth any mathematical basis at all, competent or otherwise, that the signature verification process did not occur. Many of the witnesses gave specific information that it did occur. And her opinion,
they're going to make
witness
that argument in closing, tie it all together.
Testified as to a table, if you will, for lack of other terminology, that he testified he created from data received from Maricopa County that was built within their computers during the signature verification process. But for an acknowledgement that the signature verification process occurred, there would be no data upon which he could put his piece of paper together. And I would say, Your Honor, that Reyes is a case in which both parties stipulated that there was no signature verification. And many months ago, just to correct the record and to preserve my own integrity, if you will, I never blamed any voters for voting on election day. I blamed Kari Lake's Get Out the Vote coordinator and her campaign manager for malpractice. And they did reap what they sowed.
These people.
That's all we have, Your Honor.
Very well.
All right.
Rule
Deny it.
52C contemplates judgment on partial findings, and in the middle of the language of the clearly in the rule, it says the court may decline to render any judgment until the close of the evidence.
Okay, finish.
Yes, Your Honor.
Present your
Otherwise
case.
known as directed verdict in a trial. At this particular time, I'm going to exercise the discretion to decline rendering a judgment until the close of everything,
There we go.
because
Good call.
otherwise I'm ruling from the bench as
Yeah.
well. And
Present your case.
as much as you might want me to do that, I'm not going to do that.
Yes, Your Honor. Thank you for your consideration.
Okay, Ray Valenzuela
So,
is the government's
Do defendants
expert.
wish to present any case?
Yes, we will, Your Honor.
Ray Valenzuela.
And I didn't mean to this to be a comment either way on anything, okay? I'm reserving till I hear everything where this comes out.
Understood, Your Honor. I think we all understand.
I
Very
think you
well.
can feel the tension in the
Defendants,
courtroom.
who would you like to call as
First
a witness? I think you got Mr. Valenzuela's the only one you've got left.
Yes, Mr. Valenzuela.
I don't see. There he is. Okay.
Same gentleman we started off the day with. This was,
Mr. Valenzuela, you remain under oath. I'm not going to have you sworn in again, sir.
All right.
If you'll come up to the podium. I will ask you,
we started the day with
you
Valenzuela.
do understand that you remain under oath, correct, sir?
I do, Your Honor.
Thank you. Very well. Who will be conducting the direct examination of Mr. Valenzuela?
Mr. Liddy, Your Honor.
Thank you.
Who's doing cross?
Okay. Please proceed when you're ready, Mr.
Thank you, Your Honor. Mr. Valenzuela, we have met before.
We have.
In fact, I represent you and your colleagues on a variety of matters and have for many years.
That is correct.
And I'm not going to go through the normal early litany of direct examination because you've already testified and you've given your name and your employer and your background. We're just going to go through a couple of things, see if we can't get this thing wrapped up. You mentioned earlier that you were SARA certified. Is that correct?
That's correct.
And how long did it take to get SARA certification?
The average is between 4 to 6 years.
Okay. And is that something that requires renewal?
It requires every 3 years renewal and through CLE and other classing.
And would you remind me what SARA stands for and what SARA certification is?
SARA stands for Certified Election Registration Administrator.
During the 2022 general election, were you involved in verifying signatures on early ballot envelopes?
I was.
They're arguing the law, exactly
Let's
what the
cut to the
judge wrote.
chase, Ray.
Exactly what the judge wrote. Right to it.
Did you conduct level 1 signature verification during the general election in 2022? And would you please look at the judge when you answer, not me.
I did.
And did you conduct level 2 signature verification during the general election in 2022?
I did.
And did you, in fact, in addition, conduct level 3 signature verification in accordance with the law and the requirements of the recorder's office during the general election in 2022?
I did.
Arguing the exact opinion from the judge.
And to your knowledge,
Check,
was there
check.
anybody else on the Maricopa County Recorder's team that also participated in signature verification during the general election 2022?
Yes, as I identified even in the plaintiffs, there are a total of 155 users, if you will, that participated in signature verification.
And those 155 were all trained and qualified to do level 1 certification at least, correct?
At the very least, yes.
And among those 155, there were other participants in the general election 2022 signature verification process in Maricopa County that were also trained and participated in signature verification level 2. Is that correct?
That is correct. There were 43 total.
43 total. So if somebody attempted to put forth with competent mathematical basis some sort of calculation that would stand for the proposition that Maricopa County could not do the signature verification and the amount of time allotted, 1.3 million early voters, and they use the variable of 25 level 1 reviewers and only 3 level 2, that would yield a result that would be inaccurate based on your personal knowledge of how many people participated in the 2022 general election signature verification in Maricopa County?
That is correct.
Because you don't have to be a mathematical genius to know when you switch the variables from 25 to 155 and from 3 to 43, you're going to get a bigger number, right, Ray?
As far as throughput and ability to review those, yes.
Okay. Briefly, what does a level 1 signature review employee do?
They are tasked with exactly that, user level, entry level, and I'll use the term do no harm, ability to basically filter to pass, fail, good, exception, whatever term pleases the court. But in ours, it's good and exception. They can do no harm. They can not reject. So the term, using the term reject is not proper. And not a single level 1 user could reject. They can only exception and move that to a level 2. They could make good and move that into the potential audit, 2% random audit of that.
Nice language. Nobody's
Ray, you're
rejected.
getting kind
just
of
accepted.
inside baseball on me, right?
I apologize.
So they get a computer screen in front of them, right? Provided by Maricopa County.
We don't reject
That is
anything
correct.
in Maricopa.
They have the ability to pull up
We just
digitalized
accept it
images of the green affidavit
until it gets
envelope that's
processed.
used in Maricopa County for a mail-in voter.
To add a little clarity, that is pulled up for them. They log in. A batch of 250 is provided to them with the 3 exemplars and the clipped image of the voter's signature.
So on the screen, it comes up. There's the signature that they used in 2022 to verify their ballot packet or affidavit envelope. And there are the last 3 signatures in the recorder's computer for their record. Is that correct?
That is correct. And just as a point of reference, they are ranged by ladder to, so the latest signature on file for the voter is the first signature that appears. And just for another point of clarification, it is never trained to that you must look at all 3 exemplars and scroll. I just wanted to make sure that the idea that is the most recent signature appearing first in front of that level 1 user.
Thank you, Ray. Don't get ahead of me. Thank you, though. So you've done level 1, review yourself.
Yes.
And you have also produced training materials that have been used for people that have been hired, trained, and have actually done level 1 ballot review.
I have been participatory in crafting training, yes.
Okay. Now, let's say there was a live signature right here from 2022, and over here I have the last 3. The law says you have to look to see if they're not similar, right? You have to compare them to see if they're not similar.
Actually, and if we continue to read as 16550A is being referenced, it's compare for consistency.
It's compare to see if the signature is inconsistent.
Correct.
So you have to compare to see if they're what was it? Inconsistent, right?
Not stop at compare, but compare for if it is inconsistent.
Not dissimilar and not match and not identical. But you look at the one from 2022, you look at the other 3, they're right there in front of you, and you're looking to see if they're dissimilar.
Correct.
What do you do if they all look the same?
They were consistent, then they meet that criteria for them to be then dispositioned.
How,
a good sig.
and how long does that take for somebody who's done this for a while, that's experienced? There's the one from 2022 from the green envelope, a digitalized image, and there's the last 3. Are they dissimilar? How long does that take?
Again, as mentioned, you're not required to scroll to 3 if the first latter signature on file, vetted, verified signature is an exact match. We'll use that. Then that can take 1 to 2 seconds.
Because if it's an exact match, it's pretty clear that it's not inconsistent, to use the language of the statute.
That is correct.
So in fact, you don't even have to read the 2022 signature and then read the signature from 2020, 2018, 2016. If they match, you know that they're not dissimilar as the statute requires, right?
That is part of training. That is correct. Only one exemplar is required to be referenced but the others are provided for those that may be subjective.
So you check one if they look good, you don't have to go to the others.
A level 1 signature reviewer in Maricopa County in 2022 looks at those exemplars and says, well, I think they might be dissimilar because instantaneously it doesn't look like a match to me. I'm going to look a little bit closer. And then that individual does look a little bit closer and just says, you know, I can't determine that it's not inconsistent. I actually see some inconsistencies there. What does that level 1 signature reviewer do?
Again, with the inability to reject, they would exception. And use that case in point as an example, the Reynaldo Valenzuela's packet signed by Frank Johnson. That's very dissimilar, not consistent. There is no need to go through broad characteristics, local characteristics, or to even go past the first exemplar. So that would be a 1 to 2 second exception.
And where would that signature then go, or where would that comparison go?
That would then go to the manager's level, the 43 managers that were available to task to review that second, to concur that that is indeed not a consistent signature.
Is that level 2, Ray?
That is level 2, manager's queue, I apologize, but level 2.
Okay.
A lot of verifying going on. See why they're
level
doing
2,
this?
so it goes to level 2.
They're trying to show us how the
that could be
sausage
pretty
is
quick,
made.
too.
So you just know what's
As far
going
as
on.
reaching the
All the
review
details,
in
very boring.
level 2?
Identifying that they're inconsistent, move it to level 2.
Yes, that could be one of the ones that is indeed to also include, I may be overstepping, also a no signature. There is no 11 broad characteristics to look at for a no signature.
Okay, but
that could be 1 second as well.
But let's go back to just 2 that at first look might be the same name, probably are the same name. The first name's about the same distance. They both have a middle initial. They both have a period. They both have a last name with a big fancy letter in the front. But something's just not right. It's not a match. You can figure that out pretty quickly, couldn't you?
And we actually train to our level 1 users and actually have emphasized this quality. And if they don't feel that, indeed, we ask them to exception so it can go through that higher level review.
Now, in your experience, Ray, doctors aren't the only Americans who've got bad handwriting. Is that correct?
That's correct.
Lawyers
Some
too.
voters do too.
Including myself.
And then there's people that are maybe in a hurry in life and they don't use perfect penmanship. When they sign their name, they just kind of
Or they're
do a
left-handed.
little scribble that they think is kind of cool, right?
That is correct. And it is those that you exactly are mentioning are the ones that have some similarities that go beyond the 2 seconds, the 5 seconds, the 6 seconds, even 20 seconds at that level 1 to look at all 3 exemplars because there has similarity, but they're not exactly consistent. Then at least those are the ones that would take longer than 2, 3, 4 seconds to review.
But what if that little scribble was an exact match? How long would that take?
As mentioned already, that if it was the exact same flourishes and strokes, they would take between 2 seconds to 4 seconds to infer and look at that to say those are similar and consistent.
So in fact, so if there was a voter who was an anesthesiologist and wrote all kinds of weird stuff in his name, and you might never be able to decipher the name of that doctor, you might still have exemplars that match. And you never actually read the name, but you would match the signatures, correct?
Under the
Object, Your Honor, he's leading the witness.
It's leading.
I think you previously testified that you have seen signatures that you were unable to read. Is that correct?
That's correct.
Were you able to determine whether they were similar or dissimilar from the exemplars provided in the registrar's record?
In the manager's level 2, where we have a repository of every single official registration record to include registration form, pass affidavits, and a lot of folks may not be aware, but when you check into the polling place, you sign a roster, showed ID, that's a vetted signature. That too is available to that manager level 2 reviewer.
In your experience, does level 2 review take longer than level 1?
Absolutely. It's intended to, other than, again, another folklore in demonizing the 1 second, 2 second, is that if I am a level 1 and I send up a no signature and it took me 2 seconds, one, it should be to establish that's no signature. A manager should be able to look at that and concur in 1 second that that is a no signature. There's nothing there to local or broad characteristics to review.
No, we need to get up to that.
You bet.
I'm ready.
All right, so they're showing us how the sausage is made, a lot of sausage making.
Confirm.
Just to make it very clear, all of the mechanics, everything that went into all the signature stuff.
Gotcha. Yes, this is it.
And they're holding very tight to the judge's standard. They're not talking about any of the problems, obviously. They'll try to hit him on the problems on the cross-exam.
Honor, may I approach?
You may. Which
But
exhibit is it?
Everything is just normal operations. Everything was fine. We didn't even reject anybody at level 1. They just got accepted. Moved up to level 2. And as we heard from Kari Lake's team, they say when it went up to level 2 just sent it
Mr.
back
Valenzuela,
down.
do you recognize the document you have in front of you?
I do.
And you see a green tag on that?
Yeah.
Can you confirm for me the exhibit number of that?
Exhibit number 23.
Could you take a moment and just peruse that document? Not to read it, but just to see if you recognize what it is.
I do recognize it. Yeah.
So. And what is that document, Mr. Valenzuela?
It is a printout of our PowerPoint training that's provided to all of our signature verification staff.
And was
Lights go
this
out? What happened over
document
there?
used for the classroom training, which you previously testified before while you're under examination from the testor that was provided to the level 1 signature reviewers in 2022?
This is our one user training material, or a portion thereof. There are also guides that are provided for reference.
Turn on the lights over there, man.
Your Honor, I move this exhibit into evidence.
Objection to 23.
No,
Who's doing the examination for this witness?
I am, Your Honor. No objection.
Thank you. 23 is admitted.
Who was that? Blam or Olson?
You may.
Actually, I'm trying to leave it up here in case they refer to it.
I don't mind as long as at the end of the day, it makes its way back to the clerk.
So more sausage making. We'll see how long they drag it out. You hear this in criminal cases all the time.
Yes, it's been.
No, I
admitted as
checked the
one.
blood vials and I actually tested my radar gun, yeah, on all the things.
If this has the secretaries have been admitted as exhibit.
Showing the defense the document, showing co-counsel the document.
Which exhibit do you?
Okay, if it's been admitted, then
Which number is it, Mr. Liddy?
It's 20.
One's been admitted.
it's identical. I didn't realize it was in here twice. It's the same one. It is. Yeah.
I'm told 24 is a duplicate of one. One's been admitted.
Yeah. We're good.
It's a duplicate of one, which is the signature. It was the certification. I believe.
We need to pull that up Exhibit 1. Choose to, did you ask? Choose to write. Files.
Looks like we hear some whispers from the defense table. They're shuffling some papers around. I think Exhibit 1 was the certification that everything was certified.
Mr. Valenzuela, you've answered several questions about level 2, which you said officially is called manager level. Is that correct?
Correct.
Can we talk about dispositioned ballots? What is a dispositioned ballot?
A disposition is a particular status code that we set to a given record to identify which way we want to sort that physical packet to direct it down its proper path.
Lights are on.
Okay, so by physical packet, you don't mean a ballot, and you don't mean a mere affidavit envelope, the green, ubiquitous green envelope that we've discussed a lot over the last couple of days, but you mean the combination of the two. Is that correct?
The ballot sealed,
Sealed.
is to be and remains until it reaches our citizen boards for processing. But yes, the packet is how we refer to it in early voting, because it's not, it is not the ballot. So it's not confused that we're sorting ballots. We're actually dispositioning packets and that affidavit.
So that's why the professionals use the term packet rather than ballot.
Correct. So that somebody says, oh, I was sorting ballots, that sounds a little bit nefarious, or injecting ballots where you could be injecting a packet into the stream for signature verification.
They don't like the words.
So just for clarification,
they changed the words.
Packet has the affidavit envelope, which you can see the affidavit on it, and a signature if there is one, because sometimes people forget, and a date. Is that correct?
That is correct, plus an option for the voter to list their phone number.
Phone number. And that is all visible on the outside of the packet.
That is correct.
You can kind of hold it and see if there's something inside, right? But you don't really know what's inside.
Actually, part of our process is that, but I'll not get into the weeds. But yes, we can tell if there's something within it.
And we're all hopeful that that thing that's within it is a ballot.
Correct.
Your experience, is it always a ballot?
Not always.
Just saying.
Somebody else put something else in the envelope.
So all of this review is done without the reviewer actually seeing the ballot.
Not only do they not see the ballot, they only see that it's a clipped image that the level one is looking at, and it contains the voter signature and the voter's information, if you will, their name and address.
So these reviewers don't even get their hands on the packet?
Not until they reach the curing post dispositioning as good, bad, or otherwise.
So where are the ballots at this level 1 and level 2 time? Where are the packets? Sorry.
So the process is, as sort of high level, was that we pick those up, our couriers, our staff pick those up from the U.S. Post Office. 2 members of the printing party take them to Rumbeck, where they inbound scan to capture that image and also account by that unique piece ID. Every packet that's sent to a voter, a registered voter, you have to be, unlike election day where you don't have to, you can, but I digress. Packet goes to the voter, it comes back, we inbound scan those, capture that image, and those are placed in a vault, never to be seen or touched again until we return that file with the disposition codes set.
That's where I was going. So I want to get back to that. They're actually in a vault, locked up at the time of the level 1, level 2 review. Is that correct?
A lot of sausage here, a lot of sausage.
Nobody gets to touch them.
Correct.
So if there's an evildoer son of Maricopa County at McTech that wants to play games, they can't go Karnak and figure out what's inside the envelope and make a disposition decision that way, correct?
It would not be the normal path either way for that packet to get to the citizen board processing. It has to be through that stream of disposition, audit sheet, and audit report.
My question is, they wouldn't even have their hands on it, correct?
Correct.
There's no way they can tell if there's a ballot in there or what that ballot, what's marked on that ballot, correct?
During that signature verification process.
Thank you. And that's the process that we used during the general election signature verification 2022, correct?
That is correct.
And you know that because you were there, correct?
You can also
Correct.
do the
You
signature
saw it,
verification
right.
from the office.
And participated as well, yeah.
Yeah, from
Participated
your
as
office,
well.
right? As well. Yeah, hopefully we get that question again. A lot of sausage. We know they put a lot of work into this, they say. No problems. Nothing's accepted. Everything goes up to the top. So they don't need to do anything other than just say that, we did do exactly our job.
Okay.
Which is exactly what they're doing. They are belaboring it a bit, but they've got one witness, and this is their whole case, evidently.
Your Honor, may I approach?
Which exhibit? Thank you, sir.
I think it is. It's exhibit 3. Make sure.
Mr. Valenzuela, you've had an opportunity to glance at Exhibit 25.
I have.
You recognize it?
I do.
What is it?
It is one of our signature verification user guides, or guides for our use. This one particularly is for our user level employees.
And was this, to your knowledge, was this used to train the level 1 signature reviewers, the 155 of them that were used in general election 2022?
It is a supplemental document that's part of the training that you originally presented and something that is a takeaway. They actually maintain this as a user level 1 worker.
Your Honor, I move for the admission of Exhibit 25.
Any objection? Your Honor. 25 submitted.
So I see 3 columns. Do you see those 3 columns on this document?
I do.
And the middle column says disposition, EVRT/EV26 green. Do you see that?
I do.
Would you explain to the court what that is?
This is, as mentioned, one of the disposition codes, good, that can be set. And this is a visual and example of what a user level 1 may see and what disposition would fit that category.
And what does good mean?
Good means that it's consistent signature with that they reviewed or the signature they looked at when at a level 1 initial review.
Okay. And if you go over to column number 1, it says example on the affidavit signature image. And if you drop down to the middle one there, it says, quote, verified and approved McTech stamp. You follow me there?
I do.
Explain to the court what that means.
That is a packet that went through as an example exception. The level 1 user initially said, I don't see this to be consistent. And they sent it on to manager level 2, concurred. It's not consistent, so it's sent for curing. So those thousands of that are then contacted by, or the voter is given the opportunity to cure, to authenticate their identity. And when they do contact, we document that on the affidavit and we stamp upon that verified and approved and resend that back through for 2 things, not only archive and retention to scan that packet, but also to re-verify in the system that it's a good SIG, meaning it's followed its path of exception. Could be a no SIG, could have been a questionable SIG, but it's been cured and that curing will have that stamp. And our level 1 board workers are trained till when they see that, that's a 1 to 2 second cure. There is nothing to scroll through. This has been verified by the voter.
So that's really fast.
Yes, with see that stamp, you see following the logic, you see no signature, that should be 1 second or less. You see this verified and approved, that should be trained to, that is good to go next.
So if I was trying to figure out an average time it would take to do a signature review and no high level math, let's just say 6th grade level math, maybe something I learned from my father.
You mean
somebody
statistics?
might learn from their dad or their mom. I actually learned mine from my mom.
You guys
not my
were
dad,
objecting to that earlier.
It's just figuring out an average, right? So if I were doing that, and I had some numbers from my universe for which I'm going to fill out an average that were 0 or near 0 because they've got the stamp on it. That's good. Let me finish the question. Let me finish the question. That's going to affect the average calculation, isn't it? Now go ahead.
I object, Your Honor. He's not a signature verification expert.
Your Honor, this only calls for 6th grade math.
Statistics. He's not a statistician.
He's
not a signature verification
He's not a
expert.
statistician.
expert. They haven't laid any foundation for his ability to
Hit him with
determine
the
how
same
long
thing.
it should take to do a signature verification.
That's not the question, Your Honor.
He doesn't know statistics at all. Not qualified. Sorry.
You're objecting that he's not qualified to
I'm
do.
objecting that he's not a signature verification expert, so he's talking about doing averages about how long it should take to do each of these signature. And that's they don't have an expert for that, Your Honor. Furthermore, I'll throw in the kitchen sink as they did. He's not a statistician. He has no background in that.
Oh, yeah.
I believe he testified to that fact, Your Honor.
Okay.
Yeah, right on.
Rephrase it.
He's not a statistician. Punks, how you like me now?
I'll withdraw the question.
Yeah, withdraw it. Good. Good.
And I'll get to it another way.
Fine.
Oh, love it. Good.
Ray, do you know what it means to calculate an average?
I do.
Well done.
If I want to calculate the average of 10 numbers,
Hey, this
and
down.
say
Hey,
2 of them
this is statistics, buddy. Get the calculator, girl.
very, very low, because
Where's-
those 2 come from a universe that's different than the other 8.
Where's
Let's
the
say they
calculator,
had
girl?
verified stamp approvals on them. And so I didn't have to examine them. I just knew right away we move them on. So I have 20% really low number. Is that going to affect the overall average of my calculation of the average of 10 by moving it lower?
Obviously, using the term gradient on the curve or anything, you would eliminate those that will affect your average, similar to these 1 to 2 second review dispositions or categories.
So let's say I'm the assistant coach on a Little League baseball team, and I'm calculating the average of 10 players on our team. But it's early in the season, early in the game, and 2 of them haven't even had at-bats yet. Because one was sick and the other was out of town, and they didn't play the first 2 games. So now I have 8 with batting averages, and 2 is 0, 0, 0. And if I add them all together, I'm not really going to get a look at what the average
Objection. This guy's not a
ability of our
baseball
team is
player.
to bat, because 2 of them are outliers.
Objection.
And I
This
should
isn't
throw
the
them out if I
MLB.
want to get an accurate number, right?
What the heck is this?
Yes, that is
For the-
correct. To remove outliers that would
Remove
affect
outliers.
that average.
And would you agree with me that if some of these review packets have the verified improved McTech stamp on them, that the amount of time that's going to take is going to be very, very low?
That is correct.
Your Honor.
Yeah, is he testifying?
I'm not a signature verification expert.
And he's
Are
testifying.
you asking
now.
him based on his personal experience, or are you asking for another basis?
Your Honor, I'm asking if
I'm not a signature verification expert.
Are you asking him based on his personal experience, or are you asking for another basis?
Your Honor, I'm asking him on his personal experience.
He's also speculating
As to what?
as to whether or not if something contains a stamp, the average time is going to be very, very low.
Well, that's why I asked him if he's asking based on his personal experience. He testified earlier, he actually reviewed and verified 1,600 at level 1 in the last election. So based on his experience, he can answer.
Can you answer the question?
Based on my personal experience of not just reviewing 1,600, but probably close to hundreds of thousands over my 20 years of actually doing this, and this being a consistent practice. Yes, I can say that if, in my personal experience, looking at this as is trained to all level 1 users, that I would take less than a second to see that verified and approved, and I would hit approved.
Thank you.
Less than a second.
Exhibit 26.
Now, I'm not sure that they really needed to go into all of this, to be perfectly honest with you. I think that the defense is making a real full case here, but he started out with really the crux of the argument, and I think he's just trying to anticipate what the cross-examination will be based on the direct exam. We heard a lot of the testimony about how quickly the signatures were verified, but Valenzuela's already addressed that as saying the speed of it could have just been captured by, at least the speed in the video that we saw was just being captured because he was checking his work. And you can do that very quickly, like less than 1 second even. Just boom, boom, boom. Yep, got it.
Mr. Valenzuela, do you recognize that document?
I do.
What is it?
It is similar to our user level, but it is our signature verification job aid for managers.
And was this document used in part, among others, and during the general election or the period prior to the general election 2022 to train the level 2 or managerial level document reviewers?
It is, and also as a reference take away guide.
How is this document used?
Similar to the other document, but it has that level 2 disposition options available, which on the screen when they showed, you'll see the first 3 categories are the same. The good, based on a verified and approved.
If I may, you're referring to the middle column of this exhibit, correct?
Correct.
I'm sorry to interrupt. So continue.
But if in this particular document, it moves into the next level manager disposition availability options, such as no sig. So at level 1, we're not asking them to make decisions other than exception. And then it moves to level 2 with multiple amounts of exemplars. But in the case of, you'll see the no sig is enabled option for manager because it clearly is a no sig. The need packet, there's several different dispositions that we at that manager level can, to include saying you think it is inconsistent. Let us look at the 2444 signature exemplars on file and see if we can concur.
So the level 1 reviewers have only 2 options?
That is
Good
correct.
sig and exception?
Correct.
No pass or no pass?
No good, no sig, no need packet, no any exceptional or
no rejection.
No rejection whatsoever.
That's a point of emphasis. There's impossible for level 1 reviewer to reject the signature.
Similar to our wanting to, in early voting, to call it a
Exceptions.
packet, not a ballot, and exception, not rejection, because we don't reject at level 1.
Could get some asked and answers on those. Circling back here.
We can move beyond the level 1, level 2, level 3 signature review process. And I want to ask you a few questions about something that I heard in testimony yesterday and today. That's the curing process. Are you familiar with what it means, the curing in Maricopa County? Document review?
I am.
Bringing him a note.
Before I get to curing, in your personal experience, when you have you ever seen a check mark in the box on the affidavit envelope rather than a signature?
Absolutely.
Or another indicia of marker, say an X?
Correct. As identified in the user guide, we do have a group or a population demographics that may have some physical incapacitation that requires, and then there are process procedures, how we go about to either cure or register them with that identifier.
So those voters would make a mark rather than place an signature area, what we would all call a signature.
But just if I may, point of privilege, once again, is they can make a mark, but it has to be consistent with their registration file, that is on file as such.
So if you're at level 1 reviewer and in comes the image and it's just a mark, how long does it take to determine that?
If it's consistent, it's an X and an X, then it's as much as looking at a piece of art. If it's the same, it's
Don't
the
even
same
have to
drawing,
sign
the
it.
same drawing.
As long as you didn't also sign it before.
A second to 2 seconds.
No reading involved.
No.
Not even
Just
a signature.
comparing
just a check or an X.
2 marks.
They
No
match 'em up.
11 local or broad characteristics, no swoops, swooshes, and strokes, just looking at that.
Nice.
Thank you. So would you explain for the court, please, what is the curing process?
So the curing process is behind the signature verification process. So when somebody level 1 does set a record as exception, it goes to a manager. That manager concurs that it is indeed inconsistent signature. Then it goes into a status or another disposition, sometimes referred to as a preliminary question, PQ, using these acronyms, or QS, question signature. That allows us to take it down a path to begin the contact using that phone number that's on the voter's registry, on the affidavit, using email, using a ballot subscription service where if you sign up to say, tell me my ballot status, to include when it's mailed, when it's received, and the disposition, then we'll instantly send you a text that says your ballot's been questioned, call our call center.
Why does the Maricopa County Recorder's Office have a process for curing the early ballots?
And it's required in law that we make a reasonable effort. I think we go beyond reasonable, which is voter-centric, but make at least a reasonable effort as required in statute to contact the voter to, in that same section 16550A, that if it's inconsistent, that we will make that effort.
So in your opinion, Maricopa County Recorder's signature verification and curing team goes beyond that which is required by law?
Absolutely, based on some of our cure rates, if you will.
Why is it important to you as a professional in this area to go beyond what the law requires in order to give voters an opportunity to cure an infirmity in their affidavit envelope?
Again, having done this 32 years, and I know my oath of office was brought into question and my integrity as to if I would, we look at this and take this seriously to know that we are about to disenfranchise a voter if we are not making that effort. That's why we, post-election, 298,000 dropped off. We threw all hands on deck because we need to contact those voters that fall into that curing so they have time to cure. So we take it very seriously and make sure that we are as voter-centric as possible, regardless. Again, all I see is the packet that says John Doe on it. I don't know that, am I curing this? I'm curing it for the sake of being voter-centric.
So does Recorder Richards and your team, do they document the efforts they make throughout the curing process?
We do. So we are identifying that it is in the system. There's 2 different processes. In the system, all of what this raw data that we saw, we are noting that it's been an exception. We are noting that it's set as a question signature. Then that contact is made, but we are not returning that into the system, but we are actually physically upon the actual packet. When you ask what happens when we send that disposition to Runbeck, we're sorting those good sig, but we're also sorting those need packets, questionable, all of the different dispositions. We will take those no sigs, those questionables, and we will put an affidavit label or put a label on there that has different action items that the curing team would document what they've done. I contact the voter, left voicemail, letter was sent. All of those things are maintained, and those are trade ready and left in alpha order. Some of the tests that I think was mentioned by some of the temps that were witnesses that are ready to be cured and documented through that action label.
And is it your understanding that the law in Arizona places a strict timeline and the ability of you and your team to assist those voters in curing those ballot packages?
It doesn't set a timeline for us to cure them. It sets a deadline for the voter to reach back to us. Using the 2022 as an example, it's 5 business days, which usually ends up being 7 calendar. There was a holiday on November 8th, so we moved it to November 16th. So we are curing, and that's why we take it the urgency to, by November 11th, we had cured all those because we threw resources at it to contact those voters, to give them the option so that we're not calling them on November 16th at 4:59 to say you have to cure, and it's that extra effort is put towards that.
So in 2022, there was a holiday.
Correct.
Was that Veterans Day?
Yes.
You're,
Memorial Day. I mean, it was whatever November 11th. I apologize.
and that was 2022.
Yes.
And you remember that?
Yeah. Because it's a rare circumstance, and we had to push, just as law requires, anytime that something falls on holiday, you must extend that deadline, and we did. The whole state of Arizona, all 15 counties.
So there really was signature review in Maricopa County in 2022?
Yes, for us to have curing, we would have to have those reviewed to put into that queue.
Which is really the question that he wants in totality. Verification, curing. We did a ton of sausage making here. Another question.
Your Honor, I move to admit Exhibit 26.
No objection, Your Honor.
26 is admitted then.
I wonder if we're going to finish with him today. About what we would expect from this witness. Nothing unusual, just this is how we make the sausage. This is how it goes. It's all very ordinary. Actually, a lot of it resembles what we've already talked about in the first trial, except now we're just really focused on the signature stuff.
Your Honor, may I approach?
You may.
Mr. Valenzuela, would you take a moment and look at the document I just handed to you?
I'm familiar with it.
What is it?
It is basically our, if you will, a procedural document that identifies the early voting contacting, curing process and what its purpose is that we provide to staff, or even as an outreach resource document.
You just testified in some detail about the curing process for people that mail in their ballots that are on the AVIL, what have you, but there are also early voters that don't use the postal service. Is that correct?
That is correct.
And what if
drop
one of
them in ballot
those
boxes and
forgets
stuff.
to sign that affidavit envelope? What happens then?
So there's different deadlines. For no signature, the Arizona revised statute requires that it's done by 7 p.m. on election night, still cured, but has to be done by that deadline.
They don't get the 5 days in the holiday.
They do not. They are required, and we still make a reasonable effort to reach out to those voters through all the various contact methods, as outlined in this document, just the 2 different dates, one for questionable signature, one for no signature.
Your Honor, I move to admit Exhibit 27.
Any objection?
No objection, Your Honor.
27 is admitted.
Wondering if we're getting close to wrapping up with this guy. The judge cuts us off at 4:30, I believe. So I'm wondering if they'll let us finish with him, depending on how long cross-examination is, or if we'll save cross for tomorrow and then do closings tomorrow.
Your Honor, may I approach?
You may.
More exhibits.
Mr. Valenzuela, have you had a chance to look at that document?
I have.
You recognize it?
I do.
What is it?
It is our voter contact label guide we give to staff. It is basically those individuals that are tasked with the curing process, what they are to do, what these acronyms on the label that's shown on there, bottom left-hand corner, action circle. And it's just a legend of what, if they left a voicemail, if they left a message, if the letter was sent, no voicemail, tons of different guides or contact actions that are tracked by, and the date that was done by that particular staff member.
So LS means letter sent,
Correct.
WN, wrong number.
Correct. All the way down to the last one, verified, which would then have that verified and approved stamp resent through, adds to the integer of that log file, but it's resent through and re-reviewed in 1 to 2 seconds because it has that stamp verified and approved. So all of those packets that would have been cured by the voter would be rescanned, re-reviewed, and known to me that it would take less than 1 to 2 seconds to disposition that as good.
Because it's already been stamped.
And it's already been reviewed and it's already been
Less than 1 to
validated. It's
2.
now just for ministerial kind of duties. We're capturing and archiving that image.
So all the time that it would take to review that and verify it and stamp it, that time wouldn't count back in that earlier document where their contester is saying, trying to figure out the averages of how quickly everybody does it.
Correct. That would, what,
That was exceptionally.
That was leading.
Been a lot of that.
Mr. Valenzuela, does it take a lot more time to cure an affidavit envelope and have it get all the way down to the code VER verified, action selected when the voter verifies the signature than it would to look at 2 signatures and figure out if they're similar or not?
it takes upteen amounts of time because of the fact that it is reaching out to the voter. We have shifts that'll be doing specifically that, and it could take days, quite
Take
frankly.
days. But once that's completed, there's a stamp placed on that one, right?
That is correct.
And then it goes all the way back to level 1, correct?
That is correct.
And then that machine in Maricopa County that sent the data to the contester here is going to have a really low number because when they looked and saw the stamp, it was just a really low number, right?
That exact user ID could have been categorized as an exception that took 5 seconds, could have gone to manager's level that took 12 seconds to concur. And then when it came back, that third scan would be 1 second to disposition it as verified.
To see that stamp could take only 1 second.
Boom, boom, boom,
Correct.
boom.
Or maybe less.
That's
Possible.
why.
Correct.
Well, why'd they remove that guy then?
And so if you took.
Is
so
that what he did?
My question to you is
Steve?
all the time it took to get that verified stamp on there, none of that would be reflected in the mathematical calculation that you saw earlier today put forth as alleged evidence.
So they just
that there
weren't
was a
measuring
signature
the
review
right stuff.
process done. Is that correct?
Leading, Your Honor.
Okay. It is leading.
What's your
Now,
conclusion?
you previously testified, Mr. Valenzuela, that it takes a lot of time for the Maricopa County Recorder's signature verification team to cure a ballot all the way such down that it gets to the verified stamp on it, correct?
That is correct.
And you have also testified that the time reflected in that is not accounted for in the document that was produced by the contester, Kari Lake's team, which they presented in the court while you were watching, correct?
Correct. It's leading.
Mr. Valenzuela previously testified he doesn't even, he's not even have personal knowledge of the contents on CD-ROM other than approving their disclosure to us. He hasn't looked at the data. He's admitted that. He hasn't reviewed the data. He's admitted that.
Okay. Rephrase it then, if you got another way of.
Mr. Valenzuela, were you in the courtroom earlier today?
I was.
Did you see, did you hear and watch the testimony of the alleged expert put forth by plaintiff?
I did.
You see up on that screen there when they put that document up there that he was testifying about?
I did.
Did you understand that the amount of time it takes to verify an affidavit envelope under the hearing process was not included in that data?
Correct.
Thank you.
Still leading, Your Honor. My objection is do to get
what is your opinion on
fundamental understanding
what
of the very data
Mr.
that chart was
Speckin
based
said?
upon.
The question was asked to the exhibit.
Do
I'll
you
just
agree
note
with
for the
his
record,
conclusion?
all the objections as to leading are new in this case. The other side extended the courtesy of never objecting once to anything leading throughout the entire presentation of plaintiff's case. But if you insist on objecting on leading, I can sustain those. They have to rephrase it differently. Just pointing it out as a matter of professional courtesy, but it is something that typically is true.
If Your Honor, if I heard you right, you asked him to rephrase your, asked and answered anyway, Your Honor.
I didn't understand what you just said, Mr. Bunn.
Oh, I could not hear too much in front of me. If you said something about rephrase it.
He can rephrase anything. If you're objecting to leading, some of leading in the case has to do with streamlining.
My response was asked and answered, so.
Understood. But we're at the end of the day. Okay.
The two questions,
You have
the two that I handed you, Tom.
You'll have to come in and or not to. Your Honor, for clarification, the last response that he gave, is that in the record, or have you taken that out because you've ruled that the question was leading?
The question was leading, so I sustained the objection. I was just noting for the record that it can be rephrased and asked a different way. That's fine.
If I may, Your Honor.
Say again?
If I may, asked and answered, so.
Thank you for the professional courtesy. Appreciate it.
Very well.
This is getting
Go
really
ahead.
tense in
Next
here.
question.
Mr. Valenzuela, are all level 1 reviewers trained to question the check mark stamp?
If it is inconsistent with what is on the official voter registration record, absolutely.
That would go for an X also?
There is an X or any mark that is inconsistent with what is on file of the official registration, they are indeed asked to make that an exception.
Are level 1 reviewers trained to re-verify signatures bearing the check mark stamp?
I wouldn't say that they're asked to re-verify. All of them are asked to re-look at their sub-batch of 250 to see their status. If they originally set that as exception, they should confirm that in their backwards review of that.
So when a level 1 signature verifier completes a batch of 250 signature verifications, the protocol is for them, before they submit it, to go back and review each one.
And I may add, again, for edification, not review in the same level of, I've looked at 3 exemplars, I deem this to not be the same, that they are identifying that I set this as an exception. Before I commit the batch, I'm going to look at that, and yes, indeed, I don't redo the 3-level scrolling, or if it's a good sig, they're just reconfirming.
In your experience, that's much faster than the initial review?
It's much faster, and again, it's not logged because it's not a disposition set.
Your Honor, I move to admit Exhibit 28.
Any objection?
No objection, Your Honor.
28's admitted.
Your Honor, now would be an appropriate time to break for the afternoon.
All right, very well. We will do that. We will resume tomorrow morning at 9 a.m. and we will be adjourned until that time.
All rise. Where's the judge? All right, so that's the day. All right, well, that is day 2, my friends. So we're finishing up today. We had Ray Valenzuela. He was a witness for both sides. All right, this guy works for Maricopa County, and he was called this morning. We started the day off with him, bright and early, 9 a.m. court in session, and Ray Valenzuela was there. And we had some questions. He was actually Kari Lake's witness at the time, and we were asking him about his role, and there was no cross-examination of him. because we just launched right into, because of this, because they were going to call him back. The defense was going to call him and then clean up all of the cross-examination. So both sides called him. This is what we heard from today. Ray Valenzuela, and then a big portion of our day was Erich Speckin. And today, you know, I'm not sure how productive today was, really, for either side. Kind of just slogged through it, to be honest. I think that there was some very precarious incidents with the Kari Lake almost resting with this individual. Erich Speckin was brought out to talk about his conclusions based on his analysis. He was qualified as an expert by this court, but his credentials were really hit pretty hard by Kari Lake's team. I thought he did a nice job of bringing it back up and rehabilitating himself. And this is not uncommon with experts. They're always attacked. And this guy's been, you know, testifying all over the world in many different states. And so the fact that they went and singled out a couple specific things to needle him on is not shocking to me at all. There were some, I think, opportunities to dig deeper when they were cross-examining, or actually direct examining, Ray Valenzuela. These were some of the questions that I had as we were just sitting here listening to them. But I wanted to dig into the explanation or the investigation of Steve. Apparently, this is Steve the Pecker, this guy who's just clicking away. Ray Valenzuela said to us that he was going backwards. He was just checking his work, and that is sufficient. And this guy's not doing the same thing, right? This guy's actually going slowly, going through it the first sequence. This guy on the left is going through it in the reverse sequence. And I would love to dig into that. I'd love to know what happened with the investigation. How does the investigation process work in general? What do you guys do? How does it work? Does somebody file a complaint? Does somebody identify it? Do you measure performance metrics? What's the deal? What are the criteria? What are the indicia necessary to remove that person? So once you identify who that person is and what their problems are, how do you remove them? And then we can extrapolate from all of these questions similar problems that are so pervasive, so extensive, that they would invalidate the entire process. Okay, we've got to take a place where we can latch into it and then exploit it. How many others were removed? You told us that Steve was reassigned. How many others got pulled from the case? And did you check Steve's work after you pulled him off the line? Did you go back through and verify every single one of those things that he touched was legitimate? And if you did, who did that? How many ballots did Steve process in the first place? When was he removed? And how many did he touch up until that point? And did you go and check his work? If he was incompetent at one task, and apparently he was, because you did remove him from that position, and we want to know what the criteria were that justified his removal, do those same criteria translate over into his new task? In other words, if this guy is incompetent on a computer, or he can't match signatures, or he has a hard time matching curly cues or whatever, what is he doing? And is he still tainting, jeopardizing the entire process? It's one bad apple spoils the whole bunch. And if there's a mechanical problem, not just with one person, but with the identification of problematic people and the removal of problematic people, we need a mechanism by which we can identify something that has gone askew in an election. Otherwise, if you can just, all it takes is one person to go in there and just throw things awry, and they can't fix it, and there's no remedial course of action, then is that really a safe and secure system in any way at all? No, because once the injection makes it past the line, the whole thing gets compromised. So obviously there's a whole bunch of mechanisms for this, right? There has to be a methodology. What's the process for identifying somebody who's incompetent or who's actually malicious and removing them? And how did this all play out today? Did you double check that work? What political party does Steve belong to? That's what I'd like to know. Many of these people, we know their background. We heard from Jacqueline Heineke, who said that she declared what party she was from, and many of these people are volunteers, but we'd like to know, what party is he belonging to? And were there any other people? And I'd like to know where he is. I mean, why wasn't he subpoenaed or a part of this? I'd like to know who communicated with him at Maricopa County. I'd like to know specifically, did Ray Valenzuela talk to him? Did Scott Jarrett talk to him? Did Bill Gates, onesie twosie Bill Gates talk to him? I don't know. But wouldn't it be nice to know? And what were their conversations about? Are there emails about this person? All this is too late now, right? We're in the middle of trial. This would be good to know in discovery. And why don't, and if he comes out and he says, well, I'm not familiar with that, right? We heard a bunch of this stuff. I didn't bring those numbers. I'm not familiar with all this material. Well, why not? Have you seen this video before? You saw our disclosure. You knew we were going to talk about this case. You're meaning you're not prepared to come in here. You run elections and you're telling me that you don't know about this big problem. You didn't look into it. Well, why not? Do you look into any other problems? Oh, so you don't look into any problems unless they meet what threshold for you to verify that it is good. Okay, so any problems that don't meet that threshold are not within your purview. And so you don't actually have any basis for telling us whether this was done appropriately or not, because you didn't even investigate somebody that your own side admitted you removed from the line, and you don't know about it. So there's this big gray area that you have, don't you, Ray Valenzuela? You can't speak to that, right? And how did you identify and remove Steve from the line, and how did this go to others? So that's what I would like to see on Steve, because once you can get clarity on this with Steve, then you can take it and extrapolate that. You can blow that out and say your systems are so bad that it is as though you didn't even do signature verification. And they're going to try to bring all of these things up into their closing, and I hope that they can thread the needle. But that, my friends, was really the crux of the day. We had a lot of testimony from Erich Speckin, and I'll tell you, there's actually, there was a lot of mechanical stuff that we were dealing with today, documents and objections and form and copy this, and we had a whole litany about statistics and calculations and all the things. It's a lot. And so we covered a lot of good ground. I forgot to mention today our friends over at fieldofgreens.com. And so, of course, before we jump into your super chats, let's make sure that we're all healthy and nutritious and fortified, because, man, today was a lot, and we got to make sure we're properly healthy, you know. And so, of course, we all would like to lose those leftover pandemic pounds, I know. But how sick are you of those weight loss ads for fad pills and fad diets? You know, we've all been there. We've all done that. And they just don't work. But you know what does? Field of Greens. I'm going to go guzzle some here in a minute so I can get properly fortified. Because if you do that, the weight would probably just fall off. But I know fruits and vegetables are kind of a big pain in the butt. You don't have to worry about that. Instead, let's talk about Field of Greens, which is a science-backed formula, very, very specific fruits and vegetables you're not going to find in any other product. And we know that proper nutrition reboots your metabolism so you can lose weight the healthier way and get the only brand backed by a better health promise. Yes, you're going to look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, wow, you've lost weight. Whatever you're doing, keep it up. And so go on over to fieldofgreens.com. Don't forget to use code Robert so you can save 15% at checkout. And don't forget, my friends, the vegetables want to be eaten. That's how we stay very, very fortified everywhere we go. All right, and so I want to say thank you to some of the amazing supporters that we saw come in the house. And thank you, everybody who has been so supportive today on this extra long stream. Who's here? We got Brad Bowers. Brad says, there was clearly cheating and extreme incompetence, but can she win? So it's a tall order, right? We're talking about a case where she's got some heavy lifting to do, no doubt about it, just because the standard that was set is so high. The judge, I think, is wanting them to show that something happened such that it invalidates the entire process. And so they're going to make that argument tomorrow. We're going to see how it unfolds for us. And so thank you very much, Brad. We also had we had one from Patrick Parker. Patrick's in the house. He says, go D-backs and praying for Dark Side Dad. Well, that's nice. Yeah, Dark Side Dad was traveling out to go visit his father in the ICU. And so we're praying for Dark Side's dad. Hopefully he made it there and he is by his father's side. Thank you, Patrick. I encourage that too. Jonathan Smith says, judge who didn't hear claims the first round. Thoughts? Judge who didn't hear the claims the first round. Well, I think this was the same judge. I might be misunderstanding your question, Jonathan, but I think this was the same judge at the start of the case. He's the same judge that we heard for first trial. So he heard the original complaint and he heard the first trial, and he's the one who got appealed, actually. All that got appealed and came back down in his court. Patrick Parker says, boom, you go, Judge. Good to see you again, Patrick. Thank you for that. This one from Zalkurin. He says, is there any way you can assist them, like be a part of the council? Because they don't ask some of the questions you do, even if it's not your specialty. Well, it's definitely not my specialty, but I don't think it's many lawyers' specialties. There's probably just a handful of lawyers in Arizona who've done Arizona election cases. Probably, a handful of lawyers in the country that are really dedicated to elections specifically. So it's certainly not my expertise, but it is, it's like the law. It's like anything. They're just big puzzle pieces. You just find what the rules are, and then you make arguments around the rules. The judge gave us some pretty clear rules here. So we've got to make the arguments fit into the rules and then get organized and then ask questions. But it's probably a little bit too late. Obviously, right now, we're in the middle of trial. We're on day 3 tomorrow. We're going to have, cross-examinations and closing arguments tomorrow. It's a very nice compliment. I do appreciate it. But the train has probably already left the station on that one. Of course, I'm available to help. I mean, I'm happy and willing to help. In fact, part of the reason I think some of this commentary might be useful is so that if there are individuals who are observing what people are saying, I think, look, the court of public opinion is a very big place. And if you throw ideas out into the ether, maybe sometimes they'll work their way back into various people's ears. Whether it's useful or not, I don't know. But I am trying to help in our own small way, right? We are trying to, hey, if we can put some ideas out here, if some of these questions trigger anything for, closing arguments or some other arguments, maybe it'll make its way out into somebody's ear. Thank you very much for that, Zai Curran. I appreciate it. Dolphin fans in the house, what's up, says, wow, Rob, let's go to another case. We got what we wanted and we didn't use it. Good to see you, Dolphin fan. And thank you for being here. Let's go to another case. Well, we'll finish this one and then we'll get to another one. No doubt about it. Hey, Brian Reinhardt's here. Welcome as a supporter. Don't forget to grab the Telegram link when you're over on the YouTube members, grab that Telegram link so we can join you. You can join us in the Telegram. We have, we got KX250FMX in the house. Says, I'm so excited. My first day of law school. Here's a little something for my tuition. Well, thank you. You're paying me for your tuition? Well, that's really nice of you. I appreciate that. I don't know, I'm sure it'll go to good use in locals, but I do appreciate it. And shout out to your first day of law school. We had a nice lesson today in court about some of the things maybe not to do from a couple sides, but congratulations. It's a big endeavor. It's going to be a heck of a journey. It's going to be a lot of work. You're going to be reading a ton of books, but it's worth it. If your heart's in it, stick with it. And when you come out the other end, you'll be a little bit of a different person, but you'll have a lot more experience in the law, certainly. And I think it'll help you get some clarity. At least for me, my experience was it helped me get clarity on where I wanted to go and what I wanted to do. And I had more tools to do those things. So congratulations. Hopefully it is amazing for you. Wishing you all the best. We have, okay, Zach's other one is in the house. Good to see you, Zach's other one. This one came over from our friends on Rumble, and shout out to our Rumble friends. We had a nice group on Rumble today, so I really appreciate everybody watching over there. A lot of lively chat. We got Leg Bad, T-Tones over there. Groggy's in the house. We got G. Spence Clay. I had a law school professor with a very similar name. We had Slightly Salty's in the house. Good to see everybody. Zach's other one says, in order to combat a corrupt system, you need an all-star team. Instead, we get these clowns. Yeah, you do need... We could use certainly a bigger bench, no doubt about it. We had this one come in from Economath, which sounds like a very smart individual. It says, hey, I have a master's degree in econ, and Uncle Sammy pays me 6 figures to do addition. I resemble that remark. Very good. Yeah, very good from Economath. Obviously, he's got a master's degree in econ, and Uncle Sammy pays him 6 figures to do addition. And he resembles that remark. Thank you, Economath. Sounds like a nice gig. 6 figures to do simple addition. Wow. Hey, the Chiefs Way. What's up, the Chiefs Way? Thank you for this one. Says the last 2 days and last week's screw up on submitting experts makes it clear that using out-of-state lawyers that don't know the local rules is problematic. Period. Thanks for your coverage. Period. I think I can feel it. The Chiefs Way. Yeah. I understand what you're saying, definitely. And, I think there's some truth to that. We did see today, actually, we saw it in both trials. There was an attempt to get an expert qualified, and the judge reminded that we don't do that in Arizona, just move on with it. So I understand. Yes, thanks for the comment, the Chiefs Way. I do appreciate it. Thanks for being here. And who else do we have? Patrick Parker's back. What's up, Patrick? Says, I wonder how many times the Hobbs team has thought objection, Judge. On what grounds, Hobbs team? Because it's damning to my case. I think that's a liar, liar quote, isn't it? And we had the liar, liar meme up here today. Your Honor, I object. Why? Because it's damaging to my case. And that's the liar, liar meme from I think that's from Gigam, or that's one of our locals meme smiths. Got the liar, liar face. Debbie O's in the house. Thank you, Debbie. Says, sounded to me like the judge basically asked defense for a motion for directed verdict. That's right. Yes. Is that what you heard? During objections before lunch? You mean, well, we did hear the arguments for directed verdict. I'm trying to think about what timeline you're referencing, Debbie, whether it's, was it after Kurt Olson said, I'm done with this witness, then they moved for directed verdict? I think that now, because it was going to be cross-examination, and then we definitely heard directed verdict. I mean, we basically got like a preview of closing arguments earlier. So yeah, good question. Thank you, Debbie, for that one. Here's another one that came in from IR5. Thank you, IR5. Says, signatures, smignatures. Whatever happened to the tabulator printer mismatch scam? I clearly missed something, and thanks for the great coverage. Well, that didn't even come in as a question. So just to zoom out very briefly, remember Kari Lake submitted a whole slew of questions, complaints, like 9 counts, I think, multiple counts. And one of those counts brought up that issue. But that's not the count that we're on here in this trial. That got dismissed. Those other counts got dismissed. So we can only move forward on the one claim, which is really the very narrow question, which is about the signatures. Jentifer says, I just got here 10 minutes ago, whenever that was, probably a while ago. Is this live? Sure is. You better believe it, Jentifer. Glad you made it. K Shaw, what's up, K Shaw? Thank you. Oh my gosh, is that Nintendo? Looks like a Super Nintendo. Super Nintendo. Charlotte Sanders is here. Thank you, Charlotte Sanders. Welcome to our supporter level on YouTube. Don't forget to grab the Telegram link. We very much appreciate you joining us. Charlotte Sanders. And Melanie, welcome, Melanie. Melanie says, Kari's lawyers are not making me feel confident that they will win. They did seem a little bit disorganized, and there's kind of a distinction. You can argue the judge's case, or you can argue your case, and it's better to argue the judge's case or the jury's case than your case. And oftentimes people will default back into their case, and they'll think it's a great case, and we may have a ton of evidence that I agree with, actually. Like, there are mounds of evidence that I wish the judge would consider, but the judge set what the standard is. And I don't know specifically, Melanie, what things are standing out to you, but I can understand your position, certainly. And so thank you for sending that one in. Voice of the People is in the house, says, I'm gonna take some clips of this for Saturday's show for Off Label Podcast. Yes, and we did a show with Off Label Podcast. That was a couple weeks ago. I think we were talking about some of the January 6th stuff. Was that right? So yeah, check them out. So check out Off Label Podcast, and they'll have some clips from today's, and I'm sure they'll do a great debrief. And shout out to Voice of the People. We appreciate you supporting us, and have a great stream, my man. Patrick Grog, supporter. Welcome, Patrick. Welcome, welcome. And when we're off the trial schedule, we will come back and we'll do our member only morning streams. But when we do these 8-hour marathons, it's hard to do extra stuff. But normally we do member only stuff. And for example, we'll do a Saturday show for members only. So Patrick, we'll be looking forward to seeing you there. Linda Ramey's in the house, says, hey you. Well, hey you, Linda. Good to see you. And look at this pair. Look at this pair. He's being very, what's the word? Hard to get. What's a good adjective, a synonym for that? Coy. Maybe he's being coy. He's like, you can kind of see him from the side. Good to see you, Linda. Appreciate it. This one came in from John. He says, this is Rob's version of movie night. He says, by the way, Rob, you said that you already read my message yesterday. I reattached several times. Nope. You were just tired and thought you read it. No more $20 tips for you, Rob. That's from John. And John, when that came through, I actually looked this up. And I'm pretty sure that I did read it, if I remember correctly. I thought this was it, but I haven't listened. Let's see if this is it or not. Thank you to John Allen over on Locals. Says, Rob, we really appreciate you working so hard, doing such an excellent job. Well, I appreciate you, John. And as always, you help bring in some laughter when these government stooges frustrate us. I know it's not much, but I wanted to show you my gratitude. Thank you, my friend. And thank you, John. First of all, that is a ton. That's a ton. And I very appreciate you for sending that. But I just appreciate you being here and joining us as we go through this very important stuff, because, man, this stuff is important. This is our country. Humanity has worked too hard to get here, and we cannot allow this to just be taken away. So we've got to pay attention, and I appreciate you being here and joining us as we do. All right, so that, John, I think was the one that we were talking about, just to make sure that we got it. And I appreciate you sending it in, and I appreciate the new one sending it in as well, making sure that we got that one read. I think that's the one you're talking about, but I appreciate it. We also had Drearier Spider said, Rob, according to Barnes, TYP signature challenge just needs to demonstrate more mismatched signatures than margin of victory. In my opinion, Kari needs to show the actual signatures to preserve appeal, assuming she got access. Your thoughts? And I think we covered this one a little bit earlier on the show. And I think that there are many layers to this. And, the preservation of the signatures was something that I don't think is an issue right now. We had the we had the complaint of count 3, which only focuses on, according to the judge's standard, the process, whether the process was conducted or not. So as we even heard from the expert today, and we weren't sure about this, I think, when we answered this, was from Erich Speckin. Erich Speckin, he came in and really didn't even talk about the individual signatures at all, right? I mean, he didn't say I analyzed certain numbers of signatures at all. He just specifically talked about the numbers and the volume and how they all match up. So that came in from Drearier Spider. We appreciate that one. Let's make sure we hit a couple of these others. We got Rocky Waters in the house. Says, God bless you, Govea. Thanks for covering these trials and spreading the word. We also had Rocky Water send this one in. Says, do you know, is anyone planning to call any of the room managers as witnesses? No. Which witnesses remain for the prosecution? That's it. We just had one, Valenzuela. I think we've heard from all who've been 3 level 1 people, 1 MC official, and the statistics guy. Yeah, this is it right here. These are all of the people that we've had here. Erich Speckin, and Steve the Pecker wasn't anybody who testified. We just clipped that out with our questions. We got Ray Valenzuela testified. Andy Myers, which was, I think, level 1. Shelby Bush wasn't involved. She just scraped some of the data. Same with Chris Hansel and Jacqueline Owen. So, yeah, we didn't have Bill Gates, onesie twosie Gates. We didn't have Scott Jarrett. We didn't have anybody come in and communicate about any of that stuff. So I'm not sure why they didn't call those people, but they didn't call those people. Another one from Rocky says, it's not statistical conclusion. It's a conclusion based on the statistics of averaging and simple division using a calculator. I wouldn't call it statistics. It's basic math. And I don't know what they wanted like you have to have credentials as a statistician to talk about basic math and to come up with charts and conclusions and stuff. We're not talking about really too complicated, like we hear about numbers all the time in criminal law without people being statisticians. Okay, cops talk about numbers and stuff. It's strange, but they were grasping. They didn't want him to talk, obviously. And we had KX250 says, I'm so excited. My first day of law school. Here's a little something for my tuition. I think we got that one. And thank you to JC, who says, Governor Lake by tomorrow. I wouldn't hold your breath on that one, but it is a possibility. There is a chance. So you're saying there's a chance? I'm saying there is a chance. Calm and Free in the house. Thank you, Calm and Free. Says, appreciate you, Rob. I do appreciate that. And I think this one came in from locals. Come on, locals. You're letting YouTube out-tip us. Oh, a little healthy competition there. In the name of super chats and tips, I'll take it. Melanie, another one, says, Rob, I'm not confident that Kari's lawyers will hit the key points that you summarized during their closing. Can you please go do it for them? I can't do it now. They're on the case. We need a solid and compelling closing argument. We need a W. I would love a W. If I could help, I certainly would. I think that train has left the track, the station. But I do appreciate it. So thank you for that one, Melanie. And thanks for being here with a couple of those today. I do appreciate it a lot. This one from Calm and Free. Rob, give us the bottom line for today. I think we probably got that, Calm. Maybe, hopefully you agree with that. I think we kind of got that in summation a little bit earlier at the conclusion of the testimony. But, I think we slogged through it. I don't think there could have been some really big catastrophes that were avoided, which was good. And I would have liked to have seen a little bit more in terms of really closing the loop on some things, but we'll hold off until closings and see what they're able to thread together there at the end. But good to see you, Calm and Free. I do appreciate that. Local admin says Lake's expert's opinion on what constitutes, quote, verification has no weight when the judge was clear with burden at the beginning. So I think you're making the point that the government is making, which I think is closer to the point that the judge is making, that so we're arguing over words, we're arguing over the definition of verification. I think this is an accurate point. The judge says verification is simply the mechanics of somebody verifying a signature. If they just did the thing, like if they went through the motions, like I could bake a cake, okay? Like technically I could bake a cake, but are you going to want to eat that? And is it really a cake if you can't eat it? Not really. All right, give me a bunch of crap, I'll throw it in there and it'll probably turn into something, maybe. But it's not, I don't know, I don't think I'd call it a cake, right? You could try it, maybe you'd think so. Probably not if you didn't die. But the point is, it is not the thing. So we're arguing about verification. The judge says verification is just, if you go through the motions, if you add the ingredients into the pan and you throw it in the oven and it comes out, you're done, man. I don't care if it tastes good. I don't care if it looks good. I don't care if the 3-year-old birthday party event is going to be ruined or not. You baked a cake, you're good in my book. Whereas what I might say is, well, if we're going to be baking a cake, you got, it's like if you're going to build a house, I'm going to want some utilities in it. If I'm going to give me a car, I'm going to want to drive it. If you give me a cake, I'm going to want to eat it. Otherwise, it really doesn't fit the definition of that thing. It's missing a major component. So Kari Lake's team is going to have to fit in and redefine, quote, verification to make it as though it is a legitimate process that was actually completed. Verification, signature verification means the whole thing was done appropriately without systemic problems. But the judge is not, I think, going to hold them to that standard and just say, well, they did enough of it. And Kari, you can't judge the internal operations of that process. And so I would even agree with this. Lake's expert's opinion, the judge might hold, it has no weight because he did acknowledge that there was the mechanical process of the signature thing, of the signature verification was in fact taking place. We had another one from Tanya Karras. What's up, Tanya? Says not acceptable. 4 exclamation points. Oh my goodness. That's a lot out of Tanya. Okay, we know Tanya very well from Taco Tuesday, Banana Day. And it four exclamation points. Things are pretty serious over there. All right, we're gonna have to check back in. Okay. Tanya. Well, at least it's not 5 exclamation points. All right, we'll probably be okay. If it's 5 tomorrow, we'll have to come back and check. All right, First Amendment says, thanks for putting all of this together. Says, what are Kari Lake's odds? My guess, not very good. It's a pretty good guess. It's a very high standard, right? And listen, I live in Arizona. I don't want at all to live the next 4 years with Governor Hobbs, all right? It's going to turn into a crap hole here. And we're already seeing it, actually. So I am not trying to be a downer, but I am also wanting to be very clear. The judge has set an extremely high standard. And based on what we read here, he even underlined it, and he even bolded some of it when he said no and any. So odds are it's a long shot. I actually really do think that their argument is clever in that but they've got to thread that, right? They've got to really bring it home, and we'll see what the judge does. John McGarvey also said, where'd I go? John McGarvey says, the dude threatening the witness deserves no respect. And John, I saw that come in the comment when I was saying, these guys, like, it's a lot of hard work. Let's give them a little bit of grace and the so on and so forth. And you made a good point. That other dude did come in and he did try to threaten her with some criminality. And I also agree that that was gross behavior. I think the judge agreed that that was gross behavior. And so we'll say, except for that incident. Ian Mack says the government says, hey man, we have this guy who sits in the back office who looked at the signatures. Like, we swear on it, okay? Pinky promise, he did it. So we're good, right? Like, we're good. Since we're the government and we do everything right and nobody ever can challenge us. If you do, we'll threaten you with criminal charges. So you're good, right? We're good. And we won. And if you challenge us, we'll probably prosecute you. At least at the federal level. Good to see you, Ian. Thank you for that. Ray Roberson is in the house. What's up, Ray? Says Lake needs to state how many checks need rechecking over 3 seconds for validity and who the candidate voted for. So like an audit or something to see how many. Well, that was a similar question that I had with Woodpecker Steve, that guy. How many ballots did he process? How many of those need to be rechecked? And I would also be very curious to see if there's correlation, right, between these. And those 99.97 percentile, pass rates that we heard from Erich Speckin as well. Good stuff. Good to see you, Ray. Thank you for that. Sherlock Gnomes says, hey, Rob, thought. Votes are equal. SIG verification absence therefore meets the standard. Then a matter of were enough affected, Lake stated in the opening. Voters are equal. Signature verification absence therefore meets the standard. Then it's a matter of whether enough were affected, as Lake stated in the opening. So I think the argument, you could kind of make it like an equal protection argument. You could also go that route. Remember, yeah, that's an interesting thought too. Now I'm thinking about Bush versus Gore. You got me spiraled off into Bush versus Gore. And there's a whole equal protection argument there as well that we haven't even brought up at all in this trial at all. I don't know if that's where you were going, Sherlock Gnomes, but yeah, there is an equal protection element to this. It's way too late to plead that, and I don't know if they did that in the original complaint. They may have. That may have already been dealt with. But in Bush versus Gore, the big issue was there were different standards of interpreting the ballots, in other words. And if you allow different standards, then some votes are less equal than other votes. Some votes might be counted, other votes might not. You've got an equal protection problem because all votes should be equally protected under the law. So that's an interesting comment there. And I don't recall if that argument was made in previous complaints and then dumped or not, but good comment, Sherlock. Good comment. Sergeant Willie's in the house. Sergeant Willie. We love Sergeant Willie in the house. Come on in, man, and grab the Telegram link and join us over there. Welcome as a new supporter. We've got, hey, SR Dempsey's here. Says, thank you. Future note to out-of-town attorneys, hire a local. Generally a good rule. Generally a good rule. Words mean things. Thank you, words. Nice compliment. Says, Rob, they need you in their war room. Maybe next time. We'll see what election 2024 looks like. But holy moly. Thank you for that, Words Mean Things. Very generous. Very great to see you. Thank you for being here. We had this one from local admin. It says, I'd rather pay for a chat than another audit. That's fair. That's fair. You mean as like a taxpayer? Listen, I don't want to pay for, I wish we just had good, nice, secure elections. They say we do. I don't believe them for a minute. But I don't want to pay for, I'd rather us not have a trial. I'd rather us just have elections that operated appropriately, where we didn't have, I don't know, half of election day voters, the vast majority of which were Kari Lake voters, disenfranchised on election day. I would love for that to happen. Now, we're not even talking about that anymore, as you know. Did you notice that? How we're not even talking about the biggest component of what went wrong on this election, which was that on election day, there were lines out the door. There were people who could not vote. We know that there were delays. We have the videos from onesie twosie Bill Gates communicating it. Errors all over the place, disenfranchising people from voting on that day. We can't measure who didn't vote. It's trying to prove something that doesn't exist, but we're not even talking about that anymore, right? In my opinion, that is the biggest problem with this whole election. But now we're just talking about the details on signature ballots. They created a systemic failure in the election so that when you showed up to vote, you were disenfranchised on that day, at least in the morning. And they only needed 17,000 people to decide, well, that line's too long. I'll get it on my way home from work or whatever. And then they don't. But now you can see the complaint has been extremely narrowly brought in. And now we're just talking about, strangely, not whether about there were printer problems or signature problems. It's just whether signature was done or not. Zachary Rossfield says, do you think this judge will even care what they say in the end anyways? I feel like the judge is going through the motions, made up his mind. It's a good comment, Zachary. I don't know. I mean, I think the judge, he's human like the rest of us. And I think he knows that he set a very, very high standard in his opinion. So he wrote it. It's going to be tough to meet. I think he knows that. He's probably listening, I think, openly. To be honest, I think this judge has been extremely patient and extremely fair and made rulings and given people on both sides leeway that I was trying to think if I were a judge that be like, come on, guys, like enough of this, and he's been very patient and we sat through it. I mean, we spent an hour on statistics, for crying out loud. Talk about patience of a saint. We've got Super Buff Shaft says, here is the forensic audit and all should see what was covered up by both parties. And so go over to Super Buff Shafts. There's a if you're on the Rumble chat, you can grab that link. I can't obviously click it here, but thank you for that. Thank you for sending that in. A lot of good information on Rumble. Super Buff Shaft shared the link over on Rumble. And so go check that out. Looks like it's a Rumble video. Oh, looks like it's from Jovan Pulitzer. So maybe check out his channel on that one. Thank you, Super Buff Shaft. We also have this one from Thermos. Oh, the most banned queen in the house says this expert didn't talk like he wanted to give that kind of determination to say it wasn't happening at all. That's right. He was very clear about that. He was very clear that he could not say that it was not happening at all, which is why the argument had to change into it was happening, but it was happening so poorly that it is as though it was not happening at all. And that's what I was waiting for Kurt Olson to connect for us. We had this one come in from the most banned queen. Says, I wish Lake had a whistleblower who had decided to record her conversation with her boss after her being uncomfortable with what they were being asked to do, perhaps a veiled threat to just go along with it. Yeah, I wonder about that. I wonder if they make you drop your phones off and stuff. I wouldn't be surprised if they did that. SR Dempsey in the house, thank you, SR, says this one, says, the setting of the expectations by the judge created an unreasonable burden. I like how he runs his court, but the outcome is set. The cover has been pulled back on this sham. It is a tall standard. He is running his court, I think, very graciously. But look, just think about this for a minute, just practically. Okay, we're asking this judge to literally declare that the sitting governor and her entire administration across the state of Arizona, as illegitimate as they all are, and I think they know it, He's going to order her to get out of the office, and he's going to put Kari Lake in. Just think about that ask alone and whether that can happen. Legal or not. This is why this system, I think, is so broken. It's the first past the post. If you get in and you get seated in that governor's seat or that president's seat, you're done. And that's why they rush these challenges along so quickly. You almost can't even challenge them. Let's see here. This one came out from the most banned queen from Rumble. Says her counsel is fine, and I bet they had reasons for not asking the questions you think they should ask. That's fair. Yeah, I could be totally off on this. Maybe they know a ton of other stuff that I don't know. They obviously have the files. I don't. I agree that I am not there, and I have not been working on the case. We're just giving our best observations from here. She says, I think it's because facts aren't on their side, but I wish it was. That I'm not so sure about. I think that there is a lot of evidence on their side, but they just can't talk about it or necessarily get it in because it's an absence of evidence that they're trying to prove. And in this trial, it has been so narrowed down that we just can't get into other things. But it's a fair point, and I appreciate you sending that one in. The most banned queen. Mac McCormick says, so according to his testimony, the minimum time to compare is 1 second. Therefore, the 70,000 signatures that took less than 1 second would be invalid. Yes? Well, it depends whose testimony we're talking about. I think if you brought that up with Erich Speckin, he would say yes. If you brought that up with Ray Valenzuela, he would say no. He would say no. A big portion of these less than 1 second clicks were just verification clicks. They were just, you saw stamp, click, bop, 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 bop. In other words, you do like 5 a second. Just click, 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 click very quickly. And that essentially he was arguing that Erich Speckin and Kari Lake's team were measuring the wrong stuff. They were measuring stuff that they thought should be ballot signature verifications, but they weren't. They were also rechecking homework. Those were also the entries, rechecking homework. And so they were just basically measuring the wrong things, not comparing apples and oranges. Another one came in. Thank you, Ian. Says they need to pull this Muppet up on level 3 nonsense, audit nonsense, saying, okay, so 49 out of 50 will never be looked at again if level 1 bulldozes through them. Is that right? Yeah, it's a good question. That is a good question from Ian. So you send them, they go up, you send them all back down. Level 1 bulldozes through them. They don't come back up again, but they send them up to you. And what happened with level 3? We didn't really talk a whole lot about level 3. Randall's here, dropping a swear jar. Thank you, Randall. Thank you for honoring the swear jar. We appreciate that one. Today was a swear jar worthy day. I mean, if you're going to be utilizing the swear jar, today's a good day to do it, no doubt about it. We had another one come in from S.R. Dempsey. Says, weren't the 0 to 3 seconds about 100% acceptance? Where are the rejects that needed review? Yeah, it was a tiny number. It was like 9. Remember? Well, yeah, it was like 9 out of 10,000 is what he said when it was like 99 point whatever percent. Where are those rejects? I think the bigger question is why. Yeah, it's a good question. If we extracted those rejects and looked at them, how bad are they? Are they like total opposite signatures? And it begs the question, what is the threshold for an acceptable signature that will survive? And how do you implement that across the board? And are there deviations amongst that? Are some people matching at 80% and others matching at 20%? How do you monitor that? How do you separate those two people? How do you pull the 20%er out when the 80%er is there? Is there quality control in any form, I guess, is the question. Do we have quality control? Do they care? I guess that's a good frame of this. Kari Lake is saying quality control is so bad that it's as though no product was ever produced. There was no signature verification because quality control was so bad. Government says, we don't care about quality control. We did the thing, we produced the thing, we're done. Alex is here. What's up, Alex? Borska says, wait, so the first level, not the first person, not the same person, looks at the same ballot twice or more with second and third. So the low number and the high level would even itself out. So 12 seconds, then 2 seconds, then 1/2 second. So yeah, it's actually, I mean, it starts at level 1. If their job is to approve. They don't reject anything, as Valenzuela told us. They accept it. Then it goes out to level 2. Then they look further back in that voter's records to match the signature with other evidence, prior ballots, other documents that they may have on file, MVD records, whatever. What was happening, according to Jacqueline, is level 2 would get kicked back down to level 1, and it would be the same names. And they'd say, I already accepted this. I already rejected this. And so what we heard from Valenzuela is when it got up to level 2, it actually took longer because they were looking further back in the file. So the low number and the high level would even itself out. So if you're saying like something very fast happened at level 1, but then the level 1 would be accepted. Yeah, I see what you're saying, that there are different times to different levels, but I don't know how it would break down. But anyways, good comment, Alex, and I appreciate that you being here. Another one. Oh, I think it's a continuation. So 1/2 is going to knock the average down, but not by as much as this guy is leading on. It'll be 6 seconds, not always 2. Also, long-time watcher, first-time chatter. Amazing, Alex, and thank you for the great comment. Yeah, it's a good analysis. So I'm not exactly... I think what you're saying is you're averaging them all up, and it's hard to... This is... We're asking ourselves, what are we measuring? Kari Lake's team is saying all of these entries happened so quickly for all of these ballots, they just couldn't have done it. And they're just saying, no, you're just measuring the wrong thing. You're also measuring checked work when you shouldn't have measured checked work. But I see what you're saying. You're taking this almost as a voter unit analysis. So it would be another good way to analyze it. Who was rejected? And of those rejected or accepted, what was the total processing time for those specifically, right? We got to separate the buckets out. Not all of the signatures being counted as an average of everything, only the ones that were being accepted. How long did it take to process those accepted ballots that actually went up to level 2? Because if it's processed, it doesn't go to level 2. And of those accepted in that bucket, how long does that process take? What is the average of that? Because that would tell you, are they actually really doing level 2 analysis, or how much time is being invested into that? Then you could compare those with the others. Yeah, good comments from Alex. I appreciate that. No, this one came in from Donna. Hey, Donna, thank you. Donna Newlands in the house. Thank you, Donna. Says, thanks for hanging in for us. Anxious to hear your take on the day. Well, hopefully we got it. We did make it through. You know, some of these things can be very tedious, especially when you're hearing them just make the sausage for an hour and a half. Like, okay, we know, we got it, you know, but we do have to slog through it just to see what their arguments are. And it'll be well worth it because we'll hear it back in closing arguments. And Donna, I appreciate you being here. Thanks for being a member. Thanks for joining us and supporting us today on the long haul. We had another one come in from the most banned queen over on Rumble. Oh, that was from Donna. We got 2 from Donna? Oh, I think we just got 2 clips. Thank you for those. The most banned queen says, OMG, I don't understand. Why Lakeside isn't hammering on Steve the Pecker? They obviously know that wasn't going to be the mic drop that you think it is. And there are the issue they don't want exposed. Yeah, I mean, we didn't even see him on the witness list. And I wasn't exactly sure why that is. Gaming Bud says, thanks. What's your opinion on the judge? Is he being fair? Given Barr at no verification overall, I'm leaning no, although he seems to be fair during the proceedings. Yeah, so there are 2 great questions there. And the standard is very, very high. And personally, I don't think that's a fair standard. I mean, really, it doesn't make any sense to me, just logistically. Like as a matter of policy, right? As a matter of law, like in terms of what do we want the outcome to be of an election or an election challenge? We want to be able to challenge the verification process and not not just give everybody a pass for just doing the thing. That's good enough. We want quality controls. We want assurance that things have been done appropriately. The judge has set a different standard, and he's blaming Lake for that. He's saying that she made that complaint and she narrowed it into that argument. I think that's very overly narrow. I would agree that I think Kari Lake's team also responded to this after the judge issued the order. Her team responded and said, Your Honor, that's not what we meant at all. That's ridiculous, right? It's totally out of alignment with the arguments we've been making this entire time. And so the judge, I think, is circumscribing the scope of this so that there is a clear opportunity to exercise a decision on it. And I'm sure he feels he's justified, and he's done the case law research and all of that, and it is in alignment with Arizona law. But I think, so on that one, on the first part of this, I think that the standard in this trial is way too narrow and not appropriate in terms of public policy or an outcome that we want as Arizonans. But I think he's got plausible justification for doing it the way that he has. So I don't think he's being malicious or unfair in that way. But I also think that in these proceedings, he's been extremely gracious and extremely, like for example, what if I'm done with this witness, Your Honor? What if that was Judge Kaplan, who we spent a lot of time with here over the last Trump trial days? What if somebody rested in his court? What if Trump's lawyer, Joe Tacopina, rested? Do you think Judge Kaplan would say, okay, I'll let you go again? I don't think so. Not even for a minute. And so this judge, I think, has been good in that manner. We have this one came in from KX. KX said, Rob, my law school was listening to the judge teach Lake's team the basics. After 44 years in fire, no need to burn out what little patience I have left. Thanks for your dedication. My law school was listening to the judge teach Lake's team the basics. Yeah, there were some things there today, and I don't like to dunk too hard on lawyers, and especially friendly lawyers, except prosecutors. They can take it. But thank you, KX. I'm sure that's interesting in your law school. Don't Be Hatin's here says, Rob, what's your secret to keeping such a positive spirit all the time, even through all your tough tribulations? Whew, that's a good question. That's kind of a heavy question and a heavy answer. I think that we're given a short time on this planet, and we've got an obligation to play all in. And I think that we're on the right side of history. I think that we're fighting for the things that are in alignment with humanity. I think free speech and individual sovereignty is empowering. I think that when you are fighting on behalf of those things that have shown longevity throughout time, these are the same things, fighting for freedom, fighting for free speech, fighting for personal autonomy and free rights. These are the same battles that humanity has been battling since the beginning of time. And I feel very blessed to have been, fortunate enough to learn from all of my tribulations. And, there's been some down times in my life, no doubt about it. But I just feel I've been able to extract the good from those things because they become tools that are useful in the mission, which is this great battle that we're on. And when you sort of get in that zone, it becomes supportive. You guys support me. We come here. I have a relationship with my higher power. I have a men's group. I spend a lot of time exercising and focusing on keeping my body, healthy and well. And I come here and we hang out together. We get to go through these things together. So there are times when I don't feel positive, for sure. But I think we're on the right side of history. I think that things are positive. I think that the world is positive. I think that we look around and there's a lot of bad stuff happening. But when the federal government is not America. It's not us. Governor Hobbs is not Arizona and the Arizona people. And I think that a lot of these efforts by these individuals are going to prove to be failures, just with time. I think that their failure is inevitable, honestly. So I think we can have fun here and we can kind of dunk on them and lampoon them because we're on the right side of the conversation. We're on the right side of history, and it's fun. And honestly, I think you guys really contribute a great deal to helping to keep me positive. I appreciate all of the good comments and all of the good questions. And sure, that's not the best answer right now because I really can't think much, but it's because we have to be positive. We have to be positive. How else can you live? What's the alternative? If you wake up every day saying today is going to be a great day, it's much more likely to be a great day. How do I know that? It's because when I wake up and I say today's going to suck, today's going to be terrible, I've got all this crap to do. When I think that way, guess what happens? The day is crappy. The day is terrible. So we have to jumpstart our positive, and we have to get ourselves up to what we talk about being charge neutral. We all sort of wake up in the morning at a certain level, and some of us wake up below the level of feeling good. Let's say this is good, this is bad. Are we charge neutral right here? Some of us wake up beneath that charge. I regularly do. I'm not generally, I struggle with depression and I struggle with all sorts of anxieties and everything, just like everybody does. But I try to work myself hard to get up to charge neutral so that I can be a higher performer person. And so oftentimes that's walking, that's breathing. I talk about 4-7-8. I talk about exercise. I talk about meditation. I have a men's group that I do every week. So it's not just automatic. I mean, it's like you got to create these automatic sprinkler systems in your life that will help keep you nurtured and fortified. Because look, all around us, this world, there is a lot of doom out there. And if we get plugged into that, we can be overcome and succumb into that lifestyle. And so we can't do it, because if we become negative, we lose our energy, we lose our momentum, we lose our motivation to do positive things in this world. So we've got to get ourselves up to charge neutral and beyond that. And so if you've got to do certain things in the morning to get you there and maintain that, do it. In fact, here's one quick tip that I'll share with you that I do every day, every morning. I have this little thing pops up on my calendar every day. It says today is going to be a great day on my calendar. All right. Get yourself into charge neutral. Today is going to be a great day, with smiley faces, right? As corny as that sounds, right? It might feel corny, it might feel weird or whatever, but you've got to get your mental state into a positive frame of mind. And there's all sorts of literature on this, right? Think and Grow Rich by Napoleon Hill. You can listen to The Secret by Earl Nightingale. These are very old books. And The Secret by Earl Nightingale is on YouTube. Listen to that. It's from the 1920s. How you think, what you believe, and what you can see in your mind, what you can conceive and believe, you can achieve. You just got to set your mind to it. So we've got a responsibility to stay positive. And I have a lot of people that help me with it, man. I am not on, I don't wake up every morning like, yay. I have a lot of systems and amazing people, including you, who keep the train on the tracks here. And so I'm very grateful to that and to you. So thank you. All right. Great question from Don't Be Hatin'. Let's see what else we've got. This one came in from Darla Shannon. Says, so if the process was lick the ballot and throw it in the box, we'll call that signature verification. Yeah, that's basically right. Basically right. That would fly with this judge. Basically, I mean, that's the standard. Like, if it's good enough, no quality control, if they have just done the thing, that's sufficient. From Darla Shannon. We'll see, right? Now, that's the standard that I thought that the judge articulated for us, but whether it is how the judge rules is yet to be seen. And we'll see what the closing arguments look like as well. This one came in from Rocky Water over on Locals. Thank you, Rocky Water. Says, I missed a bunch. Did anyone testify as to what the average level 1 inspection time was, or other reasonable inspectors? No, they did not. In fact, even Kari Lake's experts said the standard was kind of an objective standard. It's how much time to, it's based on the signature. It's not based on the person. How much time per signature is how much time it takes to reasonably ascertain it matches and blah, blah, blah. The government official who said he cured 1,500 ballots, what were his times based on the anonymous data? Good question. Well, he did say during the direct exam, you're talking about Ray Valenzuela, that he did oftentimes go very quickly, like less than 1 second. I think he did testify that. What were his times? Or are they not allowed to enter that into evidence? Yeah, I'm not sure. I don't think they questioned that, to be honest. It's a good question. I would like to know the answer to that. Yeah. And Gen X Boomer says, how long did it take Valenzuela, a super expert, to do his 1,600? Good question. A very similar question, right? From Rocky Water. If the average is slower, then the whole thing is a scam, but also totally legit YouTube overlords. Thank you for the thank you for the safety valve on that comment. Yeah, YouTube. Yeah. I think we're okay on the YouTube rules until they say you can't talk about state elections. It's really presidential elections. I think we're still good here. But yeah, it's a great question. And I don't know how long it took at all. Maybe they should have asked that. But thank you very much for that one also. That came from Gen X Boomer. Rocky Water says, if they were rechecking the ballots that were rejected by level 2 due to high volume, then they'd be rejecting 100% rejects again. No? Yes. Then they'd be rejecting 100% rejects again. Yes, or approving them, right? That's the problem, Rocky. What if they sent, so L1 says rejected, goes up to L2. He sends, so L1, level 1 person A sends it up to L2. L2 says, I don't want to do this work. I'm going to send it back down to L1 person B, a different L1er, to see if he'll pass those through. Just try to squeeze them in. And maybe you do it again. If it's already been rejected, L2 needs to look into it. Not send it back to say, we want it approved. Stephen Mosher is in the house, says level 1 accepts or excludes, yes, and level 2 works with the excludes to accept or reject. Exactly right. Yeah, and if I misspoke in some way, shape, or form, that's probably a correction to that, but that's right. There's a high volume that comes through at the first level. Anything that's problematic gets elevated, escalated to level 2. Let me talk to your manager. Okay, level 2, ballot talks to the manager. They say, you go back down to level 1, we'll process you again, or we'll reject you, or we'll verify you and accept you then and count the vote. So good comment from SR. Stephen Mosher's here. Looks like, is this a piano? What is that? Oh, it's a fist. Oh, it's a fist bump. Shout out to my friend, Stephen Mosher. Boom. Appreciate you, brother. Thank you for the tip here today. Another one came in from John. Hey, dude, get some rest. We'll get there, John. We've been almost going 9 hours right now. Woo! It's been a long day, but it's been a good one. A lot of fun. And we've got E. Ting Shea says, many thanks for educating us. Well, thank you, E. Ting Shea. I appreciate you for being here, and thank you for sending in the very, very nice locals tip. Absolutely amazing. And yeah, so I wanted to go back to that point from Don't Be Hatin' about staying positive. And I'll tell you this, another great tip for me has been to really try to be of service to something or somebody in some way. And when we talk about it in my men's group, we talk about being fortified in this middle position where you'll have somebody who you can look to for guidance, somebody who is like a sponsor who will help guide you when you need help or support. It doesn't have to be a real intimate relationship or anything, just somebody, okay, I can chat with or talk to. And then you also have a sponsee. Okay, so you're in this middle position. You've got somebody you can look to and somebody that you can be service to, somebody who can look to you. And that helps keep you fortified and keeps you on your straight and narrow. And if you find somebody who can help, answer your questions and be almost a mentor to you or help sponsor you in a way, or a group, another organization, right? I have many different groups that I'm a part of. And you can also be of service to other people and help them along, or find something to serve, a community to serve, something to build, something that you can be proud of, and you can serve that without really wanting anything from that. Then that helps, I think, for me, it helps me feel positive helps me feel less alone. It helps me feel like there's a community around me. And it doesn't have to be individuals, like not one to one to one, but these are structures that you build, communities you serve, things you're trying to do to, you know, develop the values that you want to do. I think there was a great quote from, you know, there's all these different quotes about, if you want self-esteem, you've got to do esteemable things. You do a bunch of esteemable things, then you're going to develop self-esteem. If you want confidence, you got to go do some things that are going to push the confidence. And so same thing with positivity. You know, it's a muscle, it's an exercise. And believe me, there's many, many days when I struggle with it, but I think about you guys. I think about the work that we're doing here. I think about the service that I can help deliver in our conversations together. And it re-energizes me, and it reminds me, hey, we've got work to do here. We've got responsibilities to do. And so I've got to be a bigger person than that. And if I'm upset about the FBI or something else, or something happened personally, or whatever's going on in the world, it's time to change the dirty diaper, throw it in the garbage, and get back to work. That's how I think about it regularly. And our minds are very malleable. We can have these conversations with ourselves, speak nicely to ourselves, and get ourselves back on track. Because we've got a long road, my friends. We've got a long road ahead. We're just getting started. And as we persist, it's going to be very important. We take care of our bodies. We take care of our souls. We take care of our minds and those around us. And that's what we're doing here. And it's that type of stuff that keeps me positive when I get back mission focused. What's the mission? What are we doing here? And hopefully some of that helps. But great questions today. And thanks for letting me riff on some of that, because that stuff is important. I think a lot about it. It's not a natural thing for me. If it looks natural, it's not. There's a lot that goes into it. And I think that that's the case for a lot of people, right? It's something that we've got to, or me personally, some people just, I think, wake up and they're just happy and thrilled. Maybe not everybody, but there are others of us out there that it takes some work. It takes some work to get up to charge neutral. And so just keep working on it. And don't put, you know, one thing that was useful for me too, to make a long point longer, is to take some of the pressure off. You know, you don't have to figure it all out in a week. You don't have to figure everything. You don't have to figure your life out in 90 days. I've worked with a lot of younger guys who are in bad positions, and they think they have to figure out the whole next 40 years in 6 months. And that is a ton of pressure on yourself, man. And I used to do that too. Big reason I was drinking all the time. I was putting a lot of pressure on myself. But then you slow down, give yourself some grace, give yourself some room to grow, find a community, grow slowly, because this is a long-term game that we're in. And I'm grateful for you. I'm really, really grateful for you, because you guys help keep me on the track and keep this train moving. So those, my friends, were all of the amazing comments over from our friends at watchingthewatchers.locals.com, from Rumble, from YouTube, from all across the fruited plain. And we are so grateful for all of you to be here. And let's see, did we have anybody in the, are we still streaming on Twitter? We are. We've got one viewer here. It's me. Hey, sweet. All right, who else do we have? Let's see who we've got here. Danny McWilliams. We got Shiloh's in the house. We've got Omnipotent. We have Danny McWilliams says, well, we're not talking about mutual combat here today. Shiloh says, excellent coverage. Thank you, Shiloh. We've got Omnipotent asking if Warp Speed Steve is going to testify. Hilarious. No one wants to hear your bogus commentary. Well, then go watch it on your own. The feed is live on the court website. So go watch it live. You don't have to watch it here. Prita says, hopefully it's not already on Twitter. Yeah, that was a good comment. And Nolan appreciates the insight. Marianne Connolly is also there. What's up, Marianne? Good to see you. Nolan says, thanks for your coverage. Appreciate you there. Says, will the debacle with the expert witness allow for a reasonable, usable appeal by Katie Hobbs? I pray no, but I fear yes. Thanks again, Rob. You're good at what you're doing. Thank you, Nolan. I do appreciate that. It would, yeah. I mean, if Kari Lake loses this, if Katie Hobbs loses this, they will be appealing out the wazoo for all of those things. Marie says, wait, what? I'm not a lawyer, but why did he not ask the expert witness more? Good question. Yeah. Mistake. A little bit of a mistake. And hey, Marie likes the commentary, so at least somebody does. That's good. Dr. Steele says, found your stream on YouTube. Figured I'd give you a follow. Agree with what you're saying. that they wasted a lot of time today thus far. Crazy yesterday that signatures from the previous election were completely off. The lawyer for the county crying about it being live streamed, his moaning is hilarious. Bob says, not sure what the Lake lawyers are doing. Fleesum says, I went into panic mode when the alarm went off today. Thought the house was on fire. We got G.A. Bourne says it was a painful trial. And Ashley's in the house. It is good to see everybody. Don't Cry PR guy is also over there. We got some good. Hey, we had 19 at one point. 19 at one point on Twitter. Whew. Out of control. Almost broke the whole platform, I think. Yeah. And we had one final one before we wrap it up on the day, my friends. We are going to go over to Locals for a very brief after party to say hello to everybody. But Rocky Waters says, my meaning was and is, and maybe I'm misunderstanding, the following. If level 1 rejects, then level 2 inspects the rejects, correct? Then the actual rate of rejection would, by definition, logic, and math, would be less. Yes, it would, right? Because level 2 is going to try to cure that. They're going to try to fix it. They're going to say, why did level 1 reject it? We're going to see if we can save it and put it back in the system. So yes, it is actually to avoid a rejection. So when it goes that route, there should be less. Also, where is the control data? I think the judge wasn't letting in anything related to some pass-fail decision-making. But I was expecting some comparisons, not just data out of 3 out of 25 plus expectors. Yeah, I mean, that's the hard thing here is we don't have a baseline. You know, think about like DUI law. You've got 0.08 is the legal limit in most states, if not all states. I think some states are trying to go lower, like 0.04, maybe Utah. But we don't have a baseline. We have just however long it takes per signature is basically the standard. However long it takes a person to do the thing is the standard. So we can't compare it really. I don't think we really have control data. At least with this signature verification issue, as the judge clarified it, because the other complaints were booted out of court. And Rocky says, would be less if they returned any quantity of ballots back to level 1. That is, the data is a max. So if they dropped it back down to level 1, yeah, it's complicated stuff. Now we're getting into math, and you know who you're talking to here, Rocky Water. Would be less if they return any quantity of ballots back to level 1. That is, the data is a max. Yeah, so we're trying to capture and just keep track of individual ballots, and we'll see what they do with closing arguments tomorrow. But that, my friends, was it for us on the day. Whew, long one. We just crossed 9 hours, baby. We did it. If you've been here since the beginning, you made it. Well done. 9 full hours together today. That's a long one. And we're not done yet, baby. We're going to come back tomorrow and do it all again. And I would love it if you joined us and continue to follow us at watchingthewatchers.locals.com. And if you joined us on YouTube, don't forget to grab your Telegram link and join the Telegram as well. We very much appreciate it. Also, probably a good time if you've been here for 9 hours to get your field of greens and get fortified with real organic superfood and save with 15% off with code Robert at checkout. And remember, the vegetables want to be eaten. Big thank yous. Oh, we got spotlightlawyer.com/mindmap if you want the mind map. Big thank yous to our mods who have done an amazing job. Thank you guys for clipping and helping to keep this show on the track. Very, very much appreciate it. Really makes the thing go nicely with all of the different platforms. You guys are awesome. Thank you to Vienticus Prime, K Bean, Just Cause in the house, Playin' Hooky, Ronnie Cole, our friend Zulu, Geomancy Games. We've got Zach Nichols. John Allen is in the house. We got Janek 909, along with Dog Digger and Donut Mind Me. Shout out to our meme smith, Sleepy Dog Lee, and Geegum Geegum, and everybody else who keeps the train on the tracks. But that, my friends, is it for us on the day. We are going to leave it there. We're going to come back. Judge said 9 a.m. tomorrow, so we'll be here. I hope that you join us. Don't forget to subscribe and do the things if you haven't already. But until then, everybody, Locals and Telegram, stick around. We're going to hang out for a few minutes. But everybody else, I hope you have a beautiful, beautiful, very restful sleep with the sweetest of dreams that are possible. And we'll see you right back here in the morning so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. I'll see you right back here tomorrow. Bye-bye.